Fully demolished? Huh? What prayer you have sought? Illal Bharati, you have to file a suit for damages. Huh? Sir, Bagila, seek instruction, madam. Taken down. All right. Now you file a suit. It requires a trial, Huh? All right. If Mr. Counsel, if you are owner of this petition property, then you have to file a suit. How to ascertain damages, Mister? How to ascertain damages? Hag ಮಾಡಬೇಕು. Whether this court is equipped under Agalri. Now, see, state has taken a stand that this demolition is insofar as unauthorized occupancy by you. You are asserting that your property is demolished. From where to gather it? You have to lead evidence. You have to demonstrate that your private property is demolished under the garb of removing encroachers. It's a matter of trial. It can't be done under jurisdiction. ₹100 ಕೊಟ್ಟಲ್ರಿ ಕೋರ್ಟ್ ಫೀ ಕಟ್ಟಬೇಕು. 1,21,00,000ಕ್ಕೆ ಕೋರ್ಟ್ ಫೀ ಕಟ್ಟಬೇಕು. ಬರ್ಕೊಳ್ರಿ. Petitioner in the caption petition ಇದೇನಿದು order, annexure order. Oh, the caption petition. Petitioner are assailing the order of the Deputy Commissioner who is declined to entertain appeal or application of representation. Declining to entertain a revision, seeking a damages to the tune of 1,21,57,090 rupees. Assailing the order of the Deputy Commissioner, petitioner is consequentially seeking a mandamus to direct the respondents to pay compensation of rupees 1,21,57,090 rupees. Next, while petitioner is asserting that his private property owned by petitioner is sought to be demolished by respondent state by taking precipitative action, learned AGA on instruction submits that the actions were initiated to remove the encroachers. Having heard the counsels on record, this court is of the view that the dispute is purely in civil nature, whether petitioner's private property was subjected to demolition under the garb of removing encroachers is a disputed question of fact, and the same needs adjudication at the hands of a civil court. Whether petitioner is entitled for damages as claimed is also matter to be adjudicated before civil court, as petitioner has to lead oral and documentary evidence to establish his claim. All this disputed question of facts cannot be adjudicated by a writ court. Therefore, this court is of the view that petitioner needs to be relegated to the civil court to seek redressal of his grievances. With these observations, the petition stand disposed of, reserving liberty to petitioner to approach civil court. Next. Huh? Yes, madam. Copy is not served. Served. ಇಲ್ಲೇ ಕೊಡಿ, ಓಪನ್ ಕೋರ್ಟಲ್ಲೇ ಕೊಟ್ಬಿಡಿ. ಅರ್ಜೆನ್ಸಿ ಇದೆ ಸರ್. ಅಲ್ಲಲ್ಲ, ವೆನ್ ಯು ವಾಂಟ್ ನೆಕ್ಸ್ಟ್ ವೀಕ್. There's already direction. Next stated ಮಾಡೋಣ ಬರ್ಕೊಡಿ. Learned AG is directed to accept notice to respondents. ಅದು judgment ಇದೆ ನೋಡಿ ತಗೊಳ್ಳೋದು. ಯಾವ when you submitted application actually seeking grant and that is all regular rate. Really this matter and preliminary on so and so date. Next. Or badlela sir, Shiva sir. 2:30. Shall I take it at 2:30? Aboda? All right, password 2:30. Yes, sir. What is the date of grant, madam? Yes, Manjunath. All right, Leonard SCGP accept notice to respondents 1 to 3 at his request. Release this matter in preliminary on. Same. All right, next. Order of how are you related with the private respondents? What's your relation with the private respondents? Huh? Who are brothers? Both respondent father and petitioner's father are brothers. They are full brothers. And what about other respondents? They are also brothers. Now what the suit is pending? Who has filed the suit? Ah. Where is the judgment? There is a base suit for injunction. Base suit for injunction. Why it is dismissed on the ground that there is no partition? From whom? Yaru. After the division, under the we executed it, and after evidence, federal court instruction is full. Yes, full. The answers the market with the net. Where are those judgments, counsel? Where are those judgments? Where are those judgments? Why you not place it on record? No. Place it on record. What is this, mister? Place madri. Whether there is a finding that it is still an ancestral property and injunction cannot be granted. Between whom? Between Ramaya and who is Appaya? Oral partition. Mutation is effected. And under the partition, whether your father was exclusively allotted these two lands. Or that in terms of partition, that oral partition, extent was reflected in RTC. Now what they have done now? What they have done? Based on gift deed. Based on gift deed. Entire. What is the law? What is the law on that point? What is the law on that point? Registered gift deed in respect of an ancestral property. Is it wide or wide ab initio? Is it wideable or wide ab initio? Barcodry. Now what Assistant Commissioner has done? Holding that there is already partition and that mutation is to be restored. What reasons he has assigned? Yagror mele dismiss ಮಾಡ್ತಾರೆ. Now who has executed sale deed? 1975 sale deed ಯಾರ್ದಿದು? That is referred in Deputy Commissioner's order at page 23. Now this mutation is in respect of which survey number? Now the trial court has held that this property cannot be considered as joint family property. You take notice, sir. You are not placing on record the judgments. Consciously, you are not placed those two judgments on record. Place it on record. We'll see. There is a finding, adverse finding against you in a suit. Learned DJ is directed to accept notice to respondent 1 to 3. All right. Notice to private respondents is deferred. petitioner shall place on record, counsel for petitioner shall place on record the judgments rendered by the civil court. Really, this matter until hearing on so and so date. Yes, next. Password. Next. Yes, sir. Ariga, sir. ಏನಿದು ಟೆನೆಂಟಾ? Seven A. Order for grant of land, for connection B at page 80. Granting the land, two items of the land to the payment. That was challenged in court. Karnataka appellate tribunal. But appellate tribunal not being accepted. Annexure C begins at page 20. Now kindly come to the. It's a cryptic order. According to it's a cryptic order. Small pages come, no. But kindly see page 26. Page 26. Oh, yeah, ಮುಂದಿದೆ. Appeal is allowed. Appeal is allowed. Appeal order passed by the second respondent dated 12/5/2006 is set aside. And this is directed to come by regulation. So it was order was set aside. After the order was set aside, again the prescribed of the writing that the additional deputy commissioner takes up the matter. The petitioner he appeared before the. You're the landlord. He appeared before the prescribed of writing. That is an additional the commissioner. Where is that? Where? Page 27. Oh. And he says that I have all the authority. I will pass an order. And he grants this land again. So it was set aside at page 29. Yes, madam. Who is it? It was brought to the notice of. He says, no, I can pass any order. What he can sit over a Karnataka appellate tribunal order. And these are proceedings under 77A. Any order by the authority is appealable before the appellate tribunal. See for certified copy. This order was passed on 16/11/22. The particular officer did not release the certified copy. I made the several applications. Then I complained to the Lokaita. My complaint is. Audit, Barcode. Heard the counsel for petitioner. Private respondent. Number 2, file form number 7A seeking grant. Seeking grant of the land on the premises that she's a tenant of the petition land and that she failed to file form number 7 after coming into force of Land Reforms Act. That was allowed. Land tribunal allowed. The concerned authority allowed the form number 7A and thereby granted the petition land. This order was challenged by petitioner before the Karnataka Appellate Tribunal in appeal number 961 of 2008. Appellate Tribunal has set aside this order. Second respondent, having suffered the order, had not chosen to challenge the order of the Appellate Tribunal. However, strangely, she approaches Yaro. Approaches the first respondent. He approaches the first respondent seeking grant of the land in question. Though objections were raised by the petitioner herein by citing the judgment rendered by Karnataka Appellate Tribunal. The first respondent has proceeded to allow the form number 7A and consequently the land is granted. Prima facie, the order wide impugned impugned order wide annex D is one without jurisdiction. This court is not in a position under what authority this order is passed, and therefore matter requires consideration. Accordingly, stayed until further orders. Landed agent is directed to accept notice to R1, issue emergent notice to R2. Registry to secure records. Yes, Raja. Mandamus. Fabricated. Sick instruction. Landed SCGP. Notice ಆಗಿದೆಯಾ? Landed SCGP 6 short accommodation to file a statement of objection. On instruction, he submits that the grant on which petitioner is placing reliance is a fraudulent, is a fabricated document. To substantiate the said allegations, he requires time to file statement. Prayer is allowed. 4 weeks time is granted to file statement of objection. Next. Yes, Prakash. SV Prakash.
Appear for petitioner.
Yes, sir.
My lord, I have sought for the writ of mandamus. The problem is this, my lord. There was a partition suit filed by my father, and that was ended in a settlement by filing, my lord, compromise petition in the final decree proceedings. My lord, the second respondent, my lord, the third respondent, he conducted a podi, my lord, under a scheme called Mukta Podi Grama, without notice to us and contrary to the decree. And that was challenged, my lord, before the second respondent. My lord, he has set aside that podi, holding, yes, and there is a direction to redo it after notice to all the persons interested.
In terms of compromise decree.
Yes, my lord. And in spite of our representations, my lord, he did not do that.
All right, where is that order passed by the second respondent?
My lord, the second respondent, my lord, annexure A, my lord. Page 14. A, page 14, 1-4.
Yes, madam.
Order portion your lordship would get at page 18. And my representation, my lord, are at page 31.
Page 30. Yes, madam.
Now we can measure the property. Taking possession is not there. Already construction because of overlapping.
Then you file a report to that effect. In the caption petition, petitioner is seeking a writ in the nature of mandamus to direct third respondent to implement the order of second respondent and conduct fresh podi and durasti in respect of survey number 74/4 of Sirivanti village, Talguppa, Hubli. Next, facts leading to the case are as under. Subject matter of the petition is an agricultural land bearing survey number 74/4, totally measuring 13 acres, 34 guntas, including 38 guntas of Kharab land. Petitioner asserts that that his father was the party to the partition suit, which was ended in compromise. Petitioner further contends that contrary to the allotment indicated in the compromise decree passed in OS 298 of 2010, third respondent, without notifying the interested parties, conducted 4D and durasti proceedings. Feeling aggrieved by the said 4D, it appears petitioner assailed the said order before second respondent. Second respondent has set aside the survey undertaken by third respondent, which is evidenced at annexure B, A, and the directive issued to third respondent to redo, strictly aligning with the allotment made under the compromise decree passed in OS 298 of 2010. This order is dated 16/11/2021.
Yeah, 21.
21. Next, perusal of the records. This court is more than satisfied that there is a clear laxness on the part of third respondent in not conducting a fresh OD and Durasti, strictly aligning with the specific allotment made under the compromise decree passed in OS 298 of 2010. Petitioner, who is tracing his right through his father, who was allotted specific share in surrender number 74/4, has a legal right to seek proper directions at the hands of this court, as there is inaction on the part of third respondent. Therefore, this is a fit case where a mandamus lies. For the foregoing reason, this court passes the following order. Writ petition is allowed. Third respondent is hereby directed to forthwith comply the directions issued by second respondent by conducting a fresh OD and Durasti proceedings in respect of surrender number 74/4. Village Barabari. Next, this exercise shall be accomplished within a period of 3 months from the date of receipt of order.
God bless.
Yes. You are challenging the order first respondent. You are challenging 3/3/2022. What is that order, madam?
Passed an order for planting an extent of 3 acres of land by order dated 16/12/2017 to be done. Since then, I am in possession of this land and I have also granted me the issued me the cargo chain. Subsequently, the Tahsildar, he filed an application before the assistant commissioner stating that this is a forest land and it cannot be granted. And then the assistant commissioner, what he does is that he takes this as an appeal and he decides that since this is a forest land, it cannot be granted.
Whether you were heard?
I was heard, my lord, but the deputy commissioner has not heard. We filed an appeal. After we filed an appeal, the deputy commissioner says that since they have not filed any arguments, so I'm disposing the matter. He disposes of the matter.
To go back, it's not on merits. Order by deputy commissioner is not on merits. Where is the order passed by the deputy commissioner? Audit, madam, seek instruction. If it's a forest land,
acres is a forest land now. It's 41 acres is a done or moved land.
moved land.
That's not right.
Correct.
While planting the annexure here also has been clearly mentioned. And planting the page number 12. ಹೊಳೆದೂರು ಹೋಬಳಿ ಸೋವಿನಕೊಪ್ಪ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 2ರಲ್ಲಿ ಬಕಾಸುಕು ಸಾಗುವಳಿ ಜಮೀನಿನ ಸಂಕ್ರಮೀಕರಣ ಕೋರಿ ನಮೂನೆ 53 ಅರ್ಜಿ ಸ್ವೀಕೃತವಾಗಿರುತ್ತದೆ. ಹೊಳೆದೂರು ಹೋಬಳಿ ಸೋವಿನಕೊಪ್ಪ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 8ರಲ್ಲಿ
all that you are in possession, you are still in possession. Petitioner is aggrieved by the order of second respondent assistant commissioner who has proceeded to cancel the grant on the premises that granted land is a forest land. Counsel for petitioner would point out that deputy commissioner has not properly appreciated the records and without examining the issue as to whether this petition land is a forest land, has summarily dismissed the revision. These two orders are under challenge. Petitioner's counsel submits that the the forest land, that though in the said survey number, there is a forest land measuring 100 acres, 41 acres. There is a additional 41 acres in the very same survey number, which is notified as January of land. Therefore, counsel for petitioner would vehemently argue and contend that what was granted was in this 41 acres and not the forest land as alleged by the authorities. Matter requires deeper examination since petitioner's possession is preceded by a grant after due inquiry. This court deems it fit to grant some protection pending consideration of the caption petition. Pending proceeding, the execution and operation of both the orders are stayed. Learned AG shall seek instruction and file statement of objection. After completion of pleadings, registry shall list this matter in big. Yes. Liberty is reserved to state to file vacating application. Next. Yes.
Purchase the lands in Martin Village in 2019. The private respondent to 5 and 6 are also planning to buy for land. Basically, the land questions are belongs to one seat of law, who has been granted and nothing else public land.
What a challenge now.
Now, possible the deputy commissioner. The deputy commissioner as well as the assistant commissioner are ready to get the data in favor of me. And it is ordered to restore the revenue entries in favor of the private respondent number 5 because he holds the earlier say. According to the respondent number 5, he filed a suit and he obtained an exported degree against my vendor, and based on that degree, you obtained a report saying in the year 2018. That was not within the knowledge of my vendors. My vendors are already challenged it, and the miscellaneous is pending.
Then outcome subject to.
One more. Subsequently, I obtained the register sale in the 2009.
Through your vendor who has suffered ex parte decree.
My vendors are suffered with the ex parte.
Just a minute. When did you purchase it? After he challenged that ex parte decree?
For challenging the ex parte decree. In the 19, I have purchased.
What is the date?
Some to the knowledge of my vendor.
What was the suit for?
Suit for specific purpose.
Against your vendor.
My vendor's father, who was died in 1985 itself.
Whatever
but
it is.
He made me as a party.
No.
No.
You are a subsequent purchaser. You will succeed only if that decree goes.
Meanwhile, the respondent number 6 is totally stated in the problem. Now, he filed one more RRT before the Tahsildar. He sought relief before the Tahsildar that he wants to get transferred the revenue records in his favor without any basis.
Now the entries are in whose favor?
Entries are in favor of respondent number 5 based on the earlier saying.
Correct.
Now the respondent number 6 are also filed RRT before the Tahsildar. In the meanwhile, what happened is that earlier my vendors executed a conditional sale deed in favor of one Parvatama, and the pledged the land in question with her. Subsequently, the said Parvatama has reconveyed this property to my vendor, and after reconveyance deed, the alleged legal aids of Parvatama has filed a suit in the 2021.
Fifth respondent has not challenged this mutation.
So he has not challenged.
It's affecting him more than you.
He has not, but fifth and sixth respondents are saying together. They are legal aids of one Chaudappa. Earlier, he obtained the revenue records in his favor, and we challenged it. And
I think there might be some interim arrangement between 5 and 6.
yes, madam.
Then you have to succeed, sir. Your vendor has to.
Earlier, grandfather of fifth and sixth respondent Chaudappa obtained the revenue records in respect of finance mission. My vendors have challenged it before the state commissioner as well as the deputy commissioner. And it's a C&D are the arms passed by the AC and DC. The deputy commissioner and assistant commissioner appreciated the title of my vendor and they ordered to decide the revenue entries in favor of my vendor.
Now-
Accordingly, when
now-
the records are transferred to power of my vendors, I obtained the sale in bona fide by, based on the cycle of.
You should blame your vendor. He suppressed a filing of suit. File a suit against him for damage.
Because my vendor's father was dead in 1985. He made him as a party in 2017. He filed a suit before the complaint.
That has to be set aside now.
In the meanwhile, kindly in the annexion E, page 61.
Ah.
This is the suit filed by the legal aids of Parvata. As I said earlier, Grant of Parvata,
Yaru.
I already reconveyed the property to my vendor. But the legal aids of Parvata filed a suit. We are all we are all parties in this suit, and they sought cancellation of the sale deed of respondent number 5 as well as liquidation.
No, without challenging ex parte decree, you can't see cancellation, sir.
I am not filing this suit. This suit was filed by some third party. So ultimately, all the parties are.
Where is that ex parte decree? Ellidado?
I am not revealing the party.
Why you are not
It is the
revealing?
contention, and it is stated in the earlier.
Why you are not produced it? Based on ex parte decree, now fifth respondent name is mutated. Huh? There is the matter. Now your vendor has challenged or you have challenged?
My vendors.
He has challenged that by
Miscellaneous.
ordinance rule 30. There is
In
the
the
matter.
meantime, the suit was filed by the third party.
No, we are not concerned. We are not concerned.
Kindly, let them maintain the status quo of the revenue records. Otherwise,
Baralla.
now the R6 is trying to get.
Seek, request your vendor. No, request your vendor to seek appropriate reliefs in the pending ordinance. If that is stayed, no. If ex parte decree is stayed, everything will fall in place. No, you're simply ಯಾರ ಹೆಸರಲ್ಲಿದೆ?
Based on this sale.
ಹಾ
Status ko maintain ಮಾಡಿ.
ಅದಂಗ್ ಬರುತ್ತೆ ನಿಮ್ ರಿಟೈರ್ಮೆಂಟ್ ಆಗಲ್ಲ.
Again, R6 ಕೇಳ್ತಾ ಇದ್ದಾರೆ ನನ್ನ ಹೆಸರು ಕೊಡ್ಬೇಕು. ಅವರಿಬ್ರು
Ask your vendor to seek appropriate relief in the pending miscellaneous petition. ನಾವ್ ಕೊಡಕ್ ಬರಲ್ರಿ, ಸ್ಟೇ ಕೊಡಕ್ ಬರಲ್ಲ. ಬರಲ್ಲ. ಯಾರಿಗ who has obtained ex parte decree?
by the R5.
So based on ex parte decree, who mutated? ಯಾರು mutation effect ಮಾಡಿದ್ರು? ಅಸಿಸ್ಟೆಂಟ್ ಕಮಿಷನರ್, ತಹಶೀಲ್ದಾರ? ತಹಶೀಲ್ದಾರ್ effected. Now assistant commissioner, deputy commissioner have dismissed your appeal and revision. ಎರಡು. ಈಗ ಅದು ಇಂಡಿಪೆಂಡೆಂಟ್ RR ಆಗಿದೆ ಅಂತ ಅದನ್ನು ಚಾಲೆಂಜ್ ಮಾಡ್ಲಿಲ್ಲ ನೀವು. R5 mutation ಚಾಲೆಂಜ್ ಮಾಡಿಲ್ಲ. And confirmed by deputy commissioner. And now you said that one more mutation is effected. That is not challenged now. ಆಯ್ತು. ಬರ್ಕೊಡ್ರಿ. ಬರಲ್ರಿ. ಮೋಹನ್ ಕುಮಾರ್ ಗೊತ್ತಿದೆ, ಎಲ್ಲ ಗೊತ್ತಿದೆ ಅದು. ಎಲ್ಲ ಗೊತ್ತಿದೆ ನಿಮಗೆ. Don't waste court time. ಆಯ್ತು, argue for 5 minutes ಅಲ್ವಾ? ಬರ್ಕೊಡ್ರಿ. Petitioner is primarily aggrieved by the order of assistant commissioner, Tahsildar, fourth respondent Tahsildar, who has ordered to mutate fifth respondent's name pursuant to decree passed in OS. Disclose ಮಾಡಿದಿರದ? Pursuant to decree passed in OS 693/2014. And who is your vendor? Is he party to this proceedings? Illi, yeah.
Because they are not before the ACR.
Petitioner is tracing title through one Sitappa based on the registered sale deed dated name sale deed 26/8/2019. However, petitioner's vendor Sitappa suffered a decree for specific performance of contract in OS 693/2014 Based on decree, the fifth respondent's name is mutated by fourth respondent Tahsildar, and same is confirmed by third respondent and second respondent Deputy Commissioner. Next, in the light of these significant details, though counsel appearing for petitioner had tried to persuade this court to grant status quo, this court is of the view that no indulgence can be granted in the light of decree obtained by fifth respondent in a suit for specific performance. Next, the counsel appearing for petitioner has also brought to the notice of this court that that the decree passed in OS so and so is the ex parte decree, and his vendor has already challenged the ex parte decree by filing a petition under Order 9 Rule 13. If the ex parte decree is challenged by his vendor, the mutations effected in favor of fifth respondent based on a decree passed in a suit for specific performance will be subject to outcome of the miscellaneous proceedings. With these observations, the petition stand disposed of. Yes, Suresh. Yes, sir. Andamas.
Petitioner has given representation to respondent file. To state a name based on the compromise decree dated.
Compromise decree. Whether that compromise decree is produced. Whether decree is produced. Whether that grant order is placed on produced with the court. Let us see what documents are produced. Compromise ಆಗಿರೋದು ಇದು. ಅದನ್ನೇನು ಡಿಸ್ಕ್ಲೋಸ್ ಮಾಡಲ್ಲ. Yes, Mr. What is the suit for? ಆಯ್ತು ಕಡೆಗೆ ನೀವು ಬನ್ನಿ ನೋಡೋಣ. ಇಬ್ರು ಲಾಯರ್ ಆದ್ರೂ ಈಗ ನೀವು ಲಾಸ್ಟ್ ಈಗ. See, these compromise decrees are very deceptive. You should be, and it's suit for specific performance. What is the vendor? How vendors are tracing their title over this property? No, not RTC. What documents? Is it their ancestral property? Huh? They say it's a government land.
My legal rights are the.
Audit, where is the grant copy? No. Produce it. Grant and Sagol Institute produce and then we'll see. Audit, you take notice. Leonard SCGP accept notice to respondents. Council, petitioners council. Since Leonard SCGP is disputing petitioner's vendor's title over the land in question, petitioners shall place on record the copy of plaint and all title documents relating to the petition land listed. What? ಯಾವ ಊರಿದು? ಯಾವ ಊರು? ಬೆಂಗಳೂರು ಅನ್ರಿ, ಕನಕ್ಪುರ ಅಂದ್ರೆ ಬೇರೆ. ಕನಕ್ಪುರ ಅಂದ್ರೆ ಬೆಂಗಳೂರು ಅಲ್ರಿ ಅದು? ಆಯ್ತು, ಪ್ರೊಡ್ಯೂಸ್ ಇಟ್, ವಿಲ್ ಸಿ. Next. Yes, seal number 15. ಏನ್ ಕೊಡ್ಬೇಕೀಗ? ಗ್ರಾಂಟ್ ಆಗಿದೆ ಬೈ ದಿ ಕಮಿಟಿನ, ಬಗರುಕುಂ ಕಮಿಟಿನ ಇದು DC ಅವ್ರು ಕೊಟ್ಟಿದ್ದಾರೆ, ಗ್ರಾಂಟ್ ಮಾಡಿದ್ದಾರೆ. ಬರ್ಕೊಡ್ರಿ. Petitioner is aggrieved by the inaction of third respondent Tahsildar in not passing appropriate orders on the representation dated 23/11/2023, wherein a request is made to issue Hakkupatra based on the grant obtained by petitioner from Deputy Commissioner. Next, learned SCGP on instruction submits the petitioner's request under representation dated 23/11/2023 will be considered in accordance with law and appropriate. And Hakkupatra will be issued, provided some reasonable time is granted. Recording is assurance. This court passes following order. Writ petition is allowed. Third respondent Tahsildar shall examine the grant made by Deputy Commissioner, evidence that annexure, grant order. ಎಲ್ಲಿದೆ ಅದು? Annexure, evidence that annexure B, and accordingly issue Hakkupatra to petitioner. This exercise shall be accomplished within a period of 3 months from the date of receipt of order. Order sheet ಅಲ್ಲಿ ಬರೀ ಆಗಿದೆ ಅಂತ ನೋಡ್ರಿ, ಆಗಿದೆ ಇಲ್ಲಿ ನೋಡಿ ಇಲ್ಲ. ನೆಕ್ಸ್ಟ್ ಶಾಂತ್ ಕುಮಾರ್. ಕನ್ಸಿಡರ್ ಮಾಡಿಲ್ಲ ಯಾರು? ತಹಸೀಲ್ದಾರ? ಕಮಿಟಿ ಇಸ್ ಫಾರ್ಮ್ಡ್, ಮಾಡ್ತೀರಾ? ಬರ್ಕೊಡ್ರಿ. Caption petition is filed. Feeling aggrieved by inaction on the part of respondent number 4 and 5 in not conducting inquiry pursuant to receipt of form number 53 tendered by 57 tendered by petitioner seeking regularization of his unauthorized occupancy over agricultural land bearing survey number 20/P6 measuring 1 acre 20 guntas. ಬರ್ಕೊಡ್ರಿ, ಅದು ಕೊಡ್ರಿ, ಲ್ಯಾಂಡ್ ಬರ್ಕೊಡ್ರಿ. Learned SCGP on instruction submits that fourth respondent committee will hold an inquiry and examine whether petitioner is eligible to be recommended for regularization of his unauthorized occupancy. Recording is sufficient. This court would direct fifth respondent Tahsildar to place all requisite documents relating to survey number 20/P6 before fourth respondent land grant committee. With these observations, this court passes the following order. Writ petition is allowed. Fifth respondent shall ensure that the application along with all requisite documents are placed before third respondent, fourth respondent land grant committee. Next, the fourth respondent land committee in turn shall hold an inquiry and examine the petitioner's eligibility to seek a regularization of his unauthorized occupation. Next, this exercise shall be accomplished by respondents 4 and 5 within a period of. Okay. Correct. That do it in 4 months. Within 4 months from the date. Nodi. Within 4 months from the date of. Nodi. Within 4 months. ಇನ್ನೊಂದು ಎಂಡೋರ್ಸ್ಮೆಂಟ್ ಇಶ್ಯೂ ಮಾಡಿ ನಾವು ಈಗಾಗಲೇ ಮಾಡಿಬಿಟ್ಟಿದ್ದೀವಿ. Within 4 months. Next. Same. ಬರಬಿಟ್ರೆ ಸರ್ವೆ ನಂಬರ್ ಬೇರೆ. Yes. Next. ನಿಮ್ದು 19 ಅದು ಸೇಮ್. 19 you want instruction? ಪಾಸ್ವರ್ಡ್ ಮಾಡ್ಬೇಕಾ? ರಿಜೆಕ್ಟ್ ಆಗಿದೆ ಅಂತ ಶಾಂತ್ ಕುಮಾರ್ ವೇಟ್ ಮಾಡಿ, ಬರ್ಲಿ ಅವರು ಬಂದ್ಮೇಲೆ ತಗೊಳ್ಳೋಣ. 18 Sridhar. Yes, sir. Ah.
As per NSA. Now thereafter, all the revenue entries were deducted in the name of the petitioner till 2010. Now, trying to correct the annexure D, without issuing the notice, without cancelling the earlier grant, the mutation entry has been cancelled.
Only mutation is cancelled.
That has not been cancelled.
By whom? Mutation is
By the annexure D assistant commissioner. And without finding any finding, the 4 ways are.
Assistant Commissioner order ಏನಿದೆ ಅದು?
Annexure D, page number 22.
That is confirmed by Assistant Commissioner. They don't refer to the grant order. ಆಮೇಲೆ deletion is without notice to you. All right. Allah, next date we will dispose of Leonard SCGP. Accept notice to response 1 to 5. 1 to 5. Prima facie, this court is satisfied that though petitioner has acquired title pursuant to grant made by a competent authority, petitioner's name is deleted by third respondent Tahsildar in gross violation of principles of national justice, and this order is confirmed by second respondent, assistant commissioner, and first respondent deputy commissioner by way of cryptic orders. Matter therefore requires consideration. For the reasons stated supra, the orders are stayed pending consideration of the caption petition. Really, this matter, since matter revolves around narrow compass, race is directed to release this matter in preliminary after on the 10 days code, on the 2 weeks on the. Yes. Yes, madam. Rejected, ಚಾಲೆಂಜ್ ಮಾಡಿ ಅದು ಚಾಲೆಂಜ್ ಮಾಡಿ ಆರ್ಡರ್ ಇದೆ ಹೌದಾ ಆರ್ಡರ್ ಯು ಅಕ್ಸೆಪ್ಟ್ ನೋಟಿಸ್ ಅಂಡ್ ಯು ಪ್ಲೇಸ್ ಇಟ್ ಆನ್ ರೆಕಾರ್ಡ್ ಆನ್ ದ ನೆಕ್ಸ್ಟ್ ಡೇ ಲ್ಯಾಂಡೆಡ್ ಆಗ್ಬೋದಾ ಡೀಟೇಲ್ಸ್ ಇದೆಯಾ ಬರೇ ಯಾವಾಗ ಡೇಟ್ ಏನ್ ಕೊಟ್ರ ಬಟ್ ರಿಜೆಕ್ಟ್ ಮಾಡಿದಾರಂತಾನ I already will give you just orally submit. I'll recall if it is not done. But just a minute. I'll, madam, Shant Kumar, I'll dispose of. But within a week, you will serve a copy on him. Shant Kumar, aurge kodbeku. ಅದೀಗ ಅವರು ಸರ್ ಮಾಡ್ತಾರೆ ಅದೇ ಎಂಡೋಸ್ಮೆಂಟ್ ಸರ್ ಮಾಡಿ ಅಂತ ಹೇಳ್ತಾ ಇದೀನಿ ಅಲ್ವಾ
If it is not considered, they will make a
ಬರ್ಕೊಡ್ ಆರ್ಡರ್ ಇದು ಏನು ಫಾರ್ಮ್ ನಂಬರ್ 57 petitioner is seeking a mandamus against respondent 4 and 5 to consider his application filed in form number 57 seeking a regularization of his unauthorized occupation. Next, Leonard AG on instruction submits that petitioner's application is already rejected. Recording her submission. Caption petition stand disposed of, reserving liberty to petitioner to assail the endorsement, rejecting petitioner's application. If petitioner's application is rejected, fifth respondent Tahsildar shall ensure that the endorsement rejecting petitioner's application filed in form number 57 is communicated within 2 weeks. In the event there is no such rejection, fourth respondent landed committee shall examine petitioner's eligibility to seek regularization of his unauthorized occupation. With these observations, writ petition stand disposed of. 2 ವಾರ ಒಳಗಡೆ ನಿಮ್ಗೆ ಕೊಡ್ಬೇಕಂತ ಬರುತ್ತೆ. Yes, Dhananjay Kumar. to effect mutation in terms of compromise decree. Whether Allah adu ಏನ್ರಿ ಅದು ನಮಗೂ this has gone unresolved, I'll tell you. How we can insist for 11 sketch ರೀ? Joint names ಮಾಡಬಹುದಲ್ಲ? There is no provision to mutate jointly. ಅಂದ್ರೆ ಎಕ್ಸ್ಟೆಂಟ್ ಅನ್ನ ಅದೇ ಸರ್ವೆ ನಂಬರ್ ದಲ್ಲಿ RTC ದಲ್ಲಿ ಅವ್ರದ್ದು ಕಾಂಪ್ರಮೈಸ್ ದಲ್ಲಿ ಎಷ್ಟು ಅಲಾಟ್ ಆಗಿದೆಯಲ್ಲ ಅದನ್ನ ರಿಫ್ಲೆಕ್ಟ್ ಮಾಡಬಹುದಲ್ಲ ಎಕ್ಸ್ಟೆಂಟ್? ಎಸ್ ಮೇಡಮ್, ಲಾಸ್ಟ್ ಟೈಮ್ ಕೇಳಿದ್ದೆ ನನಗೆ. ಅದರಲ್ಲಿ ಪೋರ್ಷನ್ ಇದ್ರೆ 11 sketch ಅದು. And wait a minute, entire extent is owned by your family or there are co-owners? ಹಾಗಲ್ರಿ, ಈ ಸರ್ವೆ ನಂಬರ್ ಎಕ್ಸ್ಕ್ಲೂಸಿವ್ಲಿ ಓನ್ ಬೈ ಯರ್ ಫ್ಯಾಮಿಲಿ, ಬೇರೆ ಅಜ್ಜ ಯಾರಿಲ್ಲ, ಬೇರೆ ಓನ್. ಅಲ್ಲ, ಈಗ ಅವ್ರದ್ದು ಎಂಟೈರ್ ಸರ್ವೆ ನಂಬರ್ ಇಸ್ ಓನ್ ಬೈ ದಮ್. Let us one ನಿಮಿಷ, let us presume that it is 10 acres, 2 brothers, ಪಾರ್ಟಿಷನ್ ಪ್ರಕಾರ ಹಾಫ್ ಆಫ್ ಶೇರ್ ಬಂದಿದೆ. RTC ದಲ್ಲಿ ನೀವು ಹಾಫ್ ಆಫ್ ಶೇರ್ ಇನ್ ಟರ್ಮ್ಸ್ ಆಫ್ ಪಾರ್ಟಿಷನ್ ಅಂತ ಬರೆಯಕ್ಕೆ ತೊಂದರೆ ಇದೆ. ಅವರು ಡಿವಿಷನ್ ಹಾಕೊಂಡ್ರೆ ಮಾಡಿ, ಅದು RTC ದಲ್ಲಿ ಬೌಂಡ್ರಿ ಬೇಡ, ಜಾಯಿಂಟ್ ಹಾಫ್ ಶೇರ್ ಮಾಡಕ್ ಬರಲ್ವಾ? ಆ ಸಬ್ ಡಿವಿಷನ್ ಅವ್ರು ಮುಂದ್ ಮಾಡ್ಕೋತಾರ್ರಿ, ಇಲ್ವಾ? ಸೊ ಈಗ ಅದು ಸಬ್ ಡಿವಿಷನ್ ಆಗಿ ರಿಅಸೈನ್ ಆಗ್ಬೇಕು. You seek 40, then they can seek 40 in terms of. Mister, they say that unless in terms of sketch there has to be 40 ಅಲ್ವಾ? ರಿಅಸೈನ್ ಆಗ್ಬೇಕಲ್ರಿ, ಸಬ್ ಡಿವಿಷನ್ ಮಾಡಿ ನಿಮ್ಗೆ ಆಗಿರೋ ಅಲಾಟ್ ಆಗಿರೋದಕ್ಕೆ ಪೋರ್ಷನ್ಗೆ they have to assign a new corresponding number and then RTC has to be generated, new RTC has to be generated. ಏನ್ರಿ ರೂಪೇಶ್ ಅವರ, ರೂಪೇಶ್ ಅಂಡ್ ನಿತೇಶ್ ಗೊತ್ತಿಲ್ಲ ರೀ, ನಮ್ ಕಡೆ ಎಲ್ಲ ಅದು ಜಾಯಿಂಟ್ ಬರ್ದ್ ಬಿಡ್ತಾರೆ. ಈಗ ಕಾಂಪ್ರಮೈಸ್ ಡಿಗ್ರಿ ಆಗಿದೆ, ಪಾರ್ಟಿಷನ್ ಸೂಟ್ ಅಲ್ಲಿ ಕಾಂಪ್ರಮೈಸ್ ಡಿಗ್ರಿ ಆಗಿದೆ. Specific shares are allotted to plaintiff and defendants. Now a worthy is submitted to mutate in terms of compromise decree. Madam says that unless there is a subdivision, the 11 is sketch.
Color number 9 they can indicate entire extent. In color number 22
ಅಲ್ಲಿ extents ಅಲ್ಲ, ಅದು ಸಾಫ್ಟ್ವೇರ್ ಇಲ್ಲ. ಈಗ ಕಾಂಪ್ರಮೈಸ್ ಡಿಗ್ರಿ ರೆಕಾರ್ಡ್ ಮಾಡಕ್ಕೆ ಸಾಫ್ಟ್ವೇರ್ ಇಲ್ಲ. There is some issue with Kaveri also. If people are not assisting, there is no provision in the software to effect changes in the khata based on a compromise decree. ಮತ್ತೆ ಒಂದು ಜಾಯಿಂಟ್ ವರದಿ ಕೊಡ್ತಾ ಇದ್ದೀರಾ, ಕಾಂಪ್ರಮೈಸ್ ಡಿಗ್ರಿ ಪ್ರಕಾರ ನಮ್ದೊಂದು ಅಪ್ಸಾತ್ ಆಗಿದೆ ಅಂತ. ಏನ್ರಿ ಕರೆಕ್ಟ್, ಯು ಆರ್ ರೈಟ್. ಅಲ್ಲ, ಇದಕ್ಕೆ 11 ಸ್ಕೆಚ್ ಕೇಳಬಾರ್ದು ನೀವು, ಇದು 40 ಆಗಬೇಕು. ಇದು 11 ಸ್ಕೆಚ್ ಅಲ್ಲ, ಎರಡು ಒಂದೇನಾ? 11 ಸ್ಕೆಚ್ ಮತ್ತೆ 40 ಏನ್ರಿ? How it's done now, because there is a software, nothing can be done manually now. You have to upload it, and that Kaveri software is not entertaining a compromise decree. The revenue authorities have no respect to these decrees granted by the courts. In ಒಂದು ಡೈರೆಕ್ಷನ್ ಹೋಗಿಲ್ವಾ ಇಲ್ಲಿಂದ? High time they include it in software. No, correct, but she says that unless there is a 11 sketch, that even mutation cannot be effected. The khata RTC cultivators column ದಲ್ಲಿ ಮಾಡಬಹುದು ಅಂತೀರಾ ನೀವು? ಏನ್ ಪರ್ಪಸ್ ಸರ್ವ್ ಆಗುತ್ತೆ ನಿಮ್ದು? ಓನರ್ಶಿಪ್ ಬೇಕ್ರಿ, ಯಾವ ಅಕ್ವೈರ್ಡ್ ಈಗ ಎಕ್ಸ್ಕ್ಲೂಸಿವ್ ರೈಟ್ ಈಗ ಪೋಸ್ಟ್ ಪಾರ್ಟಿಷನ್. What's the logic in only getting it reflected in? You apply for 40. ಆಗ್ಲೇಬೇಕು. ಹಾಗಾದ್ರೆ ಆಗ್ಲೇಬೇಕದು. ಹಾಗಾದ್ರೆ ಆಗ್ಲೇಬೇಕು. ಮತ್ತೆ ಹೇಳಿಲ್ಲ ನೀವು ಎಕ್ಸ್ಕ್ಲೂಸಿವ್ ನಿಮ್ದೆ ಅಂತ ಹೇಳಿದ್ರಿ ಅಲ್ರಿ. ಆ ಸರ್ವೆ ನಂಬರ್ ನಿಮ್ದು ಸಬ್ ಡಿವಿಷನ್ ನಿಮ್ದು. What is the extent now? Where is the compromise decree? Yes, thank you. Where is the compromise decree? Madam, please see ಏನ್ ಮಾಡ್ಬೋದು ಇದು, ಏನ್ ಗೊತ್ತಾಗ್ತದೆ. ಅಲ್ಲ 40 ಆಗ್ಬಿಟ್ಟಿದೆ ಈಗ. 40 ಆಗಿದ್ದೀರಿ, ಆಲ್ರೆಡಿ ಆಗಿದೆ 40. ಈಗ ಅದು 115/1P1 ಅಂತ ಆಗಿದೆ. ಈಗ ಮತ್ತೆ ಪಾರ್ಟಿಷನ್ ಪ್ರಕಾರ ಏನಾಗಬೇಕು ಈಗ? ಫರ್ದರ್ 40 ಆಗ್ಬೇಕಾ? ಎಷ್ಟು ಶೇರರ್ಸ್? ವೇರ್ ಇಸ್ ದ ಕಾಂಪ್ರಮೈಸ್ ಡಿಕ್ರಿ ಮಿಸ್ಟರ್? How the shares are allotted? Where is the decree drawn? ಎಷ್ಟು ಲ್ಯಾಂಡ್ ಇದೆ? ಒಂದೇ ಲ್ಯಾಂಡಾ? ಎಷ್ಟು ಭಾಗ ಆಗಿದೆ? 5 shares. Then you have to get a 40. Get it done. I share. ಮಾಡಕ್ ಬರಲ್ಲ ರೀ, ಮಾಡಲ್ಲ ಅವರು. ನೀವು ಕೇಳ್ತಾ ಇಲ್ಲ. Give a detailed representation to seek 40. 40 na 11 is sketch. What is the difference between 11 is sketch? Ravi Shankar. Hey, Mr. Ravi. What is the difference between 11 is sketch and 40 subdivision? ಅದು 11 is sketch only for sale, ಅದು ಮಾಡ್ಕೊಳ್ಳೋದು ಅವರು. ಬೌಂಡ್ರಿ ಫಿಕ್ಸ್ ಮಾಡಿ. 40 ದಲ್ಲಿ ಅಂದ್ರೆ ಸಬ್ ಡಿವಿಷನ್ ಬೈ ಸಬ್ ಡಿವೈಡೆಡ್. 11 is sketch ಅಂದ್ರೆ ಮಾರಾಟ ಮಾಡೋದಕ್ಕೆ ಮಾತ್ರ ಒಂದು ಬೌಂಡ್ರಿ ಫಿಕ್ಸ್ ಮಾಡ್ಕೊಡ್ತಾರ. They want citizen to face. ಅಲ್ಲ, ಅದಕ್ಕೆ ನಾನು ಒಂದು ರಿಸರ್ವ್ ಮಾಡ್ಕೊಂಡಿದ್ದೀನಿ. ಅದು they have to make assist. ಇಲ್ಲ, that is again now stayed now. Very difficult. Issue.
There are lot of procedures. By virtue of that, the decree of civil court is defeated. Parties cannot enjoy property.
But now it's only one land, a very small extent. There are 5 sharers. In terms of compromise decree, they want to get their name mutated. How? 1/5 share each ಅಂತ ಮಾಡ್ಬೇಕಾ? ಅದೇ extent ತೋರಿಸ್ಬೇಕಾ? I think they should have no impediment actually. They can't show, they should not. Extent reflect ಮಾಡಕ್ಕೆ ನೀವು ಯಾಕೆ ಮಾಡ್ತೀರಿ? It's already carved out, madam. ಒಂದ್ಸರಿ 40 ಆಗಿದೆ. ಆಗಿದೆ ನೋಡಿ. ಪೇಜ್ ನಂಬರ್ 20 ಅಲ್ವಾ? ರಫ್ ಸ್ಕೆಚ್ ಆಗಿದೆ. ಆಲ್ರೈಟ್. ಯಾರು ನೋಟಿಸ್ ತಗೋತಾರೆ? ಯಾರು ಯು ಸೀಕ್ ಇನ್ಸ್ಟ್ರಕ್ಷನ್. London SCDP is directed to accept notice to respondents. Yes, ನೋಡೋಣ. ಡೇಟ್ ಕೊಡಿ, February 3rd week ಅಲ್ಲಿ ಕೊಡಿ. Yes, Vijay.
By the Karnataka no action of taken, and still that conversion or they convert not being from the layout and.
Well, that's not set aside by the appellate tribunal.
At the same point, like, fake and set aside
Fake
by-
badak baralla, but it declared that it is a fake carbon. What mandamus? You know, based on that, they are still battling with the property.
It's turning to an agreement to purchase the site in the layout. Later when we scrutinize the papers, we came to know it's a fake and must.
Allah, what action can deputy commissioner take now?
Because of the conversion. ಅದನ್ನೆಲ್ಲ ಅವ್ರು cancel ಮಾಡಿದ್ರು. And if it is,
Or they have to be cancelled now?
how-
Or those, what, khata, Gram Panchayat,
once it is converted.
correct.
To take, conversion.
So he has to take action, deputy commissioner has to. Private respondent idara illi? Nodilla ನೀವು ಬರ್ಕೊಡಿ Leonard SCGP accepts notice to 1 to 3 issue 1 to 3 ಇಲ್ಲ 1 and 2 issue emergency notice to respondent 3 to 5 audit. No, but we have to hear them. I'll fix a short date. Emergency notice. Really, this matter in preliminary, second week court date, not second week.
They are 19. As per the grant, they are 1981. Today, authorized contractual fee is 24.
What is this order passed by deputy commissioner?
And now, when authorized issue, revenue records will continue in the name of petitioner. Year 2012 and 13 RTC shown in the name of fifth respondent in the without entering any records. That MR number, at stage number 36.
Your name was mutated based on a grant order.
Is not grant. And,
That-
continue my name.
That is deleted pursuant to order passed by?
My name is continued in the.
Now, who has ordered to delete your name?
Respondent of Praveena. And page number 36, shown MR number 37, 1997. As per the set MR, her name is mutated in the revenue record. With respect to set MR, I submitted the application to obtain the same. The Tahsildar issued an endorsement saying that no such MR is available in the office of Tahsildar. Thereafter, I prepared an appeal before upstate commissioner to cancel the MR and records which is standing in the name of fifth respondent. The assistant commissioner passed an order by setting aside the mutation, which stands in the name of fifth respondent, and remanded the matter to the Tahsildar. The Tahsildar, after ascertaining document and after reading the both parties, confirmed the revenue records in my favor and concluded my favor in the revenue records. Against this said order, the fifth respondent challenged the same before assistant commissioner at page 46, regarding challenging the orders of the Tahsildar. The assistant commissioner, after reading the matter, confirmed the orders of the Tahsildar and continued my name. Against which the fifth respondent challenged the same before deputy commissioner. The deputy commissioner reversed the order and allowed the wife to respond, saying that she is the owner of the property
Based on what?
based on unregistered agreement of sale. And he observes there is no document available in the our copies. There is no mutation
Henry?
available in our copies.
Unregistered sale data.
ಆಮೇಲೆ ಅವರು ಹೇಳ್ತಾರೆ ನೋಂದಾಯಿತಲ್ಲ ಅಂತ ಪೇಜ್ 22
ಕ್ರೇ ಅಂತಿದ್ಯಾ? It's a registered sale deed.
ನೋಂದಣಿ ಆಗಿರುವುದಿಲ್ಲ ಕೆಳಗಡೆ ಇದೆ ನೋಡಿ.
Unregistered ring. And she has purchased, from whom she has purchased? Where is your grant order?
Annexure B, paper copy annexure,
ನೀವೇ ಗ್ರಾಂಟ್ ಮಾಡಿದ್ದೀರಿ. ನೀವೇ ಗ್ರಾಂಟ್ ಮಾಡಿದ್ದೀರಾ?
and revenue records also continue my name, since from the grant.
ಬರ್ಕೊಡ್ರಿ. petitioner's name was mutated pursuant to grant order passed by the competent authority. Respond number 5. ಯಾರು execute ಮಾಡಿದಾರೆ ಅದು unregistered sale deed? ಅಲ್ಲ ನಿಮ್ದು ಯಾವ್ದು MR ನಂಬರ್ ಅದು ನಿಮ್ಮ ಹೆಸರು ಮ್ಯೂಟೇಟ್ ಮಾಡಿದ್ರು? Petitioner's name was mutated pursuant to grant under MR number 37/88 1980 81. Fifth respondent. Fifth respondent is asserting title based on unregistered sale deed. Tahsildar after due inquiry ordered to restore petitioner's name which was deleted at the instance of fifth respondent. Same is confirmed by Assistant Commissioner. Deputy Commissioner, however, citing, taking note of the unregistered sale deed, has set aside the orders of the Assistant Commissioner and Tahsildar and has ordered to mutate fifth respondent's name. Prima facie, Deputy Commissioner's order runs contrary to the mandate provided under 128, 129. Therefore, order under challenge needs consideration. Accordingly, stayed until further orders. SCGP is directed to accept notice to 1 to 4, issue emergency notice to R5. Huh? Use the mic, I'm not able to hear you.
My lord, the property bearing survey number 63/2, totally measuring 5 acres 5 guntas, my lord. The said property, my lords, is obtained by one Rangaya, my lords. That through a sale deed, my lords, in the year 1945, my lords.
Yaru Rangaya?
Rangaya, my lords, is the earlier owner, my lords. He purchased the property, my lords, from my lords. Annexure E, my lord, is the income certificate, page number 29. My lords, on Hanuma, my lords, is the brother of the Devirama, has purchased the property, my lords, in survey number 63/2, measuring 5 acres 5 guntas.
How we are related? Read synopsis.
My lords, I have produced a geological tree, my lords. The petitioners herein are the, my lords,
Family.
family tree, page number 20 and 21, annexure B, my lords. My lords, one Jettingappa and Devirama are the husband and wife, my lords. They have got 7 children. Page 20 and 21, my lords, is the geological tree.
Yes.
Lord, the issue regard, my lords, in this case, my lords, the property bearing survey number 63/2, measuring 5 acres 5 guntas, my lord. One Hanuma has purchased the property, my lords, by one Rangappa, my lords, in the year 1946, my lords. Subsequently, my lords, in the year 1949, my lords, the Annappa, that is the father of the respondent number 4, my lord, had purchased the property in survey number 63/2, measuring 2 acres, my lords. Subsequently, my lord, the partition deed came to be executed.
Who are you?
My lords, I am the sons of, my lords, the Devirama, my lords, as per the genealogical tree, my lords. The legal heirs of Devirama.
You're
Please,
tracing title through Hanmaya.
please, my lord. The issue is in this case, my lords, we have sold, my lord, only 2 acres of land in survey number 63/2. That is registered sale deed, my lords, in the year 1949. My lords, the respondent number 4, Annayappa, has created the one sale deed, my lords, in the year 1947, stating that another 2 acres of land pertaining to same survey number has been transferred to, my lords, some other person.
Challenge.
The assistant commissioner has given a finding that Since the registered sale deed has been involved, this covers, my lords, the civil disputes. Hence, my lords, the appeal came to be dismissed by the assistant commissioner.
1949 sale deed.
Yes, my lord. My lords, as per the RTCs, my lord, have produced the property bearing survey number 63
What
bar
should
2.
have happened to remaining 1 acre 5 guntas?
1 acre 5 guntas are in the possession of, my lords, the petitioners.
Petitioner.
The RTC shows, my lord, up to 2019, the property bearing survey number 63 bar 2 measuring 6.18 acres, including Karab, my lords. The standing in the name of Devi Rama.
You have to challenge that sale deed.
My lord, the assistant commissioner, my lord, without giving a finding, my lord, had dismissed my appeal, my lord. The deputy commissioner also given the same finding, stating that, my lords,
But there is sale deed. Based on sale deed, those purchasers' names are mutated.
lord,
in
I
the
have, my lord, I have sold only 2 acres of land, my lords, in
Wait a minute,
particular survey number.
Shrikant, you can't dispute a sale deed in a mutation.
No, I am not disputing the sale deed, my lord. The issue involves is that, my lord, I have sold only 2 acres of land, my lord,
That's
out
what
of 5 acres.
You are disputing, the other 2 acres you are disputing.
Other 2 acres has been disputing, my lords. But
It's a 1949 sale deed.
yes, my lord.
Challenge it. Now, whether the purchaser's name is reflected in RTC to an extent of 2 acres all along.
That is the issue, my lords. Another 2 acres of land, my lords, as purchased by one Govindappa by Annayappa. The Annayappa is the father of the respondent number 4. That never came to be sold by these petitioners, my lord. They have sold only 2 acres of land.
Sir, whether RTC ದಲ್ಲ 2 ಎಕರೆ ಯಾರ ಹೆಸರಲ್ಲಿ ರೀ?
ಅದು ಗೋವಿಂದಪ್ಪ ಅವರ ಹೆಸರಲ್ಲಿ ತೋರಿಸ್ತಾ ಇದೆ.
ಯಾವಾಗಿಂದ ಇದೆ?
After 2019, my lord. Since from the year 1972, 2019, the Devi Rama is shown as a possession in the said property, my lord. I have produced the RTCs, my lords. Entire survey number, my lord, the extent of 6.1 acres is in the possession of Devi Rama.
ಬರ್ಕೊಡ್ರಿ. Now you have challenged the mutation where Govindappa's name is mutated.
Yes, my lord.
To an extent of 2 acres.
2 acres, my lord.
Based on 1949.
Yes, my lord. I have also produced, my lord, in the year 1972, page number 32, my lords, may kindly be see. Annexure F, my lord.
ಬರ್ಕೊಡ್ರಿ. Petitioner is aggrieved by the mutation certified by the revenue authority, thereby mutating. ಅವ್ರನ್ನ ಪಾರ್ಟಿನ ಮಾಡಿಲ್ಲ ಅಲ್ಲಿ.
The respondent number 4 to 6, my lords, are the private
mutating
respondents.
the name of one Govindagowdana.
Govindappa, my
Govindappa with the ancestor ಆಗಬೇಕಾ?
ancestor.
Of respondents, private respondents 4 to 6. The authorities have declined to grant any intelligence. Having taken cognizance of the fact that Govindaya and Govindappa.
Govindappa, my lord.
Govindappa has acquired title based on a 1949 sale deed. Next, petitioners contend that their ancestors, namely Hanumaya and Devirama, who were owner to an extent of 5 acre 5 guntas, have only alienated 2 acres in favor of one Hanumaya under registered sale deed dated 1/8/1949. Petitioners are disputing the sale transaction as the sale deed in favor of Govindappa.
Please.
Govindappa. Revenue authorities, referring to the sale deed obtained by Govindappa way back in 1949, have declined to grant any indulgence. Civil court ಹೋಗ್ರಿ ಅಂತ ಏನಾದ್ರು ಹೇಳಿದಾರಾ?
ಇಲ್ಲ ಹೇಳಿ. The observation has been made by the AC, my lords, at page number 18, last portion, my lord.
ಏನಂತ?
ಮೇಲಿನ ಅಂಶಗಳನ್ನು ಪರಿಶೀಲಿಸಲಾಗಿ ಅಣ್ಣಪ್ಪನವರಿಗೆ ನೋಂದಣಿ ಸಂಖ್ಯೆ ಸೋನ್ಸೋ ಕ್ರಯದಂತೆ 63/2ರಲ್ಲಿ 2 ಎಕರೆ ಮತ್ತು ನೋಂದಣಿ ಸಂಖ್ಯೆ ಸೋನ್ಸೋ ಕ್ರಯಪತ್ರದಂತೆ 2 ಎಕರೆ ಜಮೀನು ಬಂದಿದ್ದು MR 9/2000.
ಬರ್ಕೊಡ್ರಿ. The revenue authorities have certified a mutation, thereby mutating Govindappa's name to the RTC to an extent of 2 acres based on sale deed, 1949 sale deed. Petitioners indirectly are disputing the sale deed which is of the year 1949. In mutation proceedings, the revenue authorities have no right to examine the validity or otherwise of the sale deeds. The scope of inquiry under section 128 and 129 is very limited. Revenue authorities are under mandatory duty to effect changes whenever acquisition of right is reported. In the case on hand, Govindappa's name is belatedly mutated in 2019, though title was acquired in 1949. petitioner's contention that Deviramma name was Deviramma name was duly reflected in the RTC, excluding the sale of 2 acres in favor of 1 Hanumaya, and therefore the orders of the assistant commissioner and deputy commissioner requires indulgence cannot be acceded to. Next, if petitioners are aggrieved by the sale deed 1949 sale deed obtained by Govindappa, who is the ancestor of respondents 4 to 6, they have to seek a redressal of their grievances by approaching civil court. The validity of sale deeds 1949 sale deed obtained by Govindappa I cannot be subjected to an inquiry under section 128. Writ petition is debarred of merits, accordingly stand dismissed.
The revenue interest, my lord, may be maintain status quo, my lord. Till, my lord, they are in the possession of the property, my lord, since from the year 1972.
ಏನ್ರಿ 227 petition ಅಲ್ಲಿ ಬಂದು ಪೊಸೆಷನ್ ಬಗ್ಗೆ ಎಲ್ಲ ಮಾತಾಡ್ತಿರಲ್ರಿ.
They are interfering, my lord, so that's why.
ಪೊಸೆಷನ್ ಬಗ್ಗೆ ಏನ್ ಮಾಡ್ಬೇಕು?
Please. Please.
Yes, sir.
Writ of mandamus, my lordship, direction. The petitioner filed the representation before the respondent number 5 to conduct the Podi and Durasti and effect the Kata computers. my lord.
Yes,
That's why the very grant itself is not.
all right, seek instruction.
No, my lordship, this honorable court already
ಹೌದಾ?
connected matter, my lord. Please, my lord.
ಇದೇ ಗುಂಡು ತೋಪ ಇದೇ ಸರ್ವೆ ನಂಬರಾ?
Same survey number. Last date in the, I served the copy of the.
Served the copy.
Please.
ಯಾವ ಸರ್ವೆ ನಂಬರ್ ಇದು ಇದರಲ್ಲಿ?
Survey number 120, my lordship.
ಸರ್ವೆ ನಂಬರ್ 120.
Survey number 120, situated at Nagundanhalli village, KR
Correct.
Puram Hobli, Bangalore East Taluk.
ಯಾರು ನೀವೇ ಇದ್ರಾ?
ಅವರೇ ಇದ್ರು ಸ್ವಾಮಿ.
ಬರ್ಕೊಡ್ರಿ. Caption petition is filed. Seeking mandamus against respondents to effect to generate computerized RTC to an extent of 1 acre in survey number 120 based on a grant order and accordingly conduct Podian Durasti. Next, petitioner has knocked the doors of this writ court, alleging that there is complete inaction on the part of ಏನು representation ಕೊಟ್ಟಿದ್ದೀರಾ?
Representation code, that is annexure A, my lord, page number 11. Subsequent representation, 28/11/2024,
ಯಾರಿಗೆ ಕೊಟ್ಟಿದ್ರಿ ಇದು?
respondent number 5. Tahsildar.
Yes, there is a complete inaction on the part of fifth respondent Tahsildar. In not considering petitioner's representation dated 28/11/2024. Petitioner is affecting title in respect of 1 acre of land based on a grant made in his favor in LND SR number so and so dated 24/9/1994. Petitioner, to substantiate the validity of grant, is also placing reliance on the official memorandum issued by the competent authority, followed by issuance of Sagulichit. The copy of official memorandum with sketch dated 24/9/1994
Please.
is also placed on record. Next, Leonard AGA has tried to resist the claim of petitioner on the ground that survey number 120 is a Gundu Topu and therefore the grant itself is not genuine. This is effectively countered by petitioner by placing reliance on directions issued by the coordinate bench in, in favor of a similarly placed grantee in the very same survey number. Having taken cognizance of the order passed by the coordinate bench, this court is of the view that this is the fit case where mandamus lies. Though representation is tendered to fifth respondent Tahsildar, there is complete laxness on the part of fifth respondent in not passing appropriate orders. Despite the representation is received by fifth respondent Tahsildar. This is the fit case where a mandamus lies. For the foregoing reason, this court passes the following order. Repetition is allowed. Fourth respondent Tahsildar is hereby directed.
Fifth respondent.
Fifth respondent Tahsildar is hereby directed to consider the repetition dated 28/11/2024, evidence at NHRA and pass appropriate orders and take appropriate steps to issue a computerized RTC followed by Podi and Durasti. So as to demarcate petitioners 1 acre of land in survey number 120. Next, this exercise shall be accomplished within a period of 6 months from the date of receipt of order.
Much. The order that is called in question is the order of DC, my lord, passed under section 136(3) of the Land Revenue Act.
Sir, it's for interim order. Just wait. Urgency.
Even now, if there is no precipitation of the revenue entries, I don't have any difficulty. But now, my lord, for the first time, the
ಮಾಡ್ಕೊಂಡ್ರೆ ಹೆಸರು ಹಚ್ಕೊಂಡ್ಬಿಟ್ರೆ ನೀವೀಗ ಹೆಸರು ಹಚ್ಕೊಂಡ್ಬಿಟ್ರೆ ಏನ್ ಮಾಡ್ಬೇಕು? For preliminary, sir, you can't seek adjournment. Stay ಕೊಡ್ಬೇಕಾಗತ್ತೆ. Who are you? What's your right?
my lord, my right is I have purchased this property under registered sale deeds. My lord, the three of the
From whom?
from my lord, the earlier owners, my lord, at an undisputed period of
And
time.
what is
1970.
private respondents?
The private respondents, my lord, claims from a different branch. My lord, the genealogical tree, my lord, is at page number 92. My lord.
92.
Please, my lord.
Ah,
My lord, Iraya is the prepositus. Will go
Yes.
ahead, please.
yes.
He had 4 sons, my lord, Iraya, Kadaya, Dyavaya, and Kariyaya. My lord, this Dyavaya's son is Nanjaya Uruf Gosaya. Nanjaya Uruf Gosaya had a son by name Devaya. This Devaya is the father of the petitioners. This is how, my lord, my lineage comes.
Yes.
My lord, now the properties are purchased by my father Devaya under various, there are 9 items of these properties which are involved in dispute. My lord, 7 of them, my lord, are under registered sale deeds. Dyavaya himself has purchased the property in the year 1971 and so on. 3 properties, my lord, are granted under the Inam Abolitions Act in favor of this. In name of Devaya. One in name of this Nanjaya Uruf Gosaya, who is the grandfather of the petitioners here. Nanjaya Uruf Gosaya. His name comes, my lord, below Dyavaya.
Ah,
That is how, my lord, the title is traced. Throughout, my lord, revenue entries are standing in my name. Now, a civil suit, 2 civil suits are filed concerning the very same property by the private respondents herein. They are Yashodamma and Shankrama. In the genealogical tree, my lord kindly find the second son Kadaya. The first son Iraya son of Iraya, my lord. He is shown to have had 3 sons. Dyavaya has got 2 children by name Yashodamma and Shankrama. They are the private respondents. They file a suit for declaration of title and permanent injunction concerning these properties.
declaration to the effect that
This is the ancestral property and they are the absolute owners of the properties.
they don't seek partition.
They don't seek partition. Suit is pending. Now what they do is, now they go before the assistant commissioner saying that revenue entries will have to be mutated in their name. Assistant Commissioner says for a very long period of time, the MRs have been also mutated and RTCs have
Alright,
given
sales are in your father's favor.
father's name.
Grant is also in your favor.
Father's name.
Whether the sale is obtained is from the corpus.
Or not
and
is the question.
Whether the grant would denote to the other family members is a question seized before civil court.
Civil court.
Now,
Now,
who ordered to effect joint names?
Now, Deputy Commissioner now says he doesn't give any reasoning. At page number 114.
Reasoning andre ಏನು?
ಏನಾದ್ರೂ ಹೇಳಿ anything. My lord, most unreasonable order also he can pass, but he doesn't say anything. At the operative portion, he says, let there be a joint mutation of.
Refused.
He refused citing the sale deeds, MR, and the pendency of the civil suit. He takes it in a revision, and the revisional court, my lord, orders for joint kata.
Now, he appears for all the private response.
He appears for the private response.
Okay, we'll dispose of. I'll grant you stay right now. Next week, you get ready.
Please.
For short point that needs consideration at the hands of this court is as to whether Deputy Commissioner was justified in directing the authorities to mutate the name of private respondents also, whose rights are yet to be decided in a pending suit filed by them in OS number
149 of 2020 and
149 of 2020
and 115 of 2021.
and 115 of 2021. While private respondents are asserting that these lands are ancestral properties, petitioner is asserting that his father has acquired all these petition lands and the sale deeds are in his favor, and some of the properties were granted to him, and therefore petitioner is asserting that these lands are self-acquired properties of his father. While these properties have been standing in the name of petitioner's father for a pretty long time,
Yes.
pending consideration of the suit, second respondent has directed to mutate the names jointly in the RTC pending consideration of the caption.
He doesn't say that also.
Has
He is
directed to
there.
order to enter the names jointly in the RTC. This order prima facie runs contrary to mandate provided under section 128. Matter therefore requires consideration. Accordingly, the order of the Deputy Commissioner is stayed until further orders. Learned, the AG is directed to accept notice to respondents 1 to 4. Let this matter in premiering on. Kodri, that one admil kodi.
Please. Great.
Collect all their fees.
6th and 7th, I'm not in station. It will be my lord any day thereafter. 10th. Great.
Yes, Ravi Shankar.
The impugned order is one passed under 136(3) of the Land Revenue Act, my lord, by which Deputy Commissioner refuses to condone the delay and dismisses the revision petition, my lord. The fact,
By you,
yes, my lord.
why, how much is the delay?
Fact necessary are that, my lord, there are some serious, my lord, fraud played by the private respondent number 4 to 7 upon the authorities. My lord, and my lord, they got
47 na?
out. My lord, may I take, my lord, few facts, annexure F, page 27, my lord. There was a proceeding, my lord, under the PTCL Act for restoration of the land, my lord, for violation of the, my lord, grant conditions.
Page?
Page 27, my lord, typed copy at page 29.
Oh.
My lord, one Rama, lordship may kindly note that name, my lord, K. Rama. My lord, as an informant, my lord, he informs the Assistant Commissioner that there is violation of conditions of.
Not the grantee.
Not the grantee, my lord. That is where I want to press upon, my lord. First pair of the order itself. In this case, K. Rama being a member of so and so filed restoration of land measuring so and so of their Belu Taluku. The land in question was originally granted to one Srimati Tannu Holati in DR number so and so. The granted land now is found to be in possession of the respondent Srimati Yamana, who does not belong to the scheduled caste, scheduled tribe. My lord, his information to the Assistant Commissioner is that, my lord, it was granted to one Tannu Holati and one Yamuna is in possession. Therefore, there is violation of conditions of grant. My lord, Assistant Commissioner conducts the proceedings, and there, my lord, opposition was made by Yamuna stating that the Rama has no authority to inform the Assistant Commissioner, and proceedings cannot be initiated at.
All right, that was allowed.
My lord, allowed, holding that, my lord, the land shall be resumed to the government and then to be given to the legal heirs of the Tannu Holati. Then, my lord, that writ petition came, the proceedings were taken up to dishonorable court, my lord, annexure G, order of dishonorable court, wherein also, my lord, a contention was raised. May I take, my lord, page 38. Page 38 in the writ petition, my lord, the contentions raised. The first point, my lord, at page 38, para 3, subclause 1.
Yes.
My lord, after contention, my lord, point number 1, 3 subclause 1, my lord. Whether respond number 4 is the legal heir of one Tannu Hulatti, who is the original grantee of the land in question. My lord, that contention was raised, and this honorable court has held that, my lord, it is for the assistant commissioner to decide who is the legal heir and to, my lord, re-allot to them. And the Yamuna cannot obstruct that on that ground, and therefore, my lord, writ petition was dismissed, observing so, my lord. Then, my lord, the legal heir of this K. Rama, after death of K. Rama, my lord, moves the Tahsildar for mutating their name in the revenue records on the ground that, my lord, the K. Rama has initiated proceedings. There is a restoration of land. Therefore, their name should be entered in the revenue record is their case, my lord. Based upon such a false information, my lord, the mutation was effected in the name of private respondents, my lord, annexure C, page 23, typed copy, page 24, my lord, I have produced.
Now, who are you represent?
My lord, I am the legal heirs of, my lord, original grantee Tannu
original
Hulatti.
grant.
As soon as
The order and the order of the assistant commissioner says that it has to be restored to the original legal heirs of grant,
yes, that
That
was
is the
confirmed by
confirmed.
this honorable court, my lord.
confirmed by this.
Confirmed by this honorable court. That specific contention was raised before.
All right,
this
now legal heirs of K. Rama got their name mutated.
Yes, my lord.
You challenged it.
On noticing this aspect, my lord, I challenged it before the, my lord, Deputy Commissioner by invoking 136(3) of the Land Revenue Act, my lord. Deputy Commissioner holds there is a delay in filing the revision, therefore, my lord, he dismisses my revision petition.
How much is the delay?
My lord, 21 years, he says, my lord. 2010, my lord, annexure B order, wherein, my lord, the assistant commissioner direction.
Whether you were notified when that?
No, my lord. That is where, my lord, Tannu Hulatti died in the year 1978 itself. We are depressed caste LTM people, my lord, residing therein.
Whether assistant commissioner ordered to restore that land to you people?
Lord,
Restoration ಆಗಿದೆಯೋ ಇಲ್ಲ ಇನ್ನು?
ಇಲ್ಲ.
ಅದು ಆಗಿಲ್ಲ.
ಅದು ಆಗಿಲ್ಲ. ರಿಸ್ಟೋರೇಷನ್ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಪೆಂಡಿಂಗ್ ಇದೆ, ಅದರಲ್ಲಿ ನಾನು ಒಬ್ಜೆಕ್ಷನ್ ಆಗ್ತೀನಿ. ನಾನು ಆಕ್ಚುಲ್ ಲೀಗಲ್ ಹೇರ್ ಇದ್ದೀನಿ. ದಿ ರಾಮ ಅವರು ಓನ್ಲಿ ಇನ್ಫಾರ್ಮೆಂಟ್, ದೇರ್ ಲೀಗಲ್ ಹೇರ್ಸ್ ಹಾವ್ ನೋ ರೈಟ್ ಓವರ್ ದಿ ಪ್ರಾಪರ್ಟಿ.
ಬರ್ಕೊಡ್ರಿ. Petitioners are tracing the title through one Tannu Hulatti who was granted the petition land. There were proceedings initiated under the provisions of PTC Act at the instance of the private respondent's father, at the instance of husband of fourth respondent, correct?
Please, Manu.
The assistant commissioner, having noticed the violation of the grant conditions, order to restore, allowed the application, and one Yamuna Bai was found in possession, contrary to the grant conditions, assistant commissioner directed to restore the petition land to the legal heirs of one Tannu Hulatti was no more.
Please.
The next, however, this K. Rama, who is the husband of fourth respondent, was a whistleblower. After his death, his legal heirs have submitted a worthy and got their name mutated. This mutation prima facie appears to be without acquisition of any right and title. Petitioners who are the legal heirs of original grantee were never notified while this mutation was effected. However, when a revision is filed before first respondent deputy commissioner, revision petition is dismissed on the ground that there is inordinate delay. Matter requires consideration, having regard to the fact that petitioners belong to depressed class and their mother had a benefit of a grant, correct?
Please, Manu.
Grant. Accordingly, what you want to be stayed now?
I have sought for stay of the 3 orders, my lord.
Huh?
I have sought for stay of the order of mutation confirmed by the assistant commissioner and deputy commissioner.
Early the mutation ಯಾವ್ದದು?
Annexure C is the original
MR 52 Allah.
MR 51, my lord.
MR
52 of 2001, 2002.
Accordingly, MR 52 of 2001 to passed by third respondent as per Annexure C and confirmed by Assistant Commissioner and Deputy Commissioner
Please.
are hereby stayed until further orders. Learned AGA is directed to accept notice to 1 to 3, issue emergency notice to respondents 4 to 7.
Great.
Appear for the petition. It's writ of mandamus well as seeking for assessment of A Kharab lands. To include A Kharab land in the column number 9 of the article.
Well, assessment and you have to make a request Allah though.
I have given representation to the DC.
Yes.
Covered by my lord's decision.
Already passed order, it is annexed.
Howda?
Page number 50.
Okay, that page.
Page number 50, madam.
Annexure E.
Please, madam. This is in respect of both A and B Kharab, madam. But
But this one is not complied, huh?
no, madam.
Similar.
Similarly. Present petition is only with respect to A Kharab.
Manjunath will be on his toes when I say that this order is not complied. All right, similar order.
It is B Kharab, it cannot be done.
Only A Kharab, madam. So we're not asking for B Kharab.
Verify. It's A Kharab land. It can be subjected to assessment Allah,
Please.
subject to inquiry. Work order.
In 28, they have issued endorsement, my lords. So that endorsement has to.
Petitioner is aggrieved by non-consideration of the representation submitted. Representation dated 14/10/2024, where a request is made to bring the petition lands which are classified as A Kharab lands under Kirada Sagu and determine assessment under section 84(2) and section 122B of Karnataka Land Use Act 1964. Next. Facts leading to the case are as under. Petitioner is aggrieved by non-consideration of petitioner's representation, where a request is made to to permit petitioner to cultivate the petition lands which are classified as A lands, citing the relevant provisions, namely 84 subclass 2 of Karnataka Land Revenue Act, read with section 122,
B.
section 122 capital B of Karnataka Land Revenue Act. Petitioners are asserting that they're entitled to seek mandamus, thereby directing the respondents to determine the assessment so that the petition lands can be subjected to cultivation. Next, learned AGA, however, submits that unless an inquiry is held and the authorities verify that the petition lands are classified as A lands, there can't be any determination of assessment. Having heard the counsels appearing for the respective parties, this court is of the view that though representation is submitted on 14/10/2024, there is some laxness on the part of authorities in not holding an inquiry to ascertain whether petition lands can be subjected to cultivation and therefore consequently require determination of assessment. Then there is inaction and petitioners have a legal right to seek directions at the hands of this court. This is a fit case where a mandamus lies. For the foregoing reasons, this court passes the following order. Petition is allowed. Respondents are hereby. Yaru respondents.
Deputy Commissioner, DDLR, AC and Tahsildar.
Who is the competent actually?
DC, Deputy Commissioner, 84 feet DC.
Madam Yarri, assessment yaru determine ಮಾಡಬೇಕು?
DC on 84 2.
Deputy Commissioner.
Mm.
Second respondent, Deputy Commissioner is hereby directed to consider the representation strictly aligning with the mandate provided under section 84, read with section 122B of Karnataka Land Revenue Act, and pass appropriate orders. Next, this exercise shall be accomplished with a period of 3 months from the date of receipt of order.
Serial number 28 also same
Okay.
matter, but their endorsement is issued 30 years.
ಏನಂತ ಮಾಡಕ್ ಬರಲ್ಲ ಅಂತ.
ಅದೇ 30 ವರ್ಷ ಇದಿದೆ, so we cannot do.
ಯಾಕೆ ಸಬ್ಜೆಕ್ಟ್ ಅಸೆಸ್ಮೆಂಟ್ ಏನು?
ವಿಲೆ ಇಡಲಾಗಿದೆ. Quoting 112 and 120, 115.
ಏನ್ ಸೈಟ್ ಮಾಡಿದ್ದಾರೆ ರೀಸನ್ಸ್? ಹಾ, ಒಂದ್ ನಿಮಿಷ, let us see what 122B says.
Thirty years.
Even I think 123 is also applicable. Nothing in this chapter shall be deemed to prevent the settlement officer from determining and registering the proper full assessment of lands wholly exempt from the payment of land revenue. You are vested with power. ಅಲ್ಲ ಈಗ A class ಅಂತ ಮಾಡಿ, if it is cultivable, why should not? ಯಾಕೆ ಮಾಡಬಾರ್ದು? What's the bar? You tell me. 30 years ಒಳಗಡೆ ಯಾಕಂತ ಎಲ್ಲಿ ಹೇಳುತ್ತೆ? Where is stipulated? Direction to be obtained from? ಎಲ್ಲಿ ಓದ್ತಾ ಇದ್ದೀರಾ ಅದು ಮಂಜುನಾಥ್?
Page number 10.
Page? ಹಾ. All right, he has cited two sections, 112 to 115. ಏನದು? ರೆಲೆವೆಂಟ್ ಇರಲ್ಲ ನೋಡಿ ಅದು ಅರ್ಜುನ. ಅದು ಬರಲ್ಲ. 114 may direct original revenue settlement of land revenue of ಅದು ಬರಲ್ಲ. 15 terms of settlement shall remain in force for a period of 30 years. Revision of settlement of land revenue in certain cases. ಯಾವಾಗ ಇದು A classify ಯಾವಾಗ ಆಗಿತ್ತು ಹಾಗಾದ್ರೆ ನಿಮ್ ಪ್ರಕಾರ? All right, you see, second instructions. You can't take away right. And if it is, if a owner wants to, see, A class is, the rights vest with the owner. You have no right. You can't curtail his right. You tell me what's the logic in denying him the right to cultivate it? Although if he's enhancing the extent of cultivation, why you should discourage him? Take instruction. We'll have it in next year. You also, please
Please.
check out. All right. London SCGP is directed to accept notice to respondent. London SCGP seeks short accommodation to examine the matter and make his submissions on the next date of hearing. At his request, release this matter in preliminary on so and so date. What a date. Yaudu?
27, serial number 27.
ಎಷ್ಟು ಮಾಡಿದೀವಿ? 3 months ಮಾಡಿ. You want 6 months? What is it?
Please.
All right, next.
Prepare for second petition. Your lordship file, I will Wakalat, your lordship, I need to file application to this. I'll file, but Wakalat, my lord, I need to file my application to the petition.
Fresh matter, how you can file objections?
Give it for
No, you can't file objection. You can contest. You can oppose interim order. Yes, sir.
Your
Joshi, sir.
simple plaintiff has approached this honorable court.
Oh,
I have-
plaintiff has approached,
I have filed a suit for partition. My suit for partition is pending.
pending.
Some of my family members have gone and got the revenue entries changed. The revenue authorities are saying,
As in the date of the filing of the suit, whose name was appearing?
our ancestors, that RTC I produced, my lord, will see at page 25.
Page 25.
If the revenue entries are retained at that name, I am more than happy. Page 25, Kushalappa.
Page 25, huh?
25 and 26. Sorry.
No, it's only 26. Why this pagination is not get,
Even 25 and then
Ah.
yesterday.
why these paginations do not tally?
So sorry.
I'm also including myself. I'm not saying that only you are at wrong. Huh?
It's typed copy, so again we had to renumber it. Then
All right, but you're closer to it. It's 26. One then a survey number, Joshi sir.
Oh, how? 180/2.
180/2. Totally
180/2,
measuring 7.
Kushalappa antide.
And now what they have done?
What they have done now is they have transferred it to the name of the respondent number 2.
2. Where is that mutation?
Well, that is at page 88. For the
80?
mutation, the revenue entry. Page 28 for me. Page 28 notebook.
Page 24.
I'll court
page
copy,
28, my lord. I
28.
produced the
court copy and page number.
28.
It's still showing.
Now what, based on what? RP 37 ಏನದು?
AC ಮುಂದೆ ಇದ್ದ proceedings.
No. See, his
ಇಲ್ಲಿ.
name is mutated based on this RP 37 of 2024 dated 19/11/2024.
Yes.
What is that order?
But that is the order of the Tahsildar at page 88, confirmed by the AC and DC.
Oh, now Tahsildar orders. to
Tahsildar
take.
permitted this.
Based on what?
Based on an internal partition deed which they have entered into amongst themselves, while my suit for partition is pending in the court.
Show me the family tree. Where is the family tree?
Well, the description is given in the plaint.
Family tree.
Family tree has not been produced for me,
Not produced.
not produced. At para 3, ink page 3,
How are you related then?
we are all members of the same family, Swami.
There are different
Page 30.
branches, independent branches,
Independent branches.
or they set the inter-C partition and they get it.
That's all that I'm saying is,
Correct.
suit for partition is
Yes,
coming.
yes, madam. All right, you get ready. Short point. It will be relisted in preliminary, Barcodry. When a partition suit is pending consideration, private respondent number 2, again, Joshi sir,
Yes, madam.
please advise your instructing counsel that you can't stuff a private name in between government authorities, either on top or on.
Cost
at the
title
bottom.
ಬರೆಯೋದ್ನಲ್ಲಿ, that's a matter
Why
of,
second
that's-
respondent, ಇದೇನಿದು?
that's
Madri. Pending partition suit number what, sir? What's number? Huh?
partition sheet. I'll give my
When admittedly,
46 of 2000.
admittedly, a partition suit is pending in OS 46 of 2018. And as on the date of the filing of the suit, the disputed property, which is subject matter of partition suit, is admittedly standing in the name of ancestor, second respondent has got his name mutated on the basis of intrinsic partition within his branch.
That's
This order, though challenged before a fifth respondent assistant commissioner has dismissed the appeal and confirmed same is
confirmed by the deputy commissioner.
appeal was allowed.
And now the DCS restored it. The Tahsildar allowed their application.
Ah.
I went in appeal before AC.
What happened?
AC agreed with me, saying that
Agreed.
interference should not be done.
then but-
DCS restored the Tahsildar's appeal.
Was set aside by fifth respondent assistant commissioner, first respondent deputy commissioner has reversed, and the impugned mutation in favor of second respondent is confirmed by deputy commissioner. Prima facie, the order of first respondent deputy commissioner clearly contravenes the mandate provided under section 128 and 129. The order also contravenes the dependence of a suit wherein the revenue authorities have to restrain themselves from effecting any changes pending consideration of the caption petition. Therefore, they have to state, madam. Therefore, the impugned order passed by fourth respondent revenue inspector and confirmed by first respondent deputy commissioner are stayed since counsel appearing for a private respondent number 2 seeks a short accommodation at her request. Matter is ordered adjourned in order to be relisted in preliminary court after 2 weeks court. Meanwhile, they stayed until further orders. The next hearing will clarify that. In preliminary. Third point.
This has been changed, but
That can't be changed. That can't be changed.
there was no statement.
No, don't argue like this. At least in this court, you don't argue.
Subject to the outcome of the.
You can't get your name entered and then say that subject to outcome anta. We'll enter their name and we'll say that subject
Subject
to.
to.
Boda. You go, how did you got? On one. Yeah, you have right, Mele. What is your right?
That are right.
You're all related. We are all claiming under.
You show me that you have acquired a right under section 128.
In view of the partition, because.
ಯಾವ partition?
There was a partition.
ಅದೇಂಗ್ ಮಾಡ್ಕೊತೀರಾ? When ಅದೇಂಗ್ ಮಾಡ್ಕೊತೀರಾ? Your branch. That was never till filing suit, it was standing in the name of ancestor. How did you get it?
Several partition between them. Your lordship, wherein they agree for others and they don't agree for.
Madam, what is the law on that point? You have to retain the entries once a suit is filed. You can't alter. They can't do it. Why deputy commissioner has done? Get ready. ಇದೆಲ್ಲ ಇದು ಹಂಗೆ ಅದು excess power exercising ಇದೆಲ್ಲ.
Grateful.
Next. Why to get ready. Preliminary.
Grateful.
Sir, on the family tree, Joshi sir,
Yes, sir.
you need a family tree.
Definitely. I'll keep it ready on the next day.
You are restricting council should
We
have,
will also produce that partition deed copy also I'll produce.
based on which they have done
I
it.
will do that.
Probably it is an unregistered or registered.
Both
because-
documents, unregistered.
Still worse,
I'll keep both documents ready.
still worse. We'll comment on it. We'll
I'll keep
comment.
both documents ready.
Yeah, we invited a trouble, we'll comment on it. Yes,
Grateful, madam.
yes,
I am for the petitioners, madam. Serial number 30.
yes, sir.
Lord, writ of mandamus, my lord, to consider the representation to accept the mutation and kata as per the inheritance. The originally property acquired by the father of the petitioners by way of registered sale deed as per annexure B, page
Tell
18.
it, it's a private land.
Private land, as per the sale deed. And my father died, I given a representation.
Please 64 in it.
No, my lord. Revenue entries are mutated, even today standing in the name of my grandfather, my father. But
ಇದ್ಯಾಕಿದು ಇದು ಅಲ್ಲ one right of appeal is also taken away. I don't know why assistant commissioner is entertaining. Actually ತಹಶೀಲ್ದಾರ್ಗೆ ಹೋಗ್ಬೇಕು ಇವೆಲ್ಲ. ಏನು ಹೌದಾ?
Seven beyond.
All that, you direct assistant commissioner is not a party here. All right, or ಕೊಡ್ತಾರೆ, ನಮ್ಮ order representation ಕೊಡ್ತಾರೆ, forthwith he will do it.
My lord, my request is, my lord, as per the SAILD, accepted the kata.
Adam is telling that you have to meet before assistant commissioner.
My lord, no, assistant commissioner not necessary, my lord. Why? Because if it is not mutated my name, I should have go before the assistant commissioner to mutate my name. But my name is reflecting in the column number 12, since from 1966 to even till today.
Column 12. What
Column number 12.
What about column 9?
Column 9 not showing in my vendor name. And now my father died, I given a representation to accept the mutation
Okay,
as per
assistant
the
commissioner
inheritance
has to do it.
kata.
According to them, assistant commissioner has to. The vendor's name has to be deleted. Mutation has to be effected in your father's name. Then by way of inheritance khata, your name has to be mutated. Stage wise.
My lord, the Tahsildar is the competent person to, because if it is not mutated in my name, my lord, that is the correct, my lord. I should have approached to the assistant commissioner.
ಮಾಡ್ಬೋದ್ರಿ, ತಹಶೀಲ್ದಾರ್ ಮಾಡ್ಬೋದು.
That is correct, my lord. If it is not mutated,
So seven must be dealt by the consider. Beyond 2007, it will be dealt by.
ಅಲ್ಲ, but when right of appeal is taken away, I don't know how they, who has permitted them. Under Land Revenue Act, assistant commissioner is an appellate authority, re 136 ಕೆಳಗಡೆ.
In respect of the sale, is private sale is. That is.
God knows, yeah. I don't know, Karnataka Land Revenue Act is not at all applicable to you.
and insofar as, my lord, in the same survey number, ಆ ಬೇರೆ ನಮ್ಮ ಜೊತೆ ತಗೊಂಡಿರೋಂಥವ್ರಿಗೆ ತಹಸೀಲ್ದಾರೇ ಖಾತಾ ಮಾಡಿದ್ದಾರೆ. ಅದು ಈಸಿನಲ್ಲಿ ಗುಂಡಪ್ಪ ಮತ್ತೆ ರಾಮು ಅನ್ನೋರು ನಮ್ಮ ಜೊತೆಲೆ ತಗೊಂಡಿದ್ದಾರೆ.
We'll direct Tashildar and let him seek.
Yes, my lord. Let Tahsildar may take appropriate action as per my documents.
Assistant commissioner. If you
Nam
want.
Tahsildar consider Mali Swami. Let him consider the representation.
Bad re. Our Tashildar will seek permission. This petition is filed, agreed by inaction on the part of second respondent Tashildar is not considering petitioner's representation dated 26/10/2017. Wherein a request is made by petitioner seeking transfer of khata pertaining to petition land bearing survey number 81 measuring 2 acre, totally measuring 5 acre 36 kuntas, situated at so and so so and so. Facts leading to the case are as under. The petition land originally was owned by one Srimati C.K. Shantabai.
No, originally. And she sold to my father.
He said Shantabai sold 2 acres of land in favor of petitioner's father. Under registration sale dated 19/5/1964.
Yes, madam.
Petitioner's father, namely Guddappa's name, was duly mutated to RTC.
In the column number 12.
In column number 12, however, the transfer of title was not reflected in column number 9.
9.
After the death of petitioner's father, it appears petitioner approached second respondent Tashildar by tendering a detailed representation, annexing a copy of sale deed.
Yes.
Certified copy of sale deed
And also RTCs.
and RTCs. Though this representation is dated 26/10/2017 now,
Yes, my lord.
the second respondent Tashildar has failed to act on the representation dated 26/10/2017. Next paragraph. Petitioner is tracing title through his father, who has purchased 2 acres of land in survey number so and so measuring, totally measuring 5 acres. If petitioner's father has acquired title based on a registered sale deed, second respondent Tashildar is bound to take cognizance of the sale deed and pass appropriate orders and effect changes in the khata aligning with the conveyance as reflected in the registered sale deed. Case on hand clearly reflects complete laxness on the part of second respondent Tashildar. Next, at this juncture, Leonard AGA submits that change of khata beyond 2007 is vested with assistant commissioner. This court is not inclined to accede to the said argument. Sale deed is of the year 1964 and the appropriate authority to consider change of khata is clearly vested with the second respondent Tashildar. Even if on administrative side is required to seek permission, there shall be no impediment for second respondent Tashildar to seek permission from Assistant Commissioner and pass appropriate orders strictly adhering to the sale deed obtained by petitioner's father and also mandate provided under section 128 and 129 of Karnataka Land Revenue Act. Petitioner petitioner is tracing title through his father who obtained sale deed in 1964. Therefore, he has a legal right to seek change of khata in his favor in respect of 2 acres of land. Second respondent, Tahsildar, is equally obligated to consider the representation submitted petitioner way back in 2017. This is a fit case for a mandamus slice. Accordingly, writ petition is allowed. Second respondent, Tahsildar, shall forthwith consider the representation dated 26/10/2017, evidence at Annexure A, and shall pass appropriate orders and ensure that petitioner's name is mutated to the RTC in petition land bearing survey number 81 to an extent of 2 acres, totally measuring out of 5 acres, 36 quintas. This exercise shall be accomplished within a period of 3 months. 3 months.
Great.
From the date of receipt of order.
Till that I may not be dispossessed, my lords.
32.
The petition, my lord, is to, my lord, consider my representation, my lord, at annexure G. Lord, an appeal, my lord, under rule 108, my lord, D is pending before the assistant commissioner from my lord last 3 years. Lord, my appeal is not being heard by my lord, the assistant commissioner. Earlier, my lord, I approached this honorable court, my lord, annexure wide, annexure E, page number 41. Lord, kindly come to page number 41, my lord.
What is this representation submitted to Assistant Commissioner?
Lord, my appeal, my lord, under rule 108K, 108,
It's kept pending.
kept pending, my lord.
Property cost in usage have to full corporation.
That,
So they have to get the documents from the corporation.
for 5 years.
It's already posted for orders. Only thing is the third time the
Yavaginda, when it is posted for orders? What is the date of appeal?
2020, my lord, 25/7/2022 was the last hearing, my lord. 22/7/2000.
You need 2 years to ascertain. Huh? Henry.
change of office,
2 ವರ್ಷದಲ್ಲಿ ಒಂದು ದಾವಾನ ಮುಗಿಸ್ಬೋದಲ್ರಿ?
change of
Direct.
Yes.
6 months,
Alas, 3 months.
3 months, posted for orders, 3 months. Caption petition is filed. Feeling aggrieved by inaction on the part of third respondent Assistant Commissioner in not deciding the appeal pending before the appeal filed in RA number
RA number LND CR1
in appeal number LND CR
1
01
22 23.
colon 2022-23 as per Annexure H. Petitioner is aggrieved by inaction on the part of Assistant Commissioner in not disposing of the appeal initiated under Rule 108 small d of Karnataka Land Revenue Rules. Learned AG on instruction submits next paragraph. That since Assistant Commissioner needs some information from
corporation.
Tumkur Corporation, he is not in a position to dispose of the appeal in accordance with law. This court is not inclined to accede to the said argument. It is stated across bar that this matter is posted for orders in 2022. And Assistant Commissioner is yet to dispose of the appeal on merits. Case on hand clearly reflects complete laxness on the part of second respondent, Assistant Commissioner. These proceedings under the provisions of Land Revenue Act are summary proceedings, and the revenue authorities have to ensure that these appeals are decided summarily at the earliest. The revenue authorities, under the garb of securing information, cannot keep these appeals pending indefinitely. if such a recourse is accepted and permitted, that would seriously prejudice the rights of the citizens, and they would be left remediless. Therefore, this is a fit case where a mandamus lies. For the foregoing reason, this court passes the following order. The petition is allowed. Third is Foreign Testing Commissioner. He is hereby directed to dispose of the appeal on merits within a period of 2 months from the date of the sit of order.
Lord,
Extra time, ಸಾಯಂಕಾಲ ಕುಂತು ಮಾಡಂತ ಹೇಳ್ರಿ.
my lord, if my lord presiding officer, my lord, is changed, my lord, he has to re-hear the matter because my lord, it's already posted for order.
ಹಾಗಾದ್ರೆ 3 months.
3 months, ತೊಂದ್ರೆ ಇಲ್ಲ.
Shall dispose of the matter after notifying the parties and affording opportunity to address fresh
Date
arguments.
may be fixed, my lord, I'll directly appear, my lord, before.
Fresh arguments. ಕೆಳಗಡೆ ಬರ್ಕೊಡ್ರಿ. Since parties are reprinted by a council, petitioner without expecting further notice shall appear before third respondent testing commissioner on
Next.
date ಕೊಡ್ರಿ. 3 ಮಾಡಬೇಕು. 3-2. From there onwards, petitioner, third respondent shall ensure that the appeal is disposed of within a period of 3 months.
Please. Great.
Yes,
For the petitioners, please.
yes, Suvarna.
My lords, the challenges to the order of the deputy commissioner under Annexure Q, my lords, at page 52. My lords, the land, my lords, initially was in the name of one Sri Karyagowda and Basavegowda, my lords,
This is
jointly.
challenge- What are you challenging now?
Annexure Q, the order of the DC, my lords, for change in Kata.
Change of Kata.
Please, my lords, this has been in existence, my lords. The Kata is in our name, the mutation, the records of rights, index of.
Based on, your name is mutated based on?
My lords, my father, my lords, Putswami Gowda, who's by way of Pauti, my lords, entered into the.
So ancestral property according.
Please, my lords. They
And who-
claim to be, my lords, the legal heirs of this Basavegowda without providing a single document to that effect. After 60 years, this is the first objection that comes in.
Your father's name was found since 1960.
Please, my lords, I produced the 1968-69 itself, my lords.
And now suddenly
A.
they mutate a private respondent's name.
Please, my lords, 7 and 8.
Delete your name or jointly?
Jointly. This is basically a partition, my lords.
And this, who has passed this mutation? Revenue inspector or Tashildar? Who has certified?
Mutation, my lords, it's at page 20.
No, that is certified by whom?
ನಕಲು ಪತ್ರ ದಾಖಲಾತಿ ಅಂತಿದೆ KR.
Yes, Manjunath. Tashildar certify ಮಾಡಿದಾರಾ?
At the bottom. my lords,
ಏನಂತ?
says,
Based on what?
ಪೌತಿ ಅಂತ ಅವರೇ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಪೌತಿ ಅಂತ ಅವ್ರ ಹೆಸರು ಮುಟ್ಟ.
ಅವರೇ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಅವ್ರ ಅನ್ಸಿಸ್ಟರ್ ಹೆಸರೇ ಇಲ್ಲ ಯಾವಾಗ್ಲೂ.
My lords, initially it was with Kaligowda and Basavegowda jointly. After that, it came in the name of Putswami Gowda and then by Pauti. That is written, my lords, recorded also at the bottom. Typed copy.
Who is your ancestor? What's his name?
My lords, Putswami Gowda, who's our father, my lords.
Father of petitioners.
Please, my lords.
His name was mutated when way back in 1960,
68, 69, my lords.
after death of his father.
Please, my lords.
Your grandfather's name was also found in
Please,
this
my
part?
lords.
Are they related? Are they cousins to you?
My lords, they claim, but we are disputing that. They have not produced any document to say that they are legal heirs of
All right,
so and so.
They have to approach civil court and. ಏನಂತ ಬರೀತಾರೆ ಏನಂತ? ಅಲ್ಲ ಪೌತಿ ವಾರಸ್ ಮಾಡಕ್ಕೆ ಫಸ್ಟ್ ಅವ್ರು ಇರ್ಬೇಕಲ್ಲ ಅವ್ರ ಹೆಸರು. Their name was there.
Their name was there. That's how my father has legally come in, my lords.
No, their ancestor name was there.
Their ancestor name, my lords, they claim to be legal heirs of this Basavegowda, but no document to that effect is produced even till date. Either before the
And,
AP or DC.
how Basavegowda is related to Kalegowda?
They are brothers, my lords.
Puttaswamy.
My lords, Kalegowda and Basavegowda are brothers. They were jointly in my lords owning the property. Thereafter, by way of Pauti, Kalegowda's son, my lords, Puttaswamy Gowda got it, my lords.
There's no family tree, Suvarna.
My lords, I have produced the family tree.
ಎಲ್ಲಿದೆ?
So far as the petitioners are concerned, it's at page 32.
30?
2, please, my lords. although it commences from Puttaswamy Gowda's.
ಎಲ್ಲಿ ಇವರು ಪ್ರೈವೇಟ್ ರೆಸ್ಪಾಂಡೆನ್ಸ್ ಎಲ್ಲಿ ಬರ್ತಾರೆ?
They are not here, my lords.
ಬೆಟ್ಟೇಗೌಡ ಹಿರೇಗೌಡ ಯಾರು ಅವರು?
They are unknown to us, my lords.
No, all right. You admit that Kalegowda and Basavegowda's both names were appearing.
Initially, yes, my lords.
Now Basavegowda is full brother of Kalegowda.
Please, my lords.
Ya Kalegowda?
My lords, Kalegowda is the son of father of Puttaswamy Gowda, who is our grandfather.
Oh, again it is repeated. Adu
Please, my
Kalegowda.
lords. My
He
lords,
is the grandson now.
please, my lords. The same names keep on repeating. my
So
lords.
that your grandfather Kalegowda has one brother by name Basavegowda.
Please, my lords. Now, these respondent numbers 7 and 8 claim to be the legal heirs of Basavai Gowda without a single document produced. 60 years have passed by.
Barkodri. Petitioner, counsel for petitioner submits that their grandfather Kalegowda was the absolute owner. And after his death, first petitioner's father Puttaswamy Gowda's name was mutated way back in 1960. Private respondents are asserting to be legal heirs of one Basavai Gowda, whom they allege to be brother of petitioner's grandfather Kalegowda. The relations are in dispute. RTC all along have been reflected in petitioner's ancestor's name right from 1960. Authorities, in absence of any document to substantiate that the private respondents have acquired right under 128, based on a mere vardi, have directed to jointly mutate the name of private respondents along with petitioners. This order is confirmed by Assistant Commissioner and
My
Deputy
lords, Assistant Commissioner order was in my favor. The
This
DC
order-
has reversed the
Though
order.
this mutation was set aside by Assistant Commissioner, third respondent Assistant Commissioner, second respondent Deputy Commissioner has allowed the revision and the order of the Assistant Commissioner is set aside. Prima facie, this court is of the view that Deputy Commissioner ought to have relegated private respondents 7 and 8 to seek to substantiate the rights of the property by approaching the competent civil court. RTC records are all along maintained in petitioner's ancestor's name. Therefore, mutation on the premises that respondent 7 and 8, that petition properties are ancestral properties of respondent 7 and 8 is one without jurisdiction. Matter requires consideration. Accordingly, what has to be said? Order of the Deputy
My
Commissioner.
lords, Annexure Q alone. my lords.
Order of the Deputy
Please,
Commissioner
my lords.
dated so and so as per annexure so and so is stayed until further orders. Letter SCGP is directed to accept notice to respondents 1 to 6. Is issue emergency notice to respondents 7 and 8.
I'm grateful.
Next.
I am for petitioners in this case, my lord. The husband of the first petitioner and father-in-law of the second petitioners were granted occupancy right by the land tribunal. Accordingly, form number 10 was issued. The assistant commissioner has directed to mutate their names. Accordingly, the mutation was effected and their names were found in
Yarik grant agide ಅದು?
ROR. The husband of the first petitioner,
Land Tribunal has granted.
land tribunal has granted.
ಈಗ
I have
what is the
produced the
order
order
now?
copy.
ಏನು
Annexure.
why?
Annexure B and C. Now I wanted to convert the land for, I have applied for conversion. For that, no objection certificates were required. I filed an application before the Tahsildar stating that non-tenancy certificate may be issued.
15 years ಆಗಿಬಿಟ್ಟಿದ್ಯಾ?
ಆಗಿದೆ ಗ್ರಾಂಟ್ ಆಗಿದೆ 82 ದಲ್ಲಿ.
ಆಯ್ತಲ್ಲ ಅದು ನಾನ್ ಎಲಿನೇಷನ್
ಅದು ಕೊಡ್ಬೋದು. ಏನಾಯ್ತು?
ಭೂ ಪರಿವರ್ತನೆ ಮತ್ತು
ಹ್ಮ್
ಮಾರಾಟ ಮಾಡಲು ಅನುಮತಿ ಕೇಳಿ ನಿರಪೇಕ್ಷಣ ವಸೂಲು ಕೇಳಿದರೆ ಕನ್ವರ್ಷನ್ ಮಾಡಬಹುದು. ಇಂಡಿವಿಜುವಲ್
ಅಲ್ಲ ಕನ್ವರ್ಜನ್ ಡೆಪ್ಟಿ ಕಮಿಷನರ್ ಕೊಡ್ಬೇಕು, ಪರ್ಮಿಷನ್ ಟು ಎಲಿನೇಟ್ ತಹಸೀಲ್ದಾರ್ ಕೊಡ್ತಾರೆ.
ಅಲ್ಲ ಆಯ್ತು, ಬಟ್ ಈಗ ಅನೆಕ್ಸರ್ ಎ ಕೊಟ್ಟಿರೋದು ಅದು ಅನೆಕ್ಸರ್ ಎ ಎಂಡಾರ್ಸ್ಮೆಂಟ್ ಆಸ್ ಇಶ್ಯೂಡ್ ಬೈ ಸೇಯಿಂಗ್ ದಟ್ assistant commissioner has directed to mutate the names. It is mutated. Therefore, I am not issuing. Your lordship may kindly see annexure E.
ಏನು ಅಸಿಸ್ಟೆಂಟ್ ಕಮಿಷನರ್ has mutated?
Assistant Commissioner has directed to mutate the names of the LRs of these persons.
Hmm.
It is already mutated. Therefore, this non-tenancy certificate cannot be granted.
ಏನ್ reason madam?
Annexure A nodi. It has
Make individual for
ಪರ್ಮಿಷನ್
permission.
ಇಲ್ರಿ ಅದು ಅಲ್ಲಲ್ಲ ಇಂಡಿವಿಜುವಲ್ ಬರಲ್ಲ.
ಬೇರೆ ಬೇರೆ ಹಾಕ್ಬೇಕು ಅವ್ರು ಎರಡು ಒಟ್ಟಿಗೆ ಕ್ಲಬ್ ಮಾಡಿ ಹಾಕಿದ್ದಾರೆ.
ಆಯ್ತು ಕನ್ವರ್ಜನ್ ಬೇಡ, ನೀವು ನಾನ್ ಎಲಿನೇಷನ್ ಪೀರಿಯಡ್ ಮುಗಿದಿದೆ,
ಅದಾದ್ರೂ
ಪರ್ಮಿಷನ್ ಟು
ಎರಡು ಎಲ್ಲ ಕ್ಲಬ್
Permi-
ಮಾಡಿ
ಒಂದೇ ಇದ್ರಲ್ಲಿ ಕೇಳಿದ್ರು. ಆಯ್ತು ಕೇಳಿದ್ರು, ನೀವು ಯಾವ್ದು ಕೊಡ್ಬೋದಾಗಿತ್ತಲ್ಲ. Pass fresh orders. That too within 4 weeks. You look into the date of grant of occupancy rights, issuance of form number 10. If a non-linear period of 15 years is over, he is bound to grant permission. ಅಷ್ಟೇ. ನೀವು ಅದು ಎರಡು ಕನ್ವರ್ಜನ್ ಆರ್ಡರ್, ಬಟ್ the Tahsildar has passed this order, no?
Tahsildar has passed the endorsement.
Only jurisdiction to consider ಅದೇ ರೈತಾವ ಅಂತಾರಲ್ಲ, ಏನಂತಾರ ನಮ್ ಕಡೆ?
Non-tenancy certificate.
ನಮ್ ಕಡೆ
ಗೇಣಿ ರಹಿತ ಪ್ರಮಾಣ ಪತ್ರ.
ರೈತಾವ ಅಂತಾರೆ ಈ ಕಡೆ. Belgaum district they say ರೈತಾವ.
Correct. ರೈತವ. Non-tenancy.
Non-tenants. ಬರ್ಕೊಡ್ರಿ. Petitioner is aggrieved. Petitioners are aggrieved by the impugned endorsement dated 29/11/2024 issued by third respondent as per Annexure A. Therefore, the said order is under challenge. Consequently, mandamus is sought to issue no tenancy certificate by considering repetition dated 21/11/2024. Facts leading to the case are as under. ಏನಿದು ಇಬ್ರು ಬೇರೆ ಬೇರೆ ಗ್ರಾಂಟಾ?
ಹೌದೌದು, ಸೆಪರೇಟ್ ಗ್ರಾಂಟ್ ಮಾಡಿದ್ರು. Annexure B ಪ್ರಕಾರ
ಅವ್ರಿಬ್ರು ಹಸ್ಬೆಂಡ್ ಗೆ ಸಪರೇಟ್ ಗ್ರಾಂಟ್ ಆಗಿದೆ.
ಅಲ್ಲ, ಒಬ್ರು ಹಸ್ಬೆಂಡ್, ಫಸ್ಟ್ ಪಿಟಿಷನರ್ಸ್ ಹಸ್ಬೆಂಡ್,
ಹಾ.
ಸೆಕೆಂಡ್ ಪಿಟಿಷನರ್ಸ್ ಫಾದರ್ ಇನ್ ಲಾ.
ಫಾದರ್-ಇನ್-ಲಾ.
ಫಾದರ್.
The first petitioner's husband asserting to be tenant filed form number 7 claiming occupancy rights. Similarly, second petitioner's father-in-law filed form number 7 taking grant of occupancy rights. Land Tribunal, after due inquiry, has conferred occupancy rights. Common order adu allu. Land Tribunal common order is separate idea.
ಇಲ್ಲ, ಕಾಮನ್ ಆರ್ಡರ್.
Wide common order dated
25/5/82.
25/5/82, which is evidenced at Annexure B. Third respondent Tahsildar has accordingly issued form number 10.
C and D.
Which is evidenced at Annexure C and D. Next para, both the petitioners intend to sell the property. And therefore,
convert.
And therefore, both the petitioners together are
Convert and also for selling the land.
ಅದು ಎರಡು unless both the petitioners have submitted a single representation seeking conversion and also permission to sell.
Alienate.
Though petitioners would not have submitted an application seeking conversion before Tahsildar. However, the third respondent Tahsildar is the competent authority to issue no tenancy certificate by taking note of the grant of by taking note of date of the grant of occupancy rights followed by issuance of form number 10. Form number 10 admittedly is issued way back in 1982 na idu.
ಇಲ್ಲ 6/7/2023.
Form number 10.
ಹೌದು.
So ಈಗ from that land
From the date
tribunal
of
order,
grant ಇಂದಾನೆ ಬರ.
it would relate back to date
ಹೌದು.
of, though form number 10 is issued in 2023, the fact that occupancy rights were granted in 1982, petitioners, both the petitioners, separate quadri, both the petitioners are entitled to seek no tenancy certificate as non-alienation clause indicated in form number 10 relates back to date of grant of occupancy rights, which is of the year 1982. Next, in that view of the matter, impugned endorsement is not sustainable. Accordingly, this court passes the following order. Writ petition is allowed. The impugned endorsement is hereby quashed. Third respondent Tahsildar is hereby directed to reconsider the representation submitted by petitioners. And after verifying the records, shall issue no tenancy certificate, individual no tenancy certificate to both the petitioners in accordance with law by considering the representation dated 21/11/2024. Next, liberty is reserved to petitioners to apply for conversion before deputy commissioner in accordance with.
Much. ಯಾರ ಮುಂದೆ
ಕಂಪ್ಯೂಟರ್ ಫೀಡ್ ಆಗುತ್ತೆ.
ಹೌದಾ? ಅದು ಏನ್ ಬರ್ದಿದ್ದಾರೆ?
ಆಯ್ತು.
ಅದಲ್ಲ ಅದ್ರ ಮೇಲೆ ಬರ್ತಾರೆ.
Separately.
Third respondent Tahsildar is directed to reconsider. Second. Representation, by considering fresh representation.
Oh.
That would be tendered by petitioners individually.
Individual. Date maybe.
Huh? ಅಲ್ಲಿಂದ ಅದು this exercise shall be accomplished by third respondent Tahsildar within a period of 4 weeks from the date of receipt of fresh representation. Yes.
Much. Challenging the land tribunal order passed under order 7A, annexure 24, page 24, annexure E. The order passed against the dead person, your lordship. The ಭೂಮಾಲೀಕರ ಹೆಸರು ಶ್ರೀನಿವಾಸ್ ಅತ್ವಾರ್. The annexure A, your lordship.
Take notice, 2019 order.
Kindly.
Leonard AG is directed to accept notice to 123.
Yeah, status quo, your lordship, they muted the name in the RTC because your lordship.
Issue emergency notice to respondents 4 and 5. Really this matter premiering on the
Your lordship,
court.
my father died in the year 74.
We don't. I'll order.
Kindly.
Next. Password.
Malad, 36, please.
Yes, Etna.
Please. Malad, this is cancellation of the scheduled property which was granted in the name of the petitioner, Malad.
Cancellation of?
Cancellation of the grant made in favor of the petitioner, Malad.
What is the date of the order?
The date of the order is at annexure J, Malad. Passed by the DC Chikkamangaluru. Petitioner was unauthorized occupation of the scheduled property from 1992, Malad.
Why it's cancelled now?
Considering the eligibility.
Why grant is cancelled? Mr. Etna.
At annexure J, Malad, the contention is that there is no.
Wait, let government advocate sit. ಅಲ್ಲ ಕಮಿಟಿ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಇದೆಯಾ ಬಟ್ಟು?
Yes, madam. Proceedings are here.
ಬಿಟ್ರೆ ಏನ್ ಮಾಡ್ಬೇಕೀಗ ಮೇಡಮ್? ಅಂದ್ರೆ ಏನ್ರಿ ಈಗ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಎಲ್ಲ ಆಗಿ ಕೊಟ್ಟು ನೀವು ಅಲ್ಲಿ ನಿಮ್ಮ ರೆಕಾರ್ಡ್ ಅಲ್ಲಿ ರಿಜಿಸ್ಟರ್ ಅಲ್ಲಿ ಅಪ್ಲಿಕೇಶನ್ ಇರ್ಲಿಲ್ಲ ಆದ್ರೆ ಏನು? ಯು ವಾಂಟ್ ಟು ರಿಕಾಲ್ ದಿ ಗ್ರಾಂಟ್ಸ್? ಇಟ್ ಬಿಕಮ್ಸ್ seek instruction. Leonard AG is directed to accept notice to response 1 to 4. Really this matter preliminary on short date court.
Interior order, madam, they are disturbing my position.
Madbadri, madam.
Please.
In the meanwhile, the authorities are directed not to take precipitative action. Next.
Please.
We are for the petitioner, my lord. My lord, I'm an ex-serviceman, my lord. I had filed an application for grant of land before the deputy commissioner, my lord, on 3/1/2023, my lord. They have done a spot measure, everything, my lord, and then they come back saying rejecting my application, my lord.
On what ground?
Saying that the land is not available. Aggrieved by this, my lord, I had filed a writ petition, my lord. It is in page number 102, annexure G. The learned single judge had directed the respondent number 2 to grant him agricultural land in survey number 218 Channagondahalli, Vastare Hobli. My lord, even after this, my lord, they have not complied with the orders of this writ petition, my lord, and I have filed a contempt petition against this, my lord. And in this contempt petition, my lord, just to avoid the contempt petition, they have filed the order, my lord, it's in annexure Q, my lord, page number 167.
Thereby rejecting your application.
My lord, they have, instead of granting me an agricultural land, my lord, they have granted a site 60 by 40 in a neighboring taluk, my lord. And in this agreement, in this order, my lord, there is no mention of survey number 218 as to why that said land is not available. I have also produced RTCs, my lord. It is in annexure M.
Let
page-
it seek instruction, madam. Suit edike? ಅದು ಬೇರೆ. They are seeking grant. Workodi, Leonard SGP is directed to accept notice to 1 to 5. Leonard SGP shall seek instruction in the matter. Listed in B group. After completion.
I appear for petitioner counsel, my lord. Based on the sale deed of the year 1942 and 54, the petitioner father purchased the land and petitioner name was entered into revenue records by the order of the assistant commissioner. Assistant commissioner order is at annexure F, page 55. Operative portion, my lord, at page 59. ಮೇಲ್ಮನವಿ ಹೊನ್ನಾಳಿ ತಾಲೂಕು ಕಸ್ಬಾ ಹೋಬಳಿ
It's your, who purchased this property, your father?
petitioner father purchased in 1942 and 54. Based on that, the name of the vendor was exhibited in the columns and RTC was changed. And based on that, he filed an application before the assistant commissioner. Assistant commissioner passed order as per annexure F and mutated in the name of the petitioner based on the sale deed. And the respondent preferred a
Yaru, respondent yaru.
legal heirs of my vendor.
Whether it is related to your vendor?
Yeah, no, legal heirs of vendor.
Vendor. Now they are challenging it.
They challenge, they made a partition after the sale deed.
After the sale deed.
They made a Jumani
Nim sale deed yavaga? What is the date of your sale deed?
1942 and 54.
Two sale deeds.
Two sale deed for 2 diamonds for 2 acre 20 guntas and 2 acre 20.
Same survey number.
Sales, different survey number.
Different survey number. Now the legal heirs of your vendor get the land partition.
Partition. But however, the partition and document position is still with me only. Based on that, assistant commission passed an order based on the sale deeds on 2020.
ನಿಮ್ ತಂದೆಯವ್ರ ಹೆಸರು ಮುಟ್ಟೆಟ್ ಆಗ್ಬಿಟ್ಟಿತ್ತ based on sale deed ಏನಾಗ್ಲಿಲ್ಲ.
ಆಗಿಲ್ಲ.
Oh, that's why they have taken advantage.
They taken advantage. But considering all these aspects, assistant commission passed an
But
order.
that there is a sale deed and your
He has
entitled.
passed an order.
What deputy commissioner has done now?
Now, then in the first order, based on this single order of the assistant commissioner, 2 revision petitions were filed before the deputy commissioner, a different respondent. The first order is at annexure K, page 81, in which the deputy commissioner said, ಹೊನ್ನಾಳಿ ತಾಲೂಕು ಕಸ್ಬಾ ಹೋಬಳಿ ಕೋಟೆಮಲ್ಲೂರು ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 136 5 ಎಕರೆ 4 ಗುಂಟೆ ಜಮೀನಿಗೆ ಸಂಬಂಧಿಸಿದ ವಿವಾದವು ಸಿವಿಲ್ ಸ್ವರೂಪದ್ದಾಗಿದ್ದು ಈಗಾಗಲೇ OS ನಂಬರ್ 225/22 and OS ನಂಬರ್ 245/23 ರಂತೆ ಪ್ರಧಾನ ಸಿವಿಲ್ ನ್ಯಾಯಾಲಯ ಹೊನ್ನಾಳಿಯಲ್ಲಿ ದಾವಾ ದಾಖಲಾಗಿದ್ದು ವಿಚಾರಣಾ ಹಂತದಲ್ಲಿರುವ ಉಭಯ ಪಕ್ಷಗಾರರು ಸಿವಿಲ್ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಪರಿಹಾರ ಕಂಡುಕೊಳ್ಳಲು ಸೂಚಿಸುತ್ತಾ ಮೇಲ್ಮನವಿಯನ್ನು ವಿಲೇ ಮಾಡಿದೆ. Assistant commissioner order, when it has come for revision before the DC stated, because the pendency of the civil suit, you have to adjudicate the issues before.
Who has filed the suit now?
My lord,
Suit ಯಾರು ಹಾಕಿದಾರು?
they have filed the suit.
ಅವರೇ suit ಹಾಕಿದಾರಾ? Challenging.
They have filed the suit. We have also filed the suit. There are 2 cross suits, my lord. And another
ಅವ್ರ suit ಏನಕ್ಕೆ ಹಾಕಿದಾರಾ? What prayer they have sought in their suit?
suit for injunction.
And they have not challenged your sale deed.
They have not challenged my sale deed.
ನಿಮ್ದು ಯಾಕೆ self golo? Who advised your client?
My lord,
Who advised your client to file a suit?
no, he has also filed a suit for injunction.
New injunction ಹಾಕಿ.
Yeah, injunction.
Based on those sale deeds.
Based on sale. My lord, what happened?
Deputy commissioner has relegated.
Deputy commission first order said, okay, you approach the civil court because there are 2. And some other respondent of the same petition, they filed another revision. In another division, annexure A, deputy commissioner has not only passed an order of cancellation of the entries, but also he recalled his earlier order. Once after passing an order, he is a functus officio. Page, my lord, page
So
20,
against Assistant Commissioner order, two revisions were preferred.
two revisions for
Which is that, the other one, annexure?
annexure A, page 24.
Innondu?
Annexure K.
K na?
ಇದೆ.
Annexure K.
Annexure K.
Just day to day ನೀವು examine ಮಾಡ್ರಿ ಮಂಜು. They just lawlessness ಏನ್ gravity ಇದೆ ಅಂತ ಗೊತ್ತಾಗ್ತದೆ. ಬರ್ಕೊಡ್ರಿ. Had the Learned Senior Council appearing for petitioner. The Learned Senior Council referring to Annexure A and Annexure K has brought to the notice of this court that second respondent Deputy Commissioner has passed two conflicting orders. While under Annexure K, he has relegated the parties to work out their remedies in the pending civil suits. In Annexure A, which was a revision by some other aggrieved parties before the Assistant Commissioner, he has not only entertained a revision by setting aside the Assistant Commissioner order, but in the impugned order while Annexure A, he has also recalled the order part under 136(3) in another revision while Annexure K. Having noticed these significant details, this court is called upon to examine the core issue as to whether private respondents whose ancestors have sold these petition lands to petitioner's father way back in
42 and 54.
1942 and 54,
Annexure B1 and B2 is held deed copy.
which is evidenced at Annexure B,
Annexure B and B1.
B1 can agitate their rights in mutation proceedings. Without examining the scope of inquiry, the second respondent Deputy Commissioner has ordered to delete the name of petitioner whose ancestors have acquired title through registered documents. Matter therefore requires consideration. Accordingly, the impugned order passed by second respondent Deputy Commissioner while Annexure A is stayed until further orders. Learned CP is directed to accept notice to 1 to 5, issue emergent notice to respondent 6 to 13. Yes.
Petitioner is challenging my lord the order passed by the Deputy Commissioner.
Huh?
Order passed by the Deputy Commissioner. My lord, the land bearing survey number 79/3, measuring my lord 2 acres, 4 gunta. This property, my lord, is ancestral property which was partitioned in the year 1958 between.
1324 though.
Please.
Order.
Please, 1320.
Take notice.
My lord, now, there was a partition in the 1958.
13 order ನಮ್ಗೆ ಗೊತ್ತಿಲ್ಲ ಏನಾಗಿದೆ we have to serve private Kalyan. What is this?
ಏನಾಗ್ತಿದೆ ಅಂದ್ರೆ ಈಗ
ಏನ್ ನಮ್ಗೆ ಗೊತ್ತಿಲ್ಲ ಅಲ್ಲಿ ಏನಾಗಿದೆ ಅಂತ ಅವ್ರು ಬಂದೇ ಹೇಳ್ಬೇಕೀಗ.
ಸ್ಟೇಟಸ್ ಅಂತ ಮಾಡಿದ್ರು.
ನಾನು ಮಾಡಲ್ಲ.
With regard to mutation entries.
Stay ಕೊಡ್ತೀನಿ. You show me what's there on the ground. You don't get status quo order in my court. Status quo ಇಲ್ಲ. Learned.
ಏನಾಗಿದೆ ಅಂದ್ರೆ ಈಗ subsequently, my lord, the
ನೀವು ಬಿಡಲ್ಲ ಬಿಡಿ.
ಅಲ್ಲ ಏನಿಲ್ಲ, ಚಿಕ್ಕಣ್ಣ son has filed a suit, my lord, without making my lord the petitioner as party. He makes only his mother as one of the defendant, files a suit. Now, my lord, the Deputy Commissioner records a finding that there is a delay of 24 and 25 years in challenging the mutation entry. If that was the ground, my lord, on which, my lord, the revision is allowed, the Deputy Commissioner ought to have remitted the matter back to the Assistant Commissioner. Instead, he allows the revision.
Sir, let us see. ಅದಕ್ಕೆ emergent notice ತಗೊಳ್ಳಿ ಮತ್ತೆ preliminary ಗೆ ಹಾಕ್ತೀನಿ.
Please, please.
I'll not list it in big. But learned AGA accept notice to 1 to 5, issue emergent notice to 6 and 7. Really this matter in preliminary on. After 15 days.
So I may also be permitted to, so.
Take out handsome. Simultaneously, petitioner is also permitted to serve notice by way of hand summons returnable by so and so date.
Much.
Yes, Rupesh.
Paper. Annexure J, page number 73. Order passed by the Honorable Court in earlier round of litigation. Page number 64, para 16. From para 16, I will read, madam. It's relevant. Page number 64.
ಏನದು?
Adರಲ್ಲಿ earlier round of litigation ನಲ್ಲಿ this Honorable Court held that my father has purchased this property under the sale deed. Wherefore, quashed the order passed by the Assistant Commissioner and Deputy Commissioner, both and directed to mutate my name. When it come to order portion, my lord. Page number 65.
You tell me the facts.
My lord, the the petitioners, the first petitioner here in my lord.
Earlier order ಇದು.
Earlier order, ಹೌದು ಇದೆ ಅದಕ್ಕೇನೆ ಪ್ಯಾರಾ 16 ಅದಲ್ಲ ಏನಕ್ಕೆ ಅಂತ ಹೇಳ್ತೀನಿ. ವೈ ಪೇಜ್ ನಂಬರ್ 64 ಬಂದ್ರೆ ಪ್ಯಾರಾ 16 ಇಂದ I will read, my lord. In my view, since there is a registered sale deed executed by Borlingegoda, the father-in-law of the respondent number 4 herein, here also fourth respondent, my lord. Favor of the petition number 1, the respondent 4 cannot object the entry of the petitioner name in the revenue records unless the sale deed is declared as to be illegal. It is also noted here that the father-in-law of the respondent number 4, Borlingegoda, did not change the revenue entries that had been made in favor of the Chikka Hanumegoda in whose for he had created usufructory mortgage. It is also not dispute that the name of the Borlingegoda was never entered in the revenue record.
Your writ petition is allowed.
Allowed, my lord, and there is a specific direction to mutate my name.
Correct.
ಈಗ ನೆಕ್ಸ್ಟ್ ಏನ್ ಮಾಡ್ತಾರೆ ವೈಡ್ ಅನಕ್ಷರ್ ಕೆ ನಲ್ಲಿ ಅಸಿಸ್ಟೆಂಟ್ ಕಮಿಷನರ್ ನನ್ನ ಹೆಸರು ಮಾಡಿ ಅಂತ ಮಾಡ್ತಾರೆ. ಆನ್ ದಿ ಮೀನ್ ಟೈಮ್ ಅನಕ್ಷರ್ ಎಲ್ ಮೇಲೆ ಪೇಜ್ ನಂಬರ್ 69 ಈ ಫೋರ್ತ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ಏನ್ ಮಾಡ್ತಾರೆ, ಅವ್ರ ಬ್ರದರ್ಗೆನೆ ಮಾರಾಟ ಮಾಡ್ಬಿಡ್ತಾರೆ ಸೇಲ್ ಡೀಡ್ ನ. ಸೇಲ್ ಡೀಡ್ ಮೇಲೆ ಅವ್ರ ಹೆಸರು ಅವ್ರಿಗೆ ಮ್ಯೂಟೇಟ್ ಮಾಡ್ಬಿಟ್ಟು ಸೇಲ್ ಡೀಡ್ ಆಗಿದೆ ನಾನು ಮಾಡಕ್ ಬರಲ್ಲ ಅಂತ ಈಗ ನಾವು ಅಸಿಸ್ಟೆಂಟ್ ಕಮಿಷನರ್ ಸೇಮ್ ವೈಡ್ ಅನಕ್ಷರ್ ಏನ್
ಏನ್ 81 ಏನ್ ಕನ್ಫ್ಯೂಷನ್ ರೀ ಇವ್ರಿಗೆ? ಹೈಕೋರ್ಟ್ ಆರ್ಡರ್ ಕಂಪ್ಲೈ ಮಾಡಕ್ ಬರಲ್ವಾ? ಯು ಕಾಂಟ್ ರೀಡ್ ಹೈಕೋರ್ಟ್ ಆರ್ಡರ್.
ಶೆಲ್ ಅಂತಾನೆ ಇದೆ, ಅದು ಅಲ್ದಾನೆ ಮೇಲೆ ಪೇಜ್ ನಂಬರ್ 65 ಪ್ಯಾರಾ 20 ಮೇ ರೀಡ್ ಆರ್ಡರ್ ಆಫ್ ದ ಹೈಕೋರ್ಟ್.
ಯು ಕೀಪ್ ಹಿಮ್ ಪ್ರೆಸೆಂಟ್ ರೀ. ಟೇಕ್ ನೋಟಿಸ್ ಅಂಡ್ ಕೀಪ್ ಹಿಮ್ ಪ್ರೆಸೆಂಟ್. The impugned order wide annexure L
N ಮೇಲೆ ನಾವು
L is clearly found to be
N
is clearly found to be in blatant violation of directions issued by the coordinate bench evidenced at annexure J. Though this is brought to the notice of third respondent assistant commissioner,
yes ma'am.
Second respondent assistant commissioner, he has entertained an application tendered by fifth respondent, who is tracing right through sale deed executed by fourth respondent.
Yes, ma'am.
The case on hand depicts a very sorry state of affairs. This is a classic case where second respondent assistant commissioner is clearly found to be consciously and deliberately violating the directions issued by this court. Learned SCGP shall ensure his presence on the next date of hearing. Till then, the order under challenge for annexure N is stayed until further orders. Yaru?
ಅಲ್ಲ ಇದ್ರೂ ಕೂಡ ಸೇಲ್ ಡೀಡ್ ಇಸ್ ದೇರ್ ಇಸ್ ಅ ಫೈಂಡಿಂಗ್ ಕ್ಯಾಟಗರಿಕಲಿ ಫೈಂಡಿಂಗ್.
ಇಲ್ಲಿ 1970 ಸೇಲ್ ಡೀಡ್ ಇದೆ, ರಿಲೀಸ್ ಡೀಡ್ ಇದೆ. ಇವ್ರ ಹೆಸರು ಆಕ್ಚುಲಿ R4 ಗೆ ಕೋರ್ಟ್ ಕಳಿಸ್ರಿ ಅಂತ ಹೇಳಿದ್ದಾರೆ. He executes a sale deed and you again entertain. What R4 can't do, you have really helped R4 to get it done through R5. Yen mischievous. Issue emergency notice to respondents 4 and 5.
ಅದು ಸೂಟುನು ಆಮೇಲೆ ನಮ್ದು ರಿಟ್ ಡಿಸ್ಪೋಸ್ ಆದ್ಮೇಲೆ ಸೂಟು.
ಏನ್ ಮಾಡ್ಬೇಕ್ರಿ ಇವ್ರ ಮೇಲೆ? ಏನ್ ಮಾಡ್ಬೇಕು ಇವ್ರ ಮೇಲೆಲ್ಲ? I don't know. Bar has to enlighten this court now.
Date may be fixed.
Yes. Presence is there. List it in preliminary on so and so date. Keep him present. Ya uru?
Pandupura subdivision.
Ask him
Mandya
to come.
district.
Highway. Barakali, no. 41.
Karnataka ladder.
Adisa Rupesh, you should remind we'll direct deputy commissioner to hold an inquiry. He has violated high court order. Let us see on that day. Yes. Shivkumarappa.
79A.
Order.
16/2018 petitioner purchased the 3 guntas of lands.
2018 sale deed.
Yes.
Order yavagagide 79
27/1/2020.
after amendment. 21 alla.
27/1/2020.
7 na? July. ನೀವು ಅಪೀಲ್ ಹಾಕ್ಲಿಲ್ವಾ?
ಅದು ಕೋವಿಡ್ ಸಿಚುವೇಶನ್ ಅಲ್ಲಿ
ಕೋವಿಡ್ ಮುಗಿತಲ್ರಿ ಈಗ ಮತ್ತೆ ಯಾವ್ದೋ ಬೇರೆ ಬರ್ತಾ ಇದೆ ಈಗ.
ಆಮೇಲೆ ಅಪೀಲ್ ಆಫ್ಟರ್ ಅಮೆಂಡ್ಮೆಂಟ್
ಯಾವ್ದೋ ಬೇರೆ ಬರ್ತಾ ಇದೆ ಈಗ.
ಅಲ್ಲ ಅಪೀಲ್ ಫೈಲ್ ಮಾಡಕ್ ಹೋಗಿ ಅವ್ರು ತಗೊಂಡಿಲ್ಲ ಸರ್. ಆಫ್ಟರ್ ಅಮೆಂಡ್ಮೆಂಟ್
Immediately you should have filed it here.
ರಿಟ್ ಪಿಟಿಷನ್ ಫೈಲ್ ಮಾಡಿದ್ವಿ ಸರ್. ಡೈರೆಕ್ಷನ್ ಕೊಡ್ತು ಅಬೇಟ್ ಮಾಡಿ ಅಂತ ಹೇಳಿ ಅನೆಕ್ಸರ್ ಜಿ
Page.
ಪೇಜ್ ನಂಬರ್ 31.
Oh, ಇದೆಯಾ?
ಲಾಸ್ಟ್ ಪ್ಯಾರಾ
ನೀವು ಅಪೀಲ್ ಬಿಫೋರ್ ಅಮೆಂಡ್ಮೆಂಟ್ ಹಾಕಿದ್ರೆ ನಾ ಆಫ್ಟರ್ ಅಮೆಂಡ್ಮೆಂಟ್ ಹಾಕಿದ್ರೆ.
ಆಫ್ಟರ್ ಅಮೆಂಡ್ಮೆಂಟ್.
ಡಿಲೇ ಎಷ್ಟಿತ್ತು ನಿಮ್ದು? 2019 ಆರ್ಡರಾ?
2020 ಆರ್ಡರ್ಸ್. 27/1/2020 ಆರ್ಡರ್.
ಕೊಡ್ರಿ. Petitioner is aggrieved by the order of Assistant Commissioner. First respondent Assistant Commissioner who has declared the sale deeds as null and void by invoking section 79A and 79B. Matter requires consideration since the records reveal that petitioner did make an attempt in challenging the order of the Assistant Commissioner. The appellate tribunal has declined to entertain the appeal on the ground that the proceedings concluded by first respondent Assistant Commissioner stand abated in view of section 13(1) alla of ordinance. 13(1) of the ordinance 2000. The act alla ಈಗ act ಆಗಿದೆಯಲ್ಲ ಅದು. Act 13(1) of ordinance 2020. Matter requires consideration accordingly. ಅದು ನೋಡಿ ಪ್ರೇಯರ್ ಏನ್ ಕೇಳಿದಾರೆ ನೋಡಿ. Stayed. Stay. Till next week. Yes.
For the counsel to respondent, my lord, review petition filed by the government, my lord, an order passed in 2015 for desilting the well and removing the encroachment. They themselves give an undertaking. They will remove the encroachment and desilt it. 20 lakhs is already sanctioned. That was the undertaking given to this honorable court, my lords. When a contempt petition is filed, my lords, then they file a review petition stating that, my lords, there is already an encroachment. So those encroachment is in their position and there is no well now. There is no public well. Therefore, review the order. It's in support of the encroachments, my lords. The review petition has been filed by the state. I will be most grateful because several rainy seasons came, my lord, then drought seasons came. Agriculturists could not benefit despite funds have been released. Because state is now wants to help the encroachers and protect them. And an unfortunate case in this case, your lordship's kind indulgence is really required to help the agriculturists. Please.
ಇದರ ಮೇಲೆ ಸ್ವಲ್ಪ ಇನ್ಕನ್ವೀನಿಯನ್ಸ್ ಇದೆ lordship.
But I think
I am not in station, your lordship.
ಅಲ್ಲಿ ಕೊಟ್ಟು ನೀವು appear for petitioner or respondent?
In one case I am responding, in one case I am petitioning.
Please inform the other side.
I inform ಮಾಡಿದೆ.
Yeah, inform ಮಾಡಿ.
Case number 4, my lords. SC was supposed to appear, my lords, due to some inconvenience is not able to appear, my lords, but passed over.
230 ನೋಡೋಣ. 230 ನೋಡೋಣ.
One match for admission, my lord. CMP tomorrow.
Thought.
ಫೈಲ್ ಕೂಡ ಕೊಟ್ಟಾಗ ಹೋಗ್ತು ತಾತನ ಕೈಲೇ ಕೊಟ್ಬಿಡ್ಬೇಕು ತಾನೆ ಮೆಮೋನ. ನನ್ನ ಹತ್ರ ಬಂದ್ರೆ ಇಲ್ಲ ಅಂದ್ರೆ ಅದೇ ನೀವು ನಮಗೆ ಮಾಹಿತಿ ಕೊಡ್ತೀರಾ? ನೀವು ಅದಕ್ಕೆ ನಾನು ಏನೋ ವ್ಯವಸ್ಥೆ ಮಾಡ್ಬೇಕು ಅದನ್ನು ಮಾಡಿದ್ರೆ ನಾವು ನಾನು ಪರ್ಟಿಕ್ಯುಲರ್
ಡೈಲಿ ಮಾಡುತ್ತೇನೆ, ಡೈಲಿ ಮಾಡುತ್ತೇನೆ.
ಜಾಸ್ತಿ ಆಗಿದೆ. ಪೂರ್ವ 6 ಶೇರ್ ಕೊಡ್ತೀವಿ, 2 ಶೇರ್ ಕೊಡ್ತೀವಿ, 2 ಶೇರ್ ಕೊಡ್ತೀವಿ. ಅದು ಕೂಡ ಒಂದಿದ್ದು ಲಾಭನೇ ಕೊಡ್ತೀವಿ. ನಾವು ಇದನ್ನ ಕೊಡ್ತೀವಿ, ಲಾಭದಲ್ಲೇ ಕೊಡೋಲ್ಲ, ಲಾಭ ಮಾಡ್ಕೊಂಡೇ ಕೊಡ್ತೇವೆ. ಎಂತ ಎಲ್ಲ ಯಾವ್ದು ಬುಕ್ ಹಾಕ್ತೀನಿ ಅವು ಇವತ್ತಿನ ನಿಮ್ಗೆ ಕೊಡೋದು. ಎಂಟ್ರಿ ಮಾಡಿದ್ರೆ ಮುಂದೆ ಸರ್
ಇಲ್ಲ ತಂದಿಲ್ಲ, ನಾನು ಅದಕ್ಕೆ ವೇಟ್ ಮಾಡ್ತೇನೆ.
ಎಲ್ಲಿ ಬಳಸ್ಬಿಟ್ಟು ಬರ್ಬೇಕು.
ಸ್ಟಾರ್ಟ್ ಮಾಡ್ತೀನಿ, ಸ್ಟಾರ್ಟ್ ಮಾಡ್ತೀನಿ.
ಮತ್ತೆ ಬ್ರಾಂಚ್
ಇಲ್ಲ ಸ್ಟಾರ್ಟ್ ಮಾಡ್ತೀನಿ.
ಸೇಮ್ ನಾನು ತಿಂಗ್ ಮಾಡಿದೆ ಯಾಕೆ ಕೊಟ್ಟಾರೆ ಅಂತ ಮೇಲ್ಗೆ ಡಿಸ್ಪೋಸಲ್ ಆಗಿದೆ ಅಂತ ಅದಕ್ಕೆ ಆಡ್ತಿದ್ದದೆ ಈ ಕಡೆ ಬರ್ದಾರೆ ಸೈನ್ ಮಾಡಾರ ಅಲ್ಲಿ ಫೋನ್ ಮಾಡಿ ತಂದು ಕೊಡ್ತಾರೆ. ಬ್ರಾಂಚ್ ಕಾಲ್ ಮಾಡಿ ಇಲ್ಲಿಂದನೇ ಮಾಡಿ, ಇಲ್ಲಿಂದನೇ ಮಾಡಿ, ಇಲ್ಲೇ ಮಾಡ್ಬಿಡಿ. ಅಲ್ಲಿ ಹೋಗಿ ಮರ್ತೋಗ್ತೀರ. ಆದ್ರೆ ಈ ಕಡೆ ಆಟೋ ಬರ್ತಾರೆ, ಈ ಕಡೆ ಡಿಸ್ಪೋಸಲ್ ಬರ್ತಾರೆ, ಎಂಬರಿಂದ ಕೊಟ್ಟಿರ್ತಾರೆ. ತೋರಿದು ರೊಟ್ಟಿ ತಿಂತೀರಿ? ಮೊಬೈಲ್ ಅಲ್ಲೇ ತಿಂತಿದ್ದ, ಇನ್ನೂ ತಿಂದಿಲ್ಲ. ನೀವು ಈ ಕಡೆ ಆರ್ಡರ್ ಬಂದಿದ್ರಿ. ನೋಟಿಸ್ ನೀವು ಅಪ್ಲೋಡ್ ಮಾಡ್ಬೇಕು ನಿಮ್ಗೆ ಕಳ್ಸ್ಬಿಟ್ಟಾರೆ. ಡೇಟ್ ಮಾಡೋದಾದ್ರೆ ನಮ್ಗೆ ಡೇಟ್ ಅವಶ್ಯಕತೆ ಇಲ್ಲ.
ನಮ್ದು ನಿನ್ನೆಯಿಂದ ಇವತ್ತಿಗೆ ಹಾಕಿದ್ದಾರೆ ಡಿಸ್ಪೋಸಲ್ಗೆ. ಅಷ್ಟೇ. ಸೊ 2:30.
ಬೇಗ ಕೋಟ.
I'll be there 20.
ಅದು ಕೊಟ್ಟಿರೋದು 3 ಎಕರೆ.
Kind indulgence. Serial number 48. I request my lord, the short accommodation because of Potter. Next week or after 10 days.
Yes. Potter ಅದು
Please, man, Potter.
ರೀಚ್ ಆಗ
ಅಲ್ಲ ಅದ್ರಲ್ಲಿ ಏನಾಗಿತ್ತು ಅಂದ್ರೆ ಲಾಸ್ಟ್ ಟೈಮ್ ಸೆಟ್ಲ್ಮೆಂಟ್ಗೆ ಅಂತ ಇತ್ತು. ಇಟ್ ಇಸ್ ನಾಟ್ ಟೇಕನ್ ಪ್ಲೇಸ್. ಒಂದು ಡೇಟ್
ಅದು ಯಾವಾಗಲೂ ರೀಚ್ ಆದಾಗ ತಗೋಬೇಕು ನೋಡಿ, ಅವ್ರ ಅಬ್ಸೆನ್ಸ್ ಅಲ್ಲಿ ತಗೋಬಾರ್ದು.
ಇಲ್ಲ ಹೇಳಿದ್ದೀನಿ ನಾನು.
ಹೇಳಿದ್ದೀರಾ? ಆಯ್ತು.
My learned friend is here.
Audit.
Next week.
Appearing for petitioner, some inconvenience on the respondent side. They have informed senior counsel that they will be taking.
Now, why you appealing for AC? Is he arraigned as a private respondent?
Yes, my lords. Defense is appearing for the defense.
Defense and state officer. Yes, why is not in a position to appear? Huh?
Some inconvenience.
What inconvenience? ಯಾರು ನೋಡೋಣ ಕೊಡ್ರಿ ಅವರು. And when this order was passed? And why his presence is secured now? Now, respond number 6 is directed to appear.
No, my lords. Arguing counsel has some inconvenience.
Yes. ಇದ್ರಲ್ವಾ ಯಾರು ಬಳಿಕೆ ಯಾವುದು?
ASG. My lords, I will be filing the list of documents.
All right. File it. At the request of counsel appearing for respond number? 6 and 7 list.
Copies have been served on the other side.
All right. ಏನದು?
List of documents.
The list of documents and citations furnished by the counsel appearing for petitioner is
Not citations, my lords, the judgment of trial court.
The list of documents furnished along with the memo is taken on record. Yes.
Much obliged.
Next,
My lords, the date may be fixed, my lord.
what is the date called?
Much obliged. So the petitioner.
What is it? Audit. Audit. Yes. Want it to be passed out, Banu? ಹೌದಾ? ನಾಳೆ ಬೇಡ, CMP ನಾಳೆ, Monday.
My lords, apologies. Serial number 4, 18-2, it will be long date, my lords. We are pressing for interim prayer.
ನೋಡೋಣ this one.
My lords,
Short code.
AC has posted matter for orders, my lords.
ಹೌದಾ?
Next week, any date may begin, my lords. Serial number 4.
Break code
18-2 ಬೇಡ.
18-2 ಕೊಟ್ಟಿದ್ದಾರೆ.
Please.
Yes.
My lord, a review petition has been filed by the state to review the order passed by the Solemn Court in 2015.
No, why? Please, no. I'm sorry. 2018 matter, review petition. Oh, today's date, not any date. At least that. Why are you not prepared, sir? What is this? ಏನ್ ಪ್ರತಿ ಸರಿ ಟೈಮ್ ತಗೊಳಿದ್ರಿ? ಡಿಫಾಲ್ಟ್ ಇಸ್ ಟೈಮೇ. ಯಾಕೆ ಸಲ ರೆಡಿ ಇರಲ್ಲ? I'll at least hear the senior counsel. I will hear you.
Yes. Page 23 is the impugned order which they request the Honorable Court to be reviewed, my lords. Page 23. Order is 11th June 2015.
Whether requisite ingredients are present to seek review.
No, my lords. You will have to kindly see the order, short order of this Honorable Court, my lords. Para 2, we stated there was an earlier order by this one to consider representation. There is a public well. It has to be, my lord, cleared of encroachments and desilting has to happen.
Who are you?
No, my lord, I am the riparian agriculturist. I am the beneficiary of this well, this public tank, my lords. And kindly now see, my lords, how this Honorable Court has para 3. Srimati so learned government pleader.
Reading para 3 of?
Para 3 of the order, that's page 24, my lords, of the order of this Honorable Court. First para will read one. Petition's grievance is that the Koram Badur public tank, Saviyavali Beltangar Taluk is encroached upon, that sanctioning for 20 lakhs for desilting has remained virtually unutilized. Para 1. Para 2, this Honorable Court notes the previous order, my lords. Para 3, Srimati so appearing for the government, submits Jilla Panchayat is the nodal agency for the implementation for the desilting work. As the Jilla Panchayat is not made a party to this petition suffers from non-joint of the party, necessary party. She also submits the proceedings dated. Kindly note this matter, 1/8/2013. Copy which is produced at Annexure R is an internal communication that therefore the same cannot form the base for claiming the rights. Without judicial submission, learned government pleader substates on instructions. Concerned officer already on the job of freeing the said tank area from all the encroachments. She submits that the process of evicting the encroachments will be completed in 7 months' time. Para. Proceedings of the Deputy Commissioner at 1/8/2013 are in public domain. Based on party to which the benefit would percolate has every right to demand its implementation. As the petitioner is a riparian agriculturist and as the desilting work would improve the agricultural operations and consequently his quality of life itself, his request for the implementation of the desilting project cannot be turned down. It is open to the government to employ or deploy whatsoever it wants as a nodal agency or implementation agency. Just because that agency is not made a party, this petition cannot be thrown out. Thus, both the preliminary objections raised by so and so overruled. This petition disposed of recorded submission of the learned government pleader that the process of removing encroachments from the tank bed area would be completed within outer limit of 7 months. Simultaneously, process of desilting shall also be started completed within.
What review is sought?
Now, my lord, after this, they file a petition. Now, 20 lakhs was also sanctioned by the government for desilting. Para 2, it's mentioned, my lord.
It's not enough.
The amount now, not at all enough. What they do is, my lord, now.
Who is going to pay that? Now 20 lakhs may not be enough.
Now may not be enough, my lord. Now it's what they do is, my lords, they come and remove the encroachments afterwards, after this order. Remove the encroachments, documents are prepared with the police force who have removed the encroachment, Tahsildar prepares a report. Thereafterwards, a review petition is filed stating that the land is already in the possession of some encroachers. And therefore, the DC went there and saw there is no well now. And therefore, the order requires review. And they said, we have all the revenue records, None of the revenue records mention about the public tank. It's only mentions about the government land, but there is an encroachment. We can't do it. Now kindly see this stand is opposed to facts and also opposed to the judicial proceedings. There was a suit filed by one of the encroachers, my lords, in Beltangadi. In that suit, the government appeared. The government said, already Honorable High Court has passed an order. Pursuant to the order, we have removed the encroachment. Injunction cannot be granted to him. Already 20 lakhs is sanctioned. It's a public well. He has encroached. Encroacher has no right. Encroachment happens in the dry season, my lords. For example, in every part of this country, it happens. A river flows. During rainy season, you can even play cricket. Nothing is there. So also in this area of Dakshina Kannada district, Netravati, we say Netravati, during the dry season, there is no Netravati, it's dry. Now here also, during the Tahsilar's report says, when we went, we saw it is actually tank bed. But during dry season, some of the neighbors would cultivate for 3 months. So it's only a seasonal thing they encroach upon. It's not permanent. During the rainy season, there is water and that water percolates to everybody. This was the report, my lords. Now the learned civil judge considers the report of the government where written statement is filed and considers that report and says injunction cannot be granted, injunction is rejected. There is a categorical statement in writing in the written statement and objections made by the state, by the deputy commissioner.
Show me, where is that?
Please, my lords, in the list of documents, kindly permit me, we have filed a list of documents by the respondents on 3/1/2019. The date may be little, my lords, with the photographs also, my lords.
Your memo,
How?
3/1/2019.
Please, my lords, kindly see the photos. This is almost at the hilly area, my lords. The vast area, government land. First is photographs.
Only the photographs. Where are the photographs?
I am sorry. First document itself in that, my lords. If lords have got 3/1/2019 memo, my lords.
3/1/2019.
Please, my lords. Memo filed by?
Application for additional documents, correct? Or this is by the government, it appears.
That's by the government, my lords. Something filed by the respondent.
Yes, sir.
The first document is the photographs, my lords. This is the public tank bed area, my lords. During the rainy season, it fills with the water, it becomes a huge tank. And this percolates throughout for about 6 to 7 months. It feeds the agriculturists. And kindly see, my lords. Then the suit, kindly see the document at page number 3. Suit filed by one of the encroachers against, kindly see the respondents there. 1, 2, 3. 1 is a state, 2 is a deputy commissioner, 3 is Tahsildar, 3rd is executive engineer. And the prayer made by him is that he has encroached upon, he should not be interfered with his position. Page 7. For this, I only beg to draw my lord's kind attention to the written statement filed. Page number 9. Kindly see page 10. This is statement filed by the executive engineer, my lords. Page 10, may I read, madam, para 5?
Yes.
This defendant is not a party to the writ petition. Executive engineer was not a party. In so and so and so. The plaintiff admits High Court issued direction to the second defendant as per order dated so and so to consider a presentation of the petitioner in the said case, namely Rajesh, in accordance with the law, to desilt so and so public tank within the time. It is not correct to allege that the order was only to consider the memorandum so and so. In pursuant said order, second defendant has directed this defendant as per the order dated 26/7/2013 to carry out the direction of the High Court, and a sum of 20 lakhs was sanctioned for the said work. In obedience to said order of the second defendant, this defendant issued a tender, called for bids. In the tender proceeding, this defendant accepted the bid submitted by one so and so Dinesh, contracted, issued a work order dated so and so. As there was some delay in implementing the order, the petitioner in the writ petition number so and so filed another writ petition, alleging the directions given in so and so has not been carried out by second defendant within the time, and had requested the High Court to direct second defendant to carry out so and so. In the said writ petition, Government of Karnataka informed to the High Court that the work of desilting has been entrusted to this defendant. Proceeds continuing. It informed the High Court that some encroachment was found in that land. Same was cleared. And it gave an undertaking that the work of desilting will be complete soon. High Court disposed of the writ petition, etc. Kindly see the next page number 11, para 6. In the meanwhile, on 12/5/2015, the second defendant got handed over possession of the said 1 acre 10 guntas of so and so in RS number so and so to this defendant after clearing the encroachments to enable the defendant to carry out the desilting task of so and so. Therefore, plaintiff
Para
cannot.
6. As per para 6, entire encroachment is removed.
Removed, and they got the police force, my lord. The documents are also there to remove it.
Yes.
Then para 7 is everything is false, my lords, and we are in possession. And page number 12, line number 1, this has been informed to the High Court, etc. Second sentence, entrustment of the work to this defendant has been mentioned by the High Court of Bangalore. And this is considered, my lords, and now your lords may kindly permit me to refer to that document which says, my lords, that the encroachment has been removed with the police force. Kindly see page 20. Report of the Tahsildar made to the Deputy Commissioner. ವಿಷಯ ಬೆಳ್ತಂಗಡಿ ತಾಲೂಕು ಸಾವ್ಯ ಗ್ರಾಮದ ಕೊರಂಬಾಡು ಎಂಬಲ್ಲಿ ಸರ್ವೆ ನಂಬರ್ 75/1P2 ಅನಾದಿ ಕಾಲದ ಇರುವ ಕೆರೆಯನ್ನು ದುರಸ್ತಿ ಮಾಡುವಂತೆ ಕೋರಿ ಸಲ್ಲಿಸಿರುವ ಮನವಿ ಬಗ್ಗೆ ನಂಬರ್ 1, 2, 3 ಸಾರ್ವಜನಿಕರ ಮನವಿ, ಜಿಲ್ಲಾಧಿಕಾರಿ ಪತ್ರ ಎಕ್ಸೆಟ್ರಾ. ಬೆಳ್ತಂಗಡಿ ಸಾವ್ಯ ಗ್ರಾಮದ ಕೊರಂಬೋಡು ಎಂಬಲ್ಲಿ ಸರ್ಕಾರಿ ಸರ್ವೆ ನಂಬರ್ 75/1P2 1 ಎಕರೆ ಜಾಗದಲ್ಲಿ ಕೆರೆಯು ಇರುತ್ತದೆ. ಫುಲ್ ಸ್ಟಾಪ್. ತಹಶೀಲ್ದಾರ್ ರಿಪೋರ್ಟ್. ಈ ಕೆರೆಯನ್ನು ದುರಸ್ತಿಪಡಿಸುವಂತೆ ಉಲ್ಲೇಖದ ಅರ್ಜಿ ಮನವಿ ಸಲ್ಲಿಸಿದ್ದಾರೆ. ಹಾಲಿ ಕೆರೆಯಲ್ಲಿ ತುಂಬಿರುವ ಸಮಯ ರೈತರು ಬೆಳೆಗಳಿಗೆ ನೀರನ್ನು ಉಪಯೋಗಿಸಿದ್ದು ಹಾಲಿ ಕೆಲವರು ದುರುಪಯೋಗ ಮಾಡುತ್ತಿರುವುದಾಗಿ ಅರ್ಜಿದಾರರು ಕೆರೆಯ ದುರಸ್ತಿಯಿಂದ ಪರಿಸರದಲ್ಲಿ ನೀರಿನ ಒಳಹರಿವು ಹೆಚ್ಚುವುದರಿಂದ ಕೆರೆಯ ಅಭಿವೃದ್ಧಿ ಮತ್ತು ಅನುದಾನ ನಿರೀಕ್ಷಿಸಿದ್ದಾರೆ. ಆದರೂ ಅರ್ಜಿದಾರರ ಕೋರಿಕೆಯನ್ನು ಪರಿಗಣಿಸಿದರೆ ಸಣ್ಣ ನೀರಾವರಿ ಇಲಾಖೆಯ ಜಿಲ್ಲಾ ಪಂಚಾಯತ್ ಇಂಜಿನಿಯರಿಂಗ್ ಇಲಾಖೆಗೆ ಸದರಿ ಮನವಿ ಕಳುಹಿಸಬಹುದು. ಲಾಸ್ಟ್, ತನಿಖೆಯ ವರದಿ ಹೇಳಿಕೆ ಮಹಾಜನರಲ್ಲಿ ಅಗತ್ಯೀಕರಿಸಿದೆ. This is 2011, my lords. 21, that is the Mahajar. I will not read the Mahajar. Mahajar says, Kandaya Nirikshaka Varadi, that, my lords, that there is a public well, etc. Now, kindly see annexure F. Based on this, page 23, Deputy Commissioner passes an order. ಕೆರೆಗಳ ಪುನರುಜ್ಜೀವನ ವಿಷಯ ಕಾರ್ಯಕ್ರಮ ಡೇಟೆಡ್ ಸೊ ಅಂಡ್ ಸೊ ವಿಧಾನಸಭೆ ವ್ಯಾಪ್ತಿಯವರೆಗೆ ಎಕ್ಸೆಟ್ರಾ. ಅದರಲ್ಲಿ ಉಲ್ಲೇಖ 1, 2, 3 ಕೆರೆಗಳ ಪುನರುಜ್ಜೀವನ ಕಾರ್ಯಕ್ರಮ ಬೆಳ್ತಂಗಡಿ ತಾಲೂಕಿನ ಸೊ ಅಂಡ್ ಸೊ ಸಾವ್ಯದ ಕೆರೆ ಅಭಿವೃದ್ಧಿಗೆ ಅನುಮೋದನೆ ನೀಡಲಾಗಿದೆ. ಅಮೌಂಟ್ 20 lakhs. Now, my lord, a proceeding happens of the Tahsildar. That's page 25. Removing the encroachment. Beltangadi Tahsil Karyagala avara nadavali. Kindly go to page 27, my lords. It all says, my lord, there is encroachment, it has to be removed, etc. Page 27, order dated proceedings, operative personnel date, my lords. 13/6. ಪ್ರಸ್ತಾವನೆ ಇವರ ಸಂದರ್ಭದಲ್ಲಿ ರೀತಿಯ ಸಾವ್ಯ ಗ್ರಾಮದ ಸೊ ಅಂಡ್ ಸೊ ಇಲಾಖೆ ವ್ಯಾಪ್ತಿಯ ಕೊರಂಬೋಡು ಪಂಚಾಯತ್ ರಾಜ್ ಇಲಾಖೆಯ ಸಹಾಯಕ ಅಭಿಯಂತರರಿಗೆ ಸರ್ವೆ ವಿಂಗಡಣೆಯಿಂದ ಗುರುತಿಸಿ ಸದರಿ ಕೆರೆ ವ್ಯಾಪ್ತಿಯಲ್ಲಿರುವ ಅಕ್ರಮ ಬೆಳೆ ರಚನೆಗಳು ಸರ್ಕಾರ ಮುಟ್ಟುಗೋಲಾಗುವಂತೆ ಒತ್ತುವರಿ ತೆರವುಗೊಳಿಸಿ ಕೆರೆಯನ್ನು ಸೊ ಅಂಡ್ ಸೊ ಸುಪರ್ದಿಗೆ ವಹಿಸಿ ವರದಿಯ ಬಗ್ಗೆ ಲ್ಯಾಂಡ್ ರೆವಿನ್ಯೂ ಆಕ್ಟ್ 104 ಅಡಿಯಲ್ಲಿ ಅಧಿಕಾರ ಉಪಯೋಗಿಸಿಕೊಂಡು ಈ ಕೆಳಗಂಡ ಸಿಬ್ಬಂದಿಗಳನ್ನು ತಂಡಗಳನ್ನು ನಿಯೋಜಿಸಿ ಆದೇಶಿಸಿದೆ. ಸಿಬ್ಬಂದಿಗಳು 1, 2, 3 ಅಧೀನ ಸಿಬ್ಬಂದಿ ತತ್ಸಂಬಂಧ ಅಗತ್ಯ ಕ್ರಮದ ಬಗ್ಗೆ ಮಾತ್ರ ಪ್ರಾಧಿಕರಿಸಿದೆ. ಅಗತ್ಯ ಆರಕ್ಷಕ ನೆರವು ಪಡೆಯಬಹುದು. Based on this, kindly see now, my lords, page 29. Page 29, my lords. Tahsildar writes a letter to the police ನಿರೀಕ್ಷಕರು. Last line. ಒತ್ತುವರಿ ತೆರವು ಹಸ್ತಾಂತರ ನಡೆಯಲಿದ್ದು ಸದ್ರಿ ದಿನದಂದು ಕ್ಲಬ್ಟಸಲ್ 1 ಮಹಿಳಾ ಬೆಟಾಲಿಯನ್ ಸಿಬ್ಬಂದಿ ನೇಮಿಸಿ ಸೂಕ್ತ ಭದ್ರತಾ ವ್ಯವಸ್ಥೆ ಕಲ್ಪಿಸುವರೆ ಕೋರಿದೆ. For removal of the encroachment on 12/5/2016. Third line in that para, my lords. This is 11/5/2016. Thereafter, page 30, it concludes the matter. Page 30, ಯಾದಾಸ್ತು ದಿನಾಂಕ 12/5 ಮಾನ್ಯ ಸಹಾಯಕ ಆಯುಕ್ತ ನಿರ್ದೇಶನದಂತೆ ನಂಬರ್ ಸೊ ಅಂಡ್ ಸೊ 26/12/2015 ಬೆಳ್ತಂಗಡಿ ತಹಶೀಲ್ದಾರ್ ನಾನು ಈ ಕೆಳಗೆ ಸಹಿ ಮಾಡಿದ ಸಮಕ್ಷಮ ಸಾವ್ಯ ಗ್ರಾಮದ ಸೊ ಅಂಡ್ ಸೊ ಒಟ್ಟು 1.10 ಎಕರೆ ಕೊರಂಬೇಡು ಕೆರೆ ಒತ್ತುವರಿ ತೆರವುಗೊಳಿಸಿ ಸಹಾಯಕ ಕಾರ್ಯಪಾಲಕ ಪಂಚಾಯತ್ ಅಭಿಯಂತರರು ಪಂಚಾಯತ್ ರಾಜ್ ಇಂಜಿನಿಯರಿಂಗ್ ಉಪಯೋಗವರಿಗೆ ನಕ್ಷೆಯೊಂದಿಗೆ ಹಸ್ತಾಂತರ ಮಾಡಿರುತ್ತೇನೆ. And signature of Tahsildar, village accountant, concerned executive officer, surveyor.
Yes, sir.
And ಹಸ್ತಾಂತರ ಪಡೆದವರು, ಹಸ್ತಾಂತರ ಮಾಡಿದವರು, ಹಸ್ತಾಂತರ ಪಡೆದವರು. Executive engineer sign is there. Sketch is at page number 31. And page 31 clearly mentions about ಕೆರೆಯ ಭಾಗ. ಒಂದು 99 cents ಮತ್ತು 11 ಒಟ್ಟಿಗೆ 1 ಎಕರೆ 10 cents. Now, my lord, based on this, an order is passed by the learned civil judge, annexure K, that's page 32. That's dated 3rd October 2017. Order A4 filed by the plaintiff for injunction, my lords. The learned judge
Yes, rejected. Injunction is
rejected, notes all the submissions. And also kindly see now, objections, page 37. I will not read further, page 37, which I had not brought the kind notice of this honorable court to. That's brief as objections filed defendants 1 to 3. The same respondents, my lords, who are now in review before the honorable court. Same respondents in the WP. Defendants 1 to 3 have denied entire content of the affidavit filed in support of the application.
Who are the authorities? Defendants 1 to 3.
The deputy commissioner, Tahsildar, and the state.
And they are the review petitioners.
They are the review petition, they are the respondents in the writ petition. And they say, the said lands are government Parambok land, property cannot be granted in favor of petition. In that property, there is Parambok Kere. From that lake, farmers are using the water of the land. That the Honorable High Court has so and so passed an order. We are obeying the order. We are going to remove the encroachment. This is what is stated. Can the state now, my lord, come and say our statement is not true? What exactly they say, my lord, in the review petition is, whatever we stated earlier is not true. Now we go and find that there is no Kere at all. State is required to be an ideal litigant, my lord. They exactly this, and learned judge takes note of this and dismisses it. What they could not, that encroacher could not get a relief there. Now he probably goes to some politician, and through that, my lord, it goes to the DC. DC comes again and says, I find no Kere. In fact, nobody can find Kere or a river if you go in the dry season or April, May.
Tell me though, where is this?
This is a Beltangadi, my lords, in the hilly area. Savia is in the very hilly area, my lords, from where, in fact.
But who are these encroachers? Adjoining landowners?
What the adjoining land? They don't have any, whether they have the land or not, it's not forthcoming. Adjoining, what they do is, my lords, when the water subsides down, they start growing and say, this is my paddy field, or this is, I am cultivating something. Because entire area, my lords, would become barren. Your lords may kindly go, we say, if Netravati flows down from there, etc., my lords, there will be no river at all.
On what ground they are seeking review?
Review is, my lord, now we find that the submission made is not correct before this honorable court. The review petition, I beg to draw my lord's kind attention to, my lords.
We will hold them accountable. Partner.
Please, my lord. This is exact, nothing more. I don't want to say anything. In the entire review petition, they say, my lords, page number 8. Deputy Commissioner fund a spot inspection. And he found that there is no land is a patta land, not a tank bed. I don't know how in the middle portion of para, page number.
All right, these
Please,
amendments are made.
he may be guilty of contempt also, my lords.
No,
But
yes.
what
We'll
he says
examine-
is a patta land, he says, my lords, and say there are.
To withdraw the statements made earlier,
Yes,
not only before the High Court, but also statement made before a competent civil court.
please.
You cite some
I will,
judgment.
my lords.
Where are these deputy commissioners? Just verify. Who have
No,
signed, who are
verifying
party-
affidavit is filed by
I don't want the present. deputy
Tahsildar.
commissioner.
Tahsildar has filed a verifying affidavit, my lords.
No,
Please.
no, I don't want this present deputy commissioners.
Please, he is the person who.
Tahsildar, check out whether they are retired. Yes, Mr. Government advocate. Where are these? The then deputy
Mohan.
commissioner and Tahsildar. Get the details by Monday, part third. Monday. Monday. Yes, next.
Please, grateful.
ಇದ್ಯಾವ್ದು? 230. Yes. Where is he? Why it was urgent to today?
Whether or not we can produce any title document to say how Sanjeev, remember this is the case where Sanjeev became Sanjeevi, the entire sex itself changed.
Yesterday's matter.
Also was inclined to dismiss the expectation, but then a final chance was given to him to produce any title document. Judgment and decree also passed in my favor.
This is your ancestors' property.
Please, 1934, Rangappa.
Where is the decree produced by you?
My lord, I produced it at annexure R7, my lord, page 41 in my objection.
If suit is for what?
But suit is for bare injunction.
But there's a reference.
Please, there's a reference and also, we have produced all our title deeds, that is two settlement deeds, registered settlement deeds, genealogical deed, and also, the DC's order.
Just narrate now, I again forgot. Your name was there? Respondents' names were there in the records, RTP record?
2002 it was there, 2001 to 2002.
At whose instance it was disturbed?
Then thereafter, they get an RRP, if my lords were to kindly see annexure P.
Which is not found in the records.
It has nothing to, how it even came, nobody has any idea.
Fictitious.
Because how they even came.
All right, where is it? Where is it?
My lords may kindly see annexure P in their compilation. Repetition compilation. If my lords were to kindly see.
Based on this they get.
For the first time, they show Sanjeev there. But they show Kum Narsimha.
Lady.
Sex is changed.
Yes, sir.
No, yesterday, I argued the matter, Your Honor. Title to the property of my vendors.
Where the typed copy of this document?
I'm not able to.
How
get
to
it.
read it?
No, I'm not able to get it, my lord.
You are not able to read it?
No, I'm not able to get it, the taped copies, my lord.
You can read it?
I'll try to read it, my lord.
No, you can't try to read. You have to read what is there.
Please, man. Otherwise, I'll purchase the typed copies, my lord. Have it next week, please.
Whether this was produced in suit?
Some of the documents are produced in.
No, not some. Whether this was part of the suit? Whether these
Before this,
documents were produced
RTCs
in
were the
market?
part of the suit.
Huh?
RTCs and family tree was the part of the suit, my lord. And this Karda and this ILR copy has been produced now here. Only because
Sanjeevi, wife of Mr. What's her full name? Sanjeevi. No. Sanjeevi, wife of Narsimha.
Yes, my lord. The first.
You are tracing your right through this lady, isn't it?
Through this lady, my lord.
How she's the owner? How
Narsimaya is the owner of the property, my lord. As per their own pleadings, Narsimaya was the owner of the property and his sons sold the property in favor of Rangappa, that is father-in-law of the respondent. My contention is Narsimaya, the children of Narsimaya has not sold the property. The property belongs to Narsimaya only, but they are claiming survey number 135. They are claiming survey number 135. All of a sudden in the year 1951, survey number 63 is came to in existence in their documents. That is my grievance before suit also, and now here also, Your Honor. They are claiming title in respect of.
Forget about them. They have title documents. They have title documents.
They have title document to survey number 135, my lord. They are title document about survey number 135.
That is renumbered, no? As 61/3.
Mine is 63.
That is renumbered.
When it is came to be existence.
Now, Sanjeevi, wife of
Narsimaya.
Who is she?
She is wife of Narsimaya. Narsimaya. Sanjeevamma, her name is Sanjeevamma. It is written as Sanjeevi. Because they are only produced the exhibit D10 to 14 before the.
Her, what is the document you have set up? Who are you?
I am the children of second LRs of this Sanjeevamma and Narsimaya. Sanjeevamma and Narsimaya had got 3 children. One is Durgaya, another one is Narsimaya, second one is Durgappa, and third one is Hanumantaya. Out of these 3 children, one Narsimaya has no issues, he died. Durgappa has got 5 children and Hanumantaya has got 6 children. The first family tree is produced.
Where you produced?
Now, along with my memo. All these children and the LRs of this Narsimaya had executed sale deed in my
favor. You type
Please type
What is this? You took time yesterday.
No, my lord. Documents were not placed, my lord, because party was not there.
Can you read what is this? What's the problem, sir?
I have raised the documents.
Equitable
in the
practice
morning
ಮಾಡ್ತೀರಾ ನೀವು?
itself. ಇಲ್ಲ ಸರ್, ಬೆಳಗ್ಗೆ
ಆ?
ಬೆಳಗ್ಗೆ ಕೊಟ್ಟರು ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಕೊಟ್ಟರು ಅವ್ರು ವಾಪಸ್ ಟೈಪ್ ಮಾಡಿ ಕೊಡಕ್ ಆಗೋದಿಲ್ಲ ಅಂದ್ರೆ ನಾನು
Sir, ಓದಕ್ಕಾಗಲ್ಲ ಅದು. You can't read it also.
ಐ ವಿಲ್ ಪ್ರೊಡ್ಯೂಸ್ ನೆಕ್ಸ್ಟ್ ವೀಕ್.
No, I will not permit you, sir.
Also to kindly see that suit, the plain which they produced, the new story now, today was Malone producing, it's a new
Let me
story.
see now, that's the difficulty. If you adjourn, you have to again revisit. For a judge, it is quite challenging.
Today it's a new story.
I had a better grip of facts yesterday. Now I have to again revisit and I have to recollect. Just a minute to tell me from whom you have purchased.
I have purchased 1934.
Huh?
Let me kindly see the same date which I have produced. It's an annexure R3, my compilation, page 18. I produced a typed copy. I purchased from Durgaya and Hanumanta, who are the sons of Narsimaya. Nayakara Narsimaya.
Just a minute, just a minute. Go slow. Survey number.
That's first while survey number 135.
135.
Yes.
Renumbered as
63.
whether there is a mutation to the defect, reassigning mutation.
Reassigning, I produced the RTCs to the effect also saying it was showing it was in minor.
No. It was reassigned 63.
I have the documentation and so far as reassigning is concerned, but not
If that is traced, my lord, the whole problem will be solved.
Audit.
Because, please.
please. Then, my lord, there is also a settlement.
Any supporting documents to show that this was earlier, this was 135 and then it is renumbered as 63.
I'll have to go through the flow of my deck. I'll just go through the flow and then I'll come.
Yes. Now, who is the owner of this land?
My lord, it was my father-in-law. Rangappa purchases the property.
No.
Rangappa has 2 children.
Rangappa has purchased.
The property, 1934.
From whom?
From my lord, Durgaya and Hanumanta. Registered sale date.
Sold to Rangaya.
Rangappa.
Rangappa.
Please.
Date of sale date?
10/5/1934.
Yes.
Please. Thereafter, there is a settlement deed where Rangappa retains the property and he says subsequent to the death of Rangappa, it will go to both of the sons.
Both of the sons.
Please.
Settlement dated?
The settlement deed dated,
All right, Rangappa execute settlement deed.
please. But there's one settlement deed which is 5/2/1951. There's one more maintenance settlement deed which is of the year
Wait, 5/2?
1951.
Ah,
There's also a maintenance settlement deed where I was taken care of. That is one of the sons of Rangappa. Sanjeevaya's wife was taken care of by virtue of the settlement deed. Maintenance settlement deed of the year 1949.
Rangappa had 2 sons, no?
Sir, please.
What is this maintenance deed? Who executes maintenance deed?
Rangappa. Because Sanjeevaya he had certain vices is what they say. Which is why he executes a maintenance settlement deed first in favor of the respondent number 1 before my lords. That's his daughter-in-law.
In favor of?
In favor of Venkatama.
Venkatama.
His daughter-in-law. Thereafter, my lord,
Can you
a settlement deed.
can you name the both the sons, Rangappa's sons? What are the names of Rangappa's sons?
Rangappa's sons, my lord, one is Sanjeevaya. One is Hanumantaya.
Second is Hanmantaya.
Please. No, my lord, I am not disputing that it belongs to both of us. Both limbs of the family belongs to.
Hanmantaya.
Please. Hanumantaya and Sanjeevaya. Then, my lord, there's a settlement deed which is executed by my father-in-law, Rangappa, in 1951, where he says, I.
Now, Venkatama is the widow of whom? Sanjeev Bhaiya. Who else are party to this petition now?
It's only Venkatama.
Only Venkatama.
Only Venkatama.
Hanumanthaya died issueless.
I'm sorry, brother.
Hanumanthaya died issueless.
No, he had sons.
Yes.
It was not for convenience, it was there in one person's name. I'm not disputing that the entire property belongs to me. It is for the benefit
All
of
right,
that.
all right.
No dispute on that. My lords may kindly see, my lords will also have an idea. If my lords were to kindly see the judgment and decree, but please, now the suit is filed against Hanumantaya's legalers and then my lord Venkatama. If my lords were to kindly see page 41, T. Nagaraj, that is the petitioner before my lords. Ranga Hanumaya, Uni Hanumaya, and Rangaya. These are all the sons of Hanumantaya.
Wait. R8,
Please. R7.
R7.
Please. This can be corroborated by the plaint which they have also filed in the repetition. Plaint is one of the annexures. Filed in 2009. Thereafter, it was rejected for want of jurisdiction.
Yes.
Please, my lord, may I just take my lords to the suit because, like I said, my lord, it's a different stand. Which
Now, Venkatama has no children.
Lord, Venkatama has one daughter.
Has only one daughter.
No.
What's her name?
Rangamma, if I'm not wrong.
Muni Anamaka.
Rangamma, if I'm not
Huh? Amale.
No,
Verify and then tell me.
I just verify.
application.
Rangamma.
Please. In fact, Hanumantaya had 4 sons and 1 daughter by the name Hanumaka.
Hanumanthaya.
Yes, Hanumantaya. So 4 defendants in the suit, first 4 defendants in the suit, and 1 Hanumaka was also there.
All right.
Another daughter. Please.
She's not party to the suit. Yes.
Please. Now, my lords, may I just take my lord's attention to the plaint which they have filed, because that will show what is their stand. They only say that I have purchased this property in 2005. How they get the property, how the vendors got the property, there is nothing. So today it's a new stand which they come up and take.
All right. Petitioner purchased it from whom?
Petitioners said to have purchased from us Anjanappa, Narsimurthy, Krishna, Sushilama, Gangamma, and Gangappa. Now, how they get the property, there's nothing there. It only refers to an RRT.
All right. Even if we accept that lady,
Please.
from her, how their purchase is not forthcoming.
And there it is not Sanjeev, it is still Sanjeev itself. Now, how they making that a lady, I have no idea.
What?
It's still Sanjeev Allah. Or Sanjeev Amma. It is not in the MR itself, which they are referring to, the MR which they themselves have produced at annexure B. If my lord were to kindly see, it is Sanjeev. Sanjeeva ಅಂತ ಹೇಳ್ಬೋದು. No Sanjeevi, no Sanjeev Amma. And it says court adesha. No, Milord, there is no court order.
All right, now Anjanappa and all these persons,
Please.
they sell this property
They sell this property to petitioner.
based on what, RR 102?
Only the other, nothing else. How they got the property, there is no recital. In fact, the DC in his order has also categorically held that where is it, show us the link between, let's assume for the sake of argument, Sanjeev is Sanjeevi or Sanjeevamma itself. What is the link between Sanjeevamma and you? That is what my lords have also pointed out yesterday.
Yes.
Assuming for the sake of, because today's argument for it is that 135 belonged to Narsimaya. That is supposed to be the father of Rangappa's vendors in 1934. Assuming for the sake of argument, it was 135. Then, Milord, how can his RRT also be for 663 then? If it all has to start from Narsimaya, if it all has to start from 135 itself.
Now in suit, this property is referred as survey number 63.
63.
And there's a finding of fact that you have acquired it under title document.
There was the Mahazar also, Milord, drawn.
All right. That's all.
Please, Milord.
Now what these documents? Why you have produced these documents?
Yes, please. The first document is the genealogical tree, my lord. The first document is the G tree of my vendors.
First document is the
Genealogical tree, my lord, of my vendors. They are grandchildren of Narsimaya and Sanjeevamma.
yes.
Please. The second document is, Your Honor, the Karda wherein survey number 117 became 135.
Second document is?
Karda of survey number 117 earlier.
What is this document?
It is Karda of survey number 135. Karda. It says the Karda antide.
Yenadu andre yenadu?
The title document to the revenue land, my lord. Resurvey number 135 has been given on the right hand side. The old number is 117 is rounded up. New survey number 135 has been given.
What is the document? ಏನಿದು?
ಹಳೆ ಸರ್ವೆ ನಂಬರ್ ಹೊಸ ಸರ್ವೆ ನಂಬರ್ ಚೇಂಜ್ ಆಗಿದೆ ಸ್ವಾಮಿ. 117 became 135.
All right.
The third document is survey number 130 became survey number 63. Right hand side, Your Honor.
135 was reassigned survey number 63.
No. 130 assigned survey number 63.
Survey number 130.
130.
Where you get it?
From the third document, Your
Honor.
At page number 4. Resurvey number 63. Old survey number 130 has been rounded up.
Okay.
The next document is the RTCs, Your Honor. Sanjeeva Kom Narsimha. Durga Namaya, son of Narsimha. Muniyamma, wife of Narsimaya.
The cultivators column the Hanumantaya yaru?
Hanumantaya is my elder son. The family tree, on the left hand side. Right hand side, sorry. Third son of Narsimaya.
Yes.
Please. And the next document is ILR 102, wherein Sanjeevi Kom Narsimha, Durga bin Hanumanta bin Narsimha, Muniyamma Kom Mot Urf Narsimha ಅಲ್ಲಿ ಖಾತೆದಾರರಿಂದ ನರಸಿಂಹನ ಹೆಸರಿಗೆ 300 ರೂಪಾಯಿಗಳಿಗೆ ಕ್ರಯವಾಗಿ ತಾಯಿ ಮಕ್ಕಳು ಮತ್ತು ಸೊಸೆಯು 2 ಭಾಗವಿಲ್ಲದೆ ಬಹುತ್ವದಲ್ಲಿ ಅನುಭವಿಸುತ್ತಾರೆ. ದಿ ಸೇಮ್ ILR refers in RTC also. Same ILR. And next document is for the year 6061, wherein survey number 63, Sanjeevi Vagaire Hanumantayya. Sanjeevi Vagaire Hanumantayya. Please. And the next document is the recent document, my lord, survey number 135, wherein it stands in the name of Kempamma Komsatigappa.
Who is Kempamma?
This is not concerned to me, my lord, because the survey number 135 is mentioned, because they are claiming title over the property in the survey number 135. That 135 survey number belongs to one Kempamma, that is measuring 1 acre 21 guntas.
All right.
The next document is, my lord, survey number 117, it stands in the name of Kempaya, because 117 came to be renumbered as 135.
Yes.
Now, my lord, come to the sale deed, what they refer to. In the year 1934, it says survey number 135 measuring 3 acre 20 guntas, sold by one Durgaya and Hanumanta, son of Nayaka Narasimha, in favor of Rangappa.
Extent is 3 acre?
3 acre 20 guntas.
3 acre 20 gunta. What is the measurement of 63?
3 acre 20 guntas plus 14 guntas of Karar.
All right. Extent
Boundaries
tax.
also differs, Your Honor.
Huh?
Boundaries also differs from each document to document. And in the settlement deed, in the year 1948, they execute the settlement deed in survey number 135. Whereas in the year 1950-51, they changed it into survey number 63. There is no reference about change of survey number from 135 to 63. Now the whole matter is running in between the survey number 135 and 63. This is only my submission, Your Honor. And before Deputy Commissioner, my lord, Deputy Commissioner passes the orders only on the basis of my non-appearance, even though I appeared before the Deputy Commissioner and undertaken to file wakalat on the next date of hearing. I have not appeared before the Deputy Commissioner. Therefore, the Deputy Commissioner order came to be passed, Your Honor. Kindly see, on the date of appearance, when the order sheet shows, this says Prativadi Hajaru antare. Prativadi signature ತಗೊಳ್ಳೋದಿಲ್ಲ. ಅದರ ಜೊತೆಗೆ ಮೆಮೋ ಆಫ್ ಅಂಡರ್ಟೇಕಿಂಗ್ ಹಾಕಿದ್ದಾರೆ ಅಂತ ಹೇಳ್ತಾರೆ ಆ ದಿವಸ ಮೆಮೋ ಆಫ್ ಅಂಡರ್ಟೇಕಿಂಗ್ ನ ಆರ್ಡರ್ ಶೀಟ್ ಅಲ್ಲಿ ನೋಟ್ ಮಾಡೋದಿಲ್ಲ ಸ್ವಾಮಿ. Principal violation of principle of natural justice, Your Honor. If I could have heard, I could have produced all these documents before Deputy Commissioner. Now, the suit came to be dismissed on the ground that the Mahajar and also order of DC, which is impugned before Your Honor. Only on these two documents, the suit came to be dismissed, Your Honor. The appeal is now filed and which is pending before this court, Your Honor. And the Mahajar, what the trial court relied upon for passing of judgment pertains to year 2009. My suit is in the year 2008. Your Honor is aware, the suit for injunction with respect to the possession of the property, because we have not sought for any declaration relief, and to prove that possession, I have produced the register sale deed, which stands in my name, and the RTC extracts. Here, as per the settlement deed refers to year 1951, Rangappa settled the property in favor of two sons, whereas only Venkatamma has challenged the mutation entries before Assistant Commissioner and also before Deputy Commissioner. That is their internal this thing around. I am not.
How we can take advantage of it?
No. I'm just saying the survey number
You
63.
want them to attack you in group,
I'm just saying, my lord, I'm just,
ಹಾಕು ವೆಂಕಟಮ್ಮ ಸಾಕಲ್ಲ.
please.
ಯಾಕೆ?
My only respect to submissions before this court is, my lord, before Deputy Commissioner, I have not given an opportunity of being produced the documents, nor I was heard. That is only my grievance, my lord. If at all I have given an opportunity, I could able to produce these documents because the survey number 135 is changed from survey number 117. Nowhere in the revenue documents, 135 changed to 63.
All right, settlement deed ಅಲ್ಲಿ there is a reference that it is.
Settlement it is 63, it is shown as 63.
63 only.
Let's go one step backward. Now, Malaran says that it belongs to Narsimaya, that is 135. Now, he's also claiming 63 today. How did that 135 become 63 then?
That's what I have produced the document 135, 60, 130 changed to 63. 130 changed to 63. That document is there.
What he says.
That document
Says
is there.
that Narsimha was owner of 130, survey number 130. Says.
130.
So Durgaya and Hanumantai also, my lords have seen these two names. They are the ones who executed the sale deed in my name in the first place. It is his sons who executed the sale deed. And my lord, if Narsimaya is the grandfather of his vendors, my lord, let's assume, my lord, what was the age of Narsimaya as in 1934? Is it possible for his wife to be alive as of 1999?
That's what I wanted to ask him.
Please, my lord. It is not possible.
No, by that time she's died. That's the reason why Sanjeeva Kom Narsimha. Sanjeevi Kom Narsimha. That is the reason why the Kata has been mutated in her name.
ಎಲ್ಲಿ
Sanjeeva
ಯಾವಾಗ?
Kom Narsimha.
ಯಾವಾಗ?
In 2005.
There is no records to show that, my lord, because even they also no records.
ಎಲ್ಲಿದ್ದಾರೆ ಅವರು? ಸಂಜೀವಿ ಎಲ್ಲಿದ್ದಾರೆ?
ಅಲ್ಲ, ಇಲ್ಲ, she is no more. Your honor.
When she died?
We don't know that because we have purchased the property and we don't know. But the revenue records were standing in their name because they also produced the documents at exhibit D8 to D14 before the trial court, wherein my vendor's name is shown.
That is my grievance, my lord. That's exactly my grievance. How did his
Yeah.
vendors' names come in the first place? In 2005, the first time they show this.
If they are able to prove, my lord, survey number 135 is changed to 63 and that 63 has been settled.
That they are not examining under mutation process.
That's why, my lord. That's true, my lord.
Why you filed only an injunction suit? How we can maintain an injunction suit?
My lord, I filed injunction suit because I
How we can
purchased the
maintain
property.
injunction
No, I purchased the property and
Okay.
based on this injunction from my vendors.
You have to substantiate, sir.
Please, my lord, in the
You're
suit,
running out of time and now your relief of declaration is barred by time.
please, my lord. But my only grievance is before the deputy commissioner, my lord.
You are the counsel appearing before the trial court also?
No, my lord, I am not the counsel.
No, it's on RFA. Okay. What did mention this on? It's on RFA today.
No,
Before the trial court, that was dismissed. Now today there's an appeal pending. That's what my lawyer friend has also
no,
applied.
no. I wanted to know whether he's conducting that.
No, no, no.
You're not conducting.
In this case, I came recently, my lord, by filing NOC.
In fact, it's quite controversial because there was a memo of appearance filed before the DC. Now, my lord, the petitioners now turn back and say, no, the memo of appearance was never filed by anybody who I authorized. They also say that though it is recorded saying I was present, I was never present then.
Yes, anything
It's
else?
recorded. All the time.
That's all.
That's all, my lord.
For Quadri. Now, this dispute started with this RR number, no? Or not? Who challenged then? You challenged?
No, I challenged it.
Before
Before the AC.
Assistant Commissioner?
Yes.
What Assistant Commissioner has done?
No, he dismisses.
Dismissed your appeal.
Yes. On 12/3/2009, he dismissed me.
And Deputy Commissioner
Allows it.
allows it. He takes cognizance of judgment and title documents.
No, no, no. By that time, judgment was not passed.
Not
passed. It was
Only
pending.
title documents
Yes. That is also mentioned.
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 Kutkote. Caption petition is filed assailing the order of second respondent deputy commissioner who has allowed the revision filed by private respondents and has confirmed the order passed by both respondent assistant commissioner. The order passed by deputy commissioner is under challenge before this court. Next facts leading to the case are as under. Petitioner is asserting title over survey number 63, measuring 3 acre 34 guntas, inclusive of 14 guntas of Kharab land based on a sale deed. Sale deed dated 22/5/2006. Petitioner is asserting that having purchased the property from his vendors, he has acquired valid title and that is in possession. Based on this sale deed, it appears petitioner's name was mutated to the RTC pertaining to the petition land. Private respondents, based on sale deed, no? His name was mutated based on sale deed.
Based on the same.
Private respondents feeling aggrieved by the impugned mutation, thereby mutating petitioner's name, preferred an appeal before fourth respondent assistant commissioner. Assistant commissioner allowed the appeal and set aside the mutation.
Assistant Commissioner.
Assistant commissioner dismissed the appeal. Dismissed the appeal. By holding that, what was the finding recorded by assistant commissioner?
The finding is that,
Annexure,
Annexure 46, page 46.
page
46. ಸಿವಿಲ್ ಕೋರ್ಟಲ್ಲಿ ಎಸ್ಟಿಮೇಟ್ ಮಾಡ್ಕೊಳ್ಳಿ ಅಂತ ಇದರಲ್ಲಿ, ಯಾಕಂದ್ರೆ ಸಂಜೀವ ಅಂತಕ್ಕಂಥದ್ದು ಹೆಸರು ಡಿಫರೆನ್ಸ್ ಇದೆ, ಹಾಗಾಗಿ ಸಿವಿಲ್ ಕೋರ್ಟಲ್ಲಿ ಎಸ್ಟಿಮೇಟ್ ಮಾಡ್ಕೊಳ್ಳಿ ಅಂತ.
ಅಲ್ಲ, but he confirmed the mutation in your favor. ಏನ್ ಬದ್ರಿ? By confirming the disputed mutation, thereby delegating private respondents to seek redressal of their grievances by approaching the civil court. And there is a serious dispute as to whether this land was originally owned by Sanjeevaya or Sanjeevi. Feeling aggrieved by the order of the assistant commissioner, fourth respondent assistant commissioner. Private respondents, private respondent number 1 assailed a remedy of revision by filing a revision before deputy commissioner under 136(3). Deputy commissioner, having adverted to the records, however, found that respondent number 1 is asserting title based on sale deeds of the year 1934, followed by a settlement deed. It is precisely in this background the deputy commissioner was of the view.
also they were not able to assert as to what the link is between Sanjeeva and.
Was of the view that respondent number 1 is able to substantiate as to how she's tracing a title over the petition land. Consequently, disputed mutation under MR number 1 of 2006 is set aside and revision is allowed. While allowing the revision, deputy commissioner has also made a passing remark that petitioner, though is asserting title based on the sale deed, his vendor's source of title is not forthcoming from the records.
No, my lord, deputy commissioner has not made that.
That's what he says, no.
No, ಅಧೀನ ನ್ಯಾಯಾಲಯದ ಕಡತವನ್ನು ಪರಿಶೀಲಿಸಲಾಗಿ
ಆದ್ರೆ ಯಾವುದೇ ದಾಖಲೆಗಳನ್ನು
ನಾವು ಡಿಸಿ ಮುಂದೆ ನಾವು ಅಪಿಯರ್ ಆಗಿಲ್ಲ ಸ್ವಾಮಿ. ಡಿಸಿ ಮುಂದೆ ನಾವು ಅಪಿಯರ್ ಆಗಲಿಲ್ಲ.
I'm noting it. I'll note it that you have not appeared.
Page 15, last 3 lines.
ಅದೇ
ಅಧೀನ ನ್ಯಾಯಾಲಯದ ಕಡತ ಪರಿಶೀಲಿಸುವಾಗ.
The said order is under challenge. The said order is under challenge. Learned counsel appearing for petitioner, while assailing the order of the deputy commissioner, has vehemently argued and contended that the order of the deputy commissioner is in gross violation of principle of natural justice. He would point out that a petitioner was never heard in the matter, and therefore the order being in blatant violation of principles of natural justice is not sustainable. Referring to the title document, he would point out that the petitioner is tracing title based on an absolute sale deed executed by his vendors, and therefore the mutation effected by Tahsildar, referring to this title document, is in accordance with law and clearly complies the mandate provided under section 128 and 129 of Karnataka Land Revenue Act. He has also tried to place reliance on the additional documents to substantiate that one is Sanjeevi, who is the legal heir of one Narsimhaya,
Wife of Narsimha.
who is the widow of Narsimhaya, was the owner, and after her death, his vendors have inherited the property, which is evidenced at which can be evidenced from the mutation. ಎಲ್ಲಿದೆ MR B, which can be evidenced from mutation under MR number 36/2005-2006. Citing this mutation, you would point out that his vendors were absolute owners who acquired right by way of inheritance, and therefore the deputy commissioner, without adverting to this mutation and the sale deed executed subsequently by his vendors, has passed an order thereby setting aside the mutation certified by the fourth Tahsildar Alva. Mutation is certified by fourth respondent Tahsildar. Next, per contra, London Council appearing for respondent number 1 has tried to effectively counter the petitioner's assertion and rights in the petition land. Referring to statement of objection filed by respondent number 1, you point out that the dispute in regard to the title over the property and possession is given quietus in an injunction suit filed by petitioner in OS 302 of 2014. You would further contend that though suit was one for injunction simpliciter, the trial court was called upon to advert to the title documents, more particularly the sale deed obtained by first respondent's ancestor, namely Rangappa, and the consequent settlement deed executed by Rangappa during his lifetime in favor of his two sons, namely Sanjeevayya and Hanmantayya. Next, having heard the counsels on record and under SCGP, the short point that needs consideration at the hands of this court is as to whether petitioner hearing based on a sale deed dated 22/5/2006 obtained from Anjanappa, Narsimurthy, Krishna D, Sushilamma, Gangamma, Gangappa, and Krishna can assert title and seek mutation in his favor. My answer is emphatically no. Though petitioner filed a bail suit for injunction, the trial court referring to rebuttal evidence, more particularly the sale deed obtained by first respondent's ancestor, followed by a settlement deed, which are marked at exhibit D3, D4, D5. This court is of the view that petitioner cannot agitate his rights in mutation proceedings. Petitioner, since there is a cloud with the title held by petitioner was required to file a comprehensive suit and substantiate his title over the property in question. The exercise undertaken by petitioner in getting his name mutated based on a sale deed which is disputed by the respondent number 1, cannot agitate his rights in mutation proceedings. On bare examination of the mutation at Annexure B, bracket MR 36/2005-2006, the said mutation appears to be clearly a fictitious document. This mutation is based on an order passed in RR 102. The said order is not forthcoming from the records. Interestingly, the mutation refers to the ownership of one Sanjeev, wife of Narsimha. While respondent number one's husband's name is Sanjeevaya, who is the elder son of the Rangappa who had obtained a sale deed way back in 1934. Admittedly, Rangappa had two sons, namely Sanjeevaya and Hanumantaya. The contention of petitioner that what was purchased by Rangappa was survey number 135, and therefore, in absence of documents indicating that this land was reassigned, survey number 63, first respondent cannot assert a right over this petition land appears to be an afterthought. The fact that there was no dispute in regard to identity of property in a bare suit for invention, this ticklish issue relating to identification of property cannot be examined in mutation proceedings. Next paragraph. Though an feeble attempt is made by the petitioner by placing reliance on these additional documents which are furnished along with the memo, unless a proper foundation is laid in the written statement by specifically pleading governments substantiating the nature of the documents which are now produced along with the memo, this court is not inclined to take cognizance of these additional documents. Next paragraph. Be that as it may, the trial court, the competent civil court in an injunction suit has declined to grant a decree in favor of petitioner. While declining to grant a relief, the trial court has taken cognizance of rebuttal evidence let in by first respondent, which are title documents which date back to 1934. Therefore, unless petitioner seeks a comprehensive relief of declaration and is able to demonstrate the right and title of his vendors in survey number 63, no indulgence can be granted in mutation proceedings. Nimdo ಹೆಸರಿತ್ತಲ್ಲ all along. Survey number 63, your name is mutated from ಎಲ್ಲಿವರೆಗಿತ್ತು?
No, no documents is produced before the trial court or before this court also.
ಇಲ್ವಾ?
ಇಲ್ಲ.
ಅಲ್ಲ, ನೀವು ಎಂಟ್ರಿ ಮಾಡ್ಕೊಂಡಿಲ್ಲ, ಅದಕ್ಕೂ ಮುಂಚೆ ಯಾರ ಹೆಸರು?
ಸಂಜೀವಿ ಕೋಮ್ ನರಸಿಂಹ ಅವರಿಂದ ಅವ್ರ ಮಕ್ಕಳಿಗೆ ಬಂತು, ಮಕ್ಕಳಿಂದ ನಾನು ಪರ್ಚೇಸ್ ಮಾಡಿದ್ದೆ. That's what I am trying to say, Your Honor. If that is there in their name, mutation or RTC in their name, why should I purchase that property, madam? They have also produced, not produced. The RTC is in their name. D10 to D13 is in my name.
ನಿಮ್ಮ ಹೆಸರು?
ನಮ್ಮ ಹೆಸರಲ್ಲಿ. I have a paper book, Your Honor.
ಬರ್ಕೊಡ್ರಿ. The counsel for petitioner at this juncture has brought to the notice of this court the decree rendered, judgment and decree rendered in OS 302 of 2014 is challenged by way of an appeal before this court, and same is pending consideration. This court, since this court is not inclined to grant indulgence, placing reliance on the judgment rendered in a bare suit for injunction, it is needless to mention that petitioner's right will be subject to the outcome of pending appeal before this court. With these observations, this court is not inclined to interfere with the order passed by the Deputy Commissioner. Writ petition giver in this upon extent. Okay. What's it for you? Yes, sir. ಯಾರು ಅಪೀಲ್ ಯಾರ್ದು?
So, ನಮ್ದು appeal.
Who are you? Plenty for dependent.
I am the dependent before the trial.
What is the suit for?
Suit decreed, my lord.
Suit is for what?
Declaration and injunction, my lord.
Declaration based on what? ಯಾಕ್ರಿ ಇದು ಪಾಟಾಡ್ ಮಾಡ್ಸಿದ್ರಿ? ಯಾರು ಮಾಡ್ಸಿದ್ರಿ ಪಾಟಾಡು?
ನಾನು ಇರ್ಲಿಲ್ಲ ಅವಾಗ.
ಆ?
So, my lordship in the
Yes, sir.
Paying for the appellant.
Where is the senior? ಇದು now I can recollect. ಅದು ಗೊತ್ತಾಯ್ತು. ಕೃಷ್ಣಮೂರ್ತಿ ಸರ್ ನೋಡಿದ್ಮೇಲೆ ಫ್ಯಾಕ್ಟ್ಸ್ ನೆನಪಾಯ್ತು. Yes, sir.
ಏನು ಆಗ್ಲಿಲ್ಲ, ವರ್ಕೌಟ್ ಆಗ್ಲಿಲ್ಲ, ಕಾಂಪ್ರಮೈಸ್
ಆಗಲ್ಲ ಅದು.
ಆಗಿದ್ರೆ
ನಾವೇ ಒಂದೇನೋ ತಪ್ಪು ಸರಿನೋ ನಾವೇ ಜಡ್ಜ್ಮೆಂಟ್ ಬರಿಬೇಕೀಗ. ಸರಿಯಾಗಿ ಬರಿಬೇಕ.
ತಾವು ಬರೆಯೋದು ಸರಿಯಾಗಿರುತ್ತೆ.
ಕಾಮನ್ ಸ್ಪೇಸ್.
ಕಾಮನ್ ಸ್ಪೇಸ್ adjacent, but admittedly we are the adjacent owners.
Yes, correct.
ಅಲ್ಲ ಅದಲ್ಲ, ನಾನು I'll bring it to lordship's kind notice.
You are able to figure out some more points in your
Yes,
favor.
Lord, yes. Lord, there are two things has to be looked into. Lord, I will give this signature.
Ready ಇದೀರಾ? ಫುಲ್ ರೆಡಿ ಇದೀರಾ? ರೆಡಿ ನೋ?
ಏನು ಶಾರ್ಟ್ ಪಾಯಿಂಟ್ ಇದರಲ್ಲಿ ವಿಶೇಷವಾಗಿ ಏನಿಲ್ಲ. ಬಟ್ Lord, the admitted position is we are the neighbors. And Lord, we are tracing title from different owners.
Correct.
And as far as they are concerned, up to Lord, I will give only brief dates and events. That's all, not in detail this thing. So it may be helpful to.
ಕಲೆಕ್ಟ್ ಮಾಡ್ರಿ.
Support of.
The boundaries and the measurements of the properties. Where can the state be produced and not?
There are two documents that are very important as far as according to me. One is the city survey sketch. City survey sketch, but city survey conducted in the year 1970. And my lord, the commissioner report submitted by the commissioner appointed by this report in the miscellaneous appeal, which was arisen out of the suit. If these two things are compared, Lord, it can be resolved. Now, Lord, please take I have given the synopsis, Lord, up to 1950. Their state list. Lord, this is the the first suit. The suit is filed by the plaintiff initially for the bare injunction. Now, last may kindly see the first that the prayer sought in the plain. Not the plain.
Now, there is no dispute in regard to your title, each other's title.
Not the measurement you dispute.
Only measurement is
Yes.
under.
Dispute, and there is no such dispute.
If the adjoining owner, you admit it.
So they also admit that I am an adjoining owner. We also admit, and they admit
Now,
that
there
we
are
are
no measurements. There are no measurements in your seal.
measurement and not the measurements.
How
not
long
me-
seal did it?
Their sale date, that is what, that is the point. Their sale, first time their sale date, measurement was disclosed only in the year 1956. From 1956, the measurement was given. We do not know from where they got that measurement.
And what about your measurements?
My measurement is there from the beginning.
1935.
From 1935, I have a document. I have a document from the year 1935. Measurement is there. Therefore, in 1956 is the first measurement. And in the measurement also, my lord, the vendors of this vendor says, I am giving this measurement. I am not responsible for any of the discrepancies in the measurement is their contention. Therefore, my lord, that is the reason why I said, your lordship may kindly see the prayer sought in the plaint. First, I will read only the plaint plot. First plaint nalli, it is a suit for bare injunction. Suit was filed on 6/11/19, 2001. The suit was filed on 6/11/2001.
Yes.
The prayer is, your lordship may kindly see the very prayer itself.
OS 16574.
Correct, 1657, correct. Is a prayer, wherefore it is prayed that the Supreme Court may be pleased to pass judgment and decree restraining the defendants, their agents, attorneys, henchmen, persons claiming under them, etc., permanently from putting up any construction by encroaching the suit schedule property.
Whether
which
this
is
plaint is amended, sir?
No, that's why I wanted to bring it. Yes, madam, it is amended. That's why I wanted to
No,
bring it.
now I don't have that copy. What you read now, I don't
That is
have
in the
it.
trial court record, it is there.
I'm reading it from the paper book.
The paper book that has not been filed.
That prayer is something different
Yes,
from
yes,
what
correct,
I'm
correct. Paper book ಹಾಕ್ಲಿಲ್ಲ ನೀವು?
ಏನು ಇದು ಪ್ಲೇಂಟ್ ಅಮೆಂಡ್ ಆಗಿದೆಯಾ?
Amend ಆಗಿದೆ. ಅದಕ್ಕಾಗಿ ನಾನು ಹೇಳೋದು. But the reason is, first, in the first blood, what is that they have amended is only the prayer and the schedule. All other,
According to you, no pleadings.
yes, madam. One first thing is there is no pleading. Second thing is even if for the schedule B, what they have stated in the plaint, amended plaint, absolutely there is no pleading. How they have carved out that 8 feet into 91 feet.
Where is the amended plaint to?
Amended plaint, madam, it is along with the, in the paper book itself, it is there. In the paper book, it is there. Ilva?
Yes, read it, sir.
Read.
Prayer is to declare the plaintiff is the owner of
ಅದು amended ಅದು.
and put the plaintiff into possession of schedule B.
ಅದು amended plaintiff. First plaint ನಲ್ಲಿ
ಹಾ.
injunction suit, ಬರೀ bare injunction suit filed on 6/11/2001. That's you got it. ಎಲ್ಲ ಬ್ಯಾಕ್ ಸೈಡ್ ನಲ್ಲೆಲ್ಲ ಸ್ಟಿಚ್ ಮಾಡಿರ್ತಾರೆ.
That to declare that plaintiff is the owner.
ಅಲ್ಲ, ಆಮೇಲೆ ಅಮೆಂಡ್ಮೆಂಟ್ ಮಾಡಿ.
ಇದಕ್ಕೂ ಮುಂಚೆನಾ?
ಡಿಕ್ಲರೇಷನ್ ಹೌದು. ಇದು
ಒರಿಜಿನಲ್ ಇದೆ ಎಲ್ಲಿದೆ ನಿಮ್ಮ ಹತ್ರ ಎಲ್ಲಿದೆ?
6/11/2001 ನಲ್ಲಿ ಇಟ್ ಇಸ್ ನಮ್ಮ ಹತ್ರ ಇದೆ. ಇಲ್ಲಿರ್ಬೇಕು.
ಅದೇ 6/11/2001 ಇದು ಇಂಜೆಕ್ಷನ್ ಸೂಟ್.
ಇಂಜೆಕ್ಷನ್ ಸೂಟ್ ಅದೇ ಬರೀ ಇಂಜೆಕ್ಷನ್ ಸೂಟ್ ಡಿಕ್ಲರೇಷನ್ ಕೇಳಿಲ್ಲ.
ಡಿಕ್ಲೇರ್ ಅಂತಿದೆ.
ಡಿಕ್ಲೇರ್ ಆಮೇಲೆ ಮಾಡಿದೆ, ಅಲ್ಲಿ ಬರ್ದಿದ್ದಾರೆ ಅಮೆಂಡೆಡ್ ಆಸ್ ಪರ್ ದಿ ಆರ್ಡರ್ ಆಫ್ ದಿ ಕೋರ್ಟ್ ಡೇಟೆಡ್ 5/11/2004 ಅಂತ ಬರ್ದಿದೆ.
Initially it was
Yes,
only.
yes. Initially, my lord, it is a suit for bare injunction. And the prayer is restrain us from putting up construction by encroaching. That's what the word used is by encroaching. But fact remains, my lord, on the eastern side is our property. It is not in dispute. In evidence also they have admitted. Eastern side of their property is our property. And there is no compound wall. According to them, they constructed the building in the year 1971 after obtaining the sanction plan, according to them. So on the eastern side, they say, eastern side they left 8 feet the setback for putting up the compound. Even till today, there is no compound wall. And my lord, in the year 1970, a city survey was conducted because this was earlier, my lord, it is a village area. Now, of course, it is a fully developed city. City survey was conducted during the year 1970. And it is an admitted fact. She has admitted in the cross-examination. It is true that city survey was conducted. And their number is 8088 of survey number 8088. Our number is survey number 8084. In both the document survey was conducted based on the title documents. And my lord, on the surveyor has pointed out, I have measured this document based on their title document produced, but both are reduced in the sense in the measurement. Therefore, he has identified their land is only 41 feet, not 48 feet. Ours is 46 feet. 50 feet is ours. Our land is 50 feet. There is 48 feet. Now, my lord, this is one aspect. This Honorable Court has also appointed a commissioner. Commissioner has also given a report. Now, my lord, what they have done is, in 6/11/2001, when they filed a suit for bare injunction, and the injunction was refused. Injunction was refused. And that was challenged before this Honorable Court in MA, when the MFA was filed. MFA was also rejected. In MFA, commissioner was appointed. Commissioner has submitted a report. Then this Honorable Court don't put up any construction, further construction. Trial court was directed to dispose of the suit. This was the order passed by this Honorable Court. Now, my lord, when the matter was pending in 2004, November 2004, they filed an application for amendment. Amendment is, will may kindly now see the suit, the relief sought. Except, my lord, the prayer portion, except prayer portion, no other amendment was made.
The relief of declaration is.
This is declaration, but declare that the plaintiff is the owner of B schedule property and put the plaintiff into possession of the B schedule property. So it presupposes that they are not in possession. And my lord, unless they explain, we disposes him or entered into possession after filing the suit.
It's a vacant land.
Vacant land, my lord, correct? That's what I'm saying.
Where is the physical possession?
No, my lord, the question is this. When we are the owner on the eastern side, they are on the western side, and they have put up the construction, vacant land is very much available. And my lord, on the back side, my lord, front portion was only vacant. In the back side, there is already a construction. My brother has constructed the property that it is 130 feet into 50 feet total land measurement. So therefore, my lord, on the eastern side land, it is a vacant land up to some portion. Remaining portion is a constructed area. Now they are saying that B schedule property, they say they have given a boundary for B schedule in the amendment application, and they are seeking for possession of that property. Now when they are then they have disposed, is the point for consideration. Suppose, my lord, if I am able to satisfy this Honorable Court, they were not in possession of this property, then suit itself has to be dismissed because of limitation.
The vacant land is symbolic possession, but the actual barrel.
No, my lord, I'll bring it to your lordship. Note how it has to be appreciated. No, my lord, this is the facts I will narrate to your lordship. Now, my lord, the symbolic possession will come into place when handing over of possession itself is disputed, but that is not the case in this. Here is a case of dispute between the neighbors. Therefore, now the measurement, as per the public records, what is the measurement available has to be looked into by this Honorable Court, because in the earlier sale, in their sale deed, up to 1956, there is no measurement. First time in the 1956, measurement has been shown. And in the cross, I will also take your lordship through the evidence of PW1. And my lord, the survey records, straight away, my lord, this is the prayer they have sought in the plaint. We have denied their contention. We have also stated, we have traced out the title, our title in the written statement. We said that it is barred by limitation, they are not entitled for relief. All these contention we have taken. Now, my lord, the PW1, your lordship, PW1 has been examined. Your lordship may kindly take the evidence of PW1. The evidence is nothing but repetition of the pleading. I mean, by way of affidavit. And apart from that, even otherwise also, I am entitled to take that contention. Even otherwise also, lordship can see it under Section 3 of the Limitation Act.
You can only Section 3.
But Section 3 of the Limitation Act, your lordship can definitely look into it. If I am able to satisfy this Honorable Court, possession itself is not maintained. Section 3, your lordship can look into it.
It is not as if my lord, it cannot be. Therefore, my lord, will ask may kindly come to, but there are two things in this evidence. PW1, page 78 onwards, will ask may kindly see.
Paper book.
Paper book ನೋಡಿ ಅಥವಾ ಅದರಲ್ಲಿ ನೋಡಿದ್ರೆ ಅದು ಯಾವ್ದಾದ್ರು ಪೇಪರ್ ಬುಕ್ ಒಂದು ಮನೆ ಸರಿ ಇಲ್ಲ. ಐ ಆಮ್ ವೆರಿ ಸಾರಿ ಫಾರ್ ದಿಸ್. ಏನೋ ಹಿಂಗೆ ಹಾಕ್ಬಿಟ್ಟಿದ್ದಾರೆ. Page 78 PW1. But what she has stated is that evidence must be in conformity with pleading. And this PW1 is the daughter of the plaintiff. Plaintiff is Murad, he is very hale and healthy. He is looking after the factory. He has given power of attorney in favor of his daughter. She was Murad, on the date, she was 33 years. She was not even born when the house was constructed. House was constructed even according to her in the year 1971. This affidavit is filed in 2004. She has no personal knowledge at all.
The suit based on title documents. How?
Allah, title document correct, but the question is the boundaries and when that is why I want. In 1970 there was a city survey. In the city survey, last may kindly see in this what they have the evidence I will say.
By filing a review petition before the competent.
Nevertheless, what is was declaration. Is any art of the review court is subject to the
revenue court allado, but anyway, measurement is anyway. I will take you.
You be sure you made a statement. You wanted to rely on.
I will take you last through that also. Well, now, Malad, the question is the giant developer. ಮಾಡಲಿಲ್ಲ ಅಂತಾರೆ ಅವರು. ಎಲ್ಲಿ ರಿಮಾಂಡ್ ಏನಾಯ್ತು? ಸೆಟ್ ಅಸೈಡ್ ಆಗಲಿಲ್ಲ ಅಂತ ರಿಮಾಂಡ್ ಮಾಡಿ ರೀಕನ್ಸಿಡರ್ ಅಂತ that is still pending consideration. That is one aspect. But now you will actually kindly see the PW1. I'm sorry that I was not knowing this. PW1 evidence. But what she has stated is not only tracing of title, whatever our sale deed says, first 1956 sale deed is 58 feet. Will actually kindly see the measurement of the first in point of time their property is measures. There are two, I have given that in the synopsis.
Better go through synopsis and then you can elaborate. Vishmurthy sir.
Yes.
Because I too will get acquainted with facts. Otherwise,
yes, please.
It becomes very difficult.
Yes. You will actually kindly come to first. I'll one by one.
Yeah, go through your synopsis and then you can elaborate.
Yes, yes. Lakshmi, kindly take synopsis. ಇದರಲ್ಲಿ plaintiff claimed and they are ಚುಕ್ಕಿಡ್ಬೇಕು ಬಿಟ್ಬಿಟ್ಟು colon title in pleading and evidence and documents ಅಂತ ಹಾಕಿದೆ ಮೂರು. On 2/1/1954, one Kalappa was the owner in respect of 4 items of the properties. That he
a common vendor,
huh?
Is he common vendor?
No, not a common. That is the question is here. If the common vendor, then we can find out where exactly the property comes. No, my lord, for them also there is a less property. For us also there is a less. If both are taken together, but that is the reason why I made a submission last time. Ultimately, it is a matter of calculation. My property, from 1935, I have traced the title. It is 50 feet into 130 feet. Their property initially, it was only no measurement initially. Only boundary was given. In the year 1954, Exhibit P19, there is no except boundary, no measurement. And 1955, Exhibit P20, here also there is no measurement. I have given that in the synopsis. And in 1956, the purchaser was Muniswamappa, but he has, there are 4 items. He purchased only item number 2 in the original listing. This is the property of the previous sale deed of Srimati Puttananjamma having the same boundaries in the purchase madidru. Then in this also I have mentioned. In the previous sale deed, the said property was sold as item number 1 as first
Single view.
item, one item ಮಾಡಿದ್ರು. However, in this sale deed, it has been bifurcated into two properties. First ಒಂದೇ ಐಟಮ್ ಇತ್ತು, ಆಮೇಲೆ ಎರಡು ಐಟಮ್ ಮಾಡಿ ಈ ಪ್ರಾಪರ್ಟಿ ಎಕ್ಸಿಬಿಟ್ P21 ಅಲ್ಲಿ ಮಾರಾಟ ಮಾಡಿದ್ರು. ಯಾವ್ದಾದ್ರು ಅಂದ್ರೆ the measurement of the property is given as east to west on the southern side 48 feet and the north to south 80 feet and adjacent to this east to west 18 feet and north to south as 30 feet. This is in exhibit P21, two boundaries were given. But as far as 18 feet into 30 feet, there is no explanation how this 18 feet into 30 feet they have got it. And in the evidence, first time she says, that is a part. Because otherwise, if my learned friend said it is not a part, then there is a matter. Because 48 into 80 feet, they are claiming 48 into 97 feet. How this 97 feet has come into existence is the question. 48 feet into, please see this, 48 feet into 80 feet ಆದರೆ 97 feet ಆಗಬೇಕಾದ್ರೆ ಎಲ್ಲರೂ ಬರಲೇಬೇಕಲ್ಲ ಪ್ರಾಪರ್ಟಿ.
Yes.
This is the first time in the measurement they have shown. There is no disclaimer. There is a disclaimer also in this sale deed. Says that if any boundary mistake is, I am not responsible. Is his contention, the vendor's contention, their vendor's contention. Then this property was sold to one Puttananjamma. This Munishamappa sold to Puttananjamma. They are claiming they have purchased from Puttananjamma. Puttananjamma sold one of the items to Manjappa measuring 48 feet into 80 feet, and this is also given. Then on 6/10/98, Puttananjamma sold another item of the property to Kanishmare number 2 Muniswami Gowda. This is 18 into 30 feet. Mele 80 into 48 feet. Kagade 18 into 30 feet. Two items. Then this Manjappa sold the property back to Puttananjamma. So Puttananjamma again she acquired this 48 feet into 30 feet. Sorry, 80 feet. Then this Puttananjamma sold the property to Pushpakantamma, where it sale deed dated exhibit P25. The measurement shown is 48 feet into 97 feet. This 97 feet will actually make no explanation how it has been come in the pleading also. There is no explanation.
From 80 to 97.
87, yes, ma'am. 48 to 97. 80 to 97 ಹೇಗಾಯ್ತು ಅಂತಿಲ್ಲ. Then Pushpakantamma sold the property to Channappa, that is not the plaintiff. As per exhibit P6, measurement continued to be shown as 48 feet into 97 feet, and eastern boundary is not our property. Sanjeevaya is our the appellant's father. Then the plaintiffs claimed that they constructed the building in the property, leaving 8 feet on the eastern side to be built compound wall. This is in the year 1971. From 1971 till now, they have not put up any compound, at least before filing the suit. But really they are the owners, nobody will keep the property open. Then the defendant's title I have given it here. And the next, please see this. On 24/12/1935, one Kempaya sold 2 extents of land measuring 40 feet by 80 and 40 feet by 60 feet to Muniamma and Timmaya. 1935 kinta ಹಿಂದೆ ಹೋಗೋ ಅವಶ್ಯಕತೆ ಇಲ್ಲ, because there is 1956. Then this the total area of the land measures 5,600 square feet. There was some reduction in this. Here also some measurement difference is there. I'll point out that also. Thus, Muniamma and her son Timmaya sold 2 properties to Sanjaya, that is to the respondent, that is the appellant before you watch. There, property 1 measuring 40 feet by 100 feet and 2 30 feet into 65 feet. Therefore, then the boundary will actually make it. The boundary of the property number 2 of the eastern side is bounded by Sanjeevaya's property. So totally measures 5,950 square feet. My lord, earlier measurement was, it is 5,600. Now this has become 5,950 feet. And in the next sale deed, my lord, after measurement, they again it is measured. 23/4/1961, Sanjeevaya sold the property out of larger extent to Ishwar Patri, so and so, east to west 36 feet, on the south 50 feet, north to south 130 feet, situated at 35th cross zone. So,
I think, Krishmurthy sir, you have to bring in a sketch. You have to show the location and then you have to refer to this title documents. Otherwise,
ಇದು ಕಷ್ಟ ಅಂತಾರೆ. ಅಲ್ಲ ಇನ್ನೊಂದು last may kindly see, because even otherwise, my lord, I will.
no point in running through the synopsis. India side ಬರುತ್ತೆ ಅದು. Last time we were able to see.
ಅಲ್ಲ ನಮ್ದು ಏನಂದ್ರೆ, I will show to your last that the sketch
East to west. That runs in length. No, east to west runs in length.
Yes.
It runs in length. North south is in width. All right.
My time is
No, the dispute is in width only, no.
my lord, the question is, it is there, my lord. it
East
is
to
there.
west.
Where do they get it?
Oh.
Primary document, what that document which they refer to and prime title, east west it is only 40 feet.
ಯಾವಾಗದು?
That is the crux of the matter.
1936 ನಮ್
Oh,
document.
you mean to say that both extents sold under two sale deeds, in width it is only 40 feet?
ಇಲ್ಲ ಇಲ್ಲ ಇಲ್ಲ.
Your argument.
Our argument ಅಷ್ಟೇ.
Our argument.
Our argument. But I will take your, your lordship may kindly see.
No, I'll go through the synopsis and I'll come back. You also come prepared.
I have also filed synopsis.
ನಂಗೊಂದು ಕಾಪಿ
ಎರಡು ಓದ್ಕೊಂಡು ಬರ್ತೀನಿ ನಾನು. ನೋಡಿ. ಇದು ಯಾವಾಗ ಆಗ್ಬೋದು? ಇದು 4 ಗಂಟೆ 4 o'clock.
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಯಾವ ತರ ತಮಗೆ ಯಾವ
ಕೆಲಸ ಮುಗಿಸಿ ಆಮೇಲೆ ನಿಮ್ದು
20ನೇ ತಾರೀಕು ಅಂತ ಯಾವ ತರ ಉಂಟು?
ಆಫ್ಟರ್ 20th ಆಗ್ಬೋದಾ ನಿಮಗೆ?
ಯಾವ ತರ ತಾವು ಹೇಳಿ?
ಆಫ್ಟರ್ 20th ಕೊಡ್ರಿ, ಆಫ್ಟರ್ 4 o'clock.
ಆಗ್ಬೋದು. ನಾವು ಸರಿಯಾಗಿ ನೋಡ್ಕೊಂಡ್ ಬರ್ತೇವೆ ಅಂತ.
ನೀವೆಲ್ಲ ಕೇಸ್ ಮುಗಿಸ್ಕೊಂಡು ಬಂದ್ಬಿಡಿ.
ಅಲ್ಲ ನಾವು ಸ್ವಲ್ಪ ಸರಿಯಾಗಿ ನೋಡ್ಕೊಂಡ್ ಬರ್ತೇವೆ ಅಂತ.
ಇದೊಂದು ಸ್ವಲ್ಪ ಫೈಲ್ ಹಾಕ್ಬಿಡಿ.
ಅಲ್ಲ ಸ್ವಲ್ಪ ಇದರಲ್ಲಿ ತಾವು ಒಂದೇ ಒಂದು ರಿಕ್ವೆಸ್ಟ್ ಅಂದ್ರೆ, ಅವ್ರೇನೋ ಸೆಟ್ ಅಸೈಡ್ ಆಗಿದೆ ಹೇಳ್ತಾರೆ, ತಾವು ಒಂದ್ಸಲ ನೋಡಿ ಅದನ್ನ ಸೇಲ್ ವಾಟ್ ಎವರ್ ಎಕ್ಸಿಬಿಟ್ D1 D exhibit.
Any findings of the very report is subject to.
That's correct, that's right, I am not disputing that aspect of the matter, but only thing is, when they came to know about the encroachment, that is the point. If they come to know in the year 1970, then where is the question?
Sir, the vacant site is the question.
ಅಲ್ಲ vacant ಅಲ್ಲ, 1970 ಮಲ್ಲ 90 according to them.
ಪ್ಲೀಡಿಂಗ್ ಎಲ್ಲ ಇಶ್ಯೂ ಇಲ್ಲ ಅದು.
ಪ್ಲೀಡಿಂಗ್ ಇಲ್ಲ, ಇಶ್ಯೂ ಅಲ್ಲ, ಅವ್ರು ಹೇಳೋದು ಅವರು ಅದಕ್ಕೆ.
Section 3 ಯಾವಾಗ, when you can invoke section 3 at what stage?
But if any time, even before the Honorable Supreme Court, I will have a judgment also on that. Even before the Honorable Supreme Court in a certain case.
The Order 7 Rule 11 limitation is available to you. Section 3 is available to the court. At what stage?
At any stage ಅಂತ ಹೇಳ್ತಾರೆ.
ನೋಡಿ.
ಜಡ್ಜ್ಮೆಂಟ್ ಇದು ಕೊಡ್ತೇನೆ.
They cannot.
ಅಲ್ಲ ನಾವು ಅಡ್ವಾನ್ಸ್ ಪೊಸಿಷನ್ ಹೇಳಿದ್ರೆ ನಾವೇ ಓನರ್ ಅಂತ, ನಾವು why should I say adverse possession? I cannot set up contract.
And it's a vacant open space between two.
Section 3 ನಲ್ಲೇ ಕ್ಲಿಯರ್ ಆಗಿದೆ, although its limitation is not set up as a defense.
ನೋಡ ಅದು ಕಡೆಗೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿ ಲಿಮಿಟೇಷನ್ ಮೊದಲು ಮೇನ್ ಇಶ್ಯೂಸ್ ಕೋರ್ ಇಶ್ಯೂಸ್ ಏನಿದೆಲ್ಲ
ಮುಂಚೆ ಫ್ಯಾಕ್ಟ್ಸ್
you argue and you finish up, then keep that limitation point at last.
Please.
Go to last next matter ಯಾವುದು? ಎರಡು ಕೊಟ್ಟೆ
ಡೇಟ್ 20 sir.
44. Yes sir.
I have completed my argument, no, it is only for the respondents to.
ಇದು ಏನ್ ಸರ್, ಇದು SM ಸರ್ ಏನಿದು?
Lord,
ಇದು
remand of granted land to the, my lord, the tribunal. We have questioned the order of remand by the appellate tribunal. That is Karnataka Revenue Appellate Tribunal. We say, my lord, the question of remand at the instance of a purchaser will not have, alleged purchaser. Because the landowner has not questioned the order of grant.
Not
and section 4 of the Land Reforms Act.
You are relying on section 4.
Yes. And suit for possession is also rejected, and that has become final.
Final. ಇವತ್ತು ಬಂದಿಲ್ಲ ಅವರು. Anything more from your
That's all, my lord.
That's all.
Yes.
Dictating and ಇಟ್ಕೊಳ್ತೀನಿ ನೋಡ.
Please.
You're done with your duty. You
Yes.
can keep your instructing counsel
Please.
present.
Please.
If I have
If there is
doubts, then I
any
will-
doubts, my lord, I will.
ಆಯ್ತು ನೋಡೋಣ ಡಿಕ್ಟೇಟಿಂಗ್ ಜಡ್ಜ್ಮೆಂಟ್ ಅಂತ ಹಾಕ್ಬಿಡ.
Please.
Keep this.
My lord, could it be
That is one of the doing this. Case 45.
The respondents have filed an IA seeking modification and recalling the order as passed by this honorable court. They had approached in writ appeal, and in the said writ appeal, the court sought whether you had filed an application for modification, and based on such direction, the matter was disposed of in writ appeal. And herein they have filed an application for modification of order.
You know what modification there?
My lords, the modification of order is dated 23/8/2022.
Where is that order?
The order sheet it is there. Order sheet. Plus the facts of the case is 268, survey number 268/1, totally measured 3 acre 22 guntas. Out of that, the respondents have subsequently purchased one, the petition number 1 is abated, my lords. I am appearing for petition number 2. Petition number 1 and his father had acquired 268/1 to an extent of 3 acre 20 guntas. No dispute with regard to that. There was an alienation of 1 acre and 2 acres 17 guntas by the landlord, father of the petitioner, in favor of which has culminated in the hands of the respondent, contesting respondents here. So totally, out of 3 acre 22 guntas, 3 acre 17 guntas has been acquired by the respondent.
Just let me see what is this order, 23/8/2022, third order.
Order sheet.
Main matter pending ಇದೆಯಾ?
Main matter pending. Because this order was an inter se, this was not called upon by the petitioner. The court, after observing the facts of the case and considering the impugned order, was pleased to pass this order. I had not filed any IF seeking for the passing of the order dated 23/8/2022.
ಇದು ಸಾಹೇಬ್ ಮುಂದೆ ಹೋಗ್ಬೇಕಲ್ಲ, ರಿಕಾಲಿಂಗ್ ದಟ್ ಆರ್ಡರ್ ಅಂದ್ರೆ ನಮ್ಮಂದ ಹೆಂಗ್ ಬರುತ್ತೆ? ಯಾವ್ದೋ ಸಾಹೇಬ್ ಮಾಡಿದ್ರು ಅದು.
Actually, this order should go to the concerned bench. Because this order was passed. Yes.
Substantial, that's a detailed order.
Yes, my lord.
Now let us see what is the interim order.
The same set of facts is filed a suit for declaration.
Appeal is pending. Appeal is pending.
And the impugned order says that it is subject to the decision of.
Now let me see what is the interim order first. Okay, we'll hear the main matter also.
Main matter I dispose ಮಾಡ್ಬೋದು.
Main matter dispose ಮಾಡಿ.
What happened to this order? Whether survey is conducted?
No, my lords. In the meanwhile, they went in appeal.
That was stayed.
Appeal is stay ಆಗಿತ್ತು. And subsequently, my application hakkolu.
All right, what is the suit for?
Suit for declaration
And injunction.
and injunction.
And what this proceedings arise out of?
136 proceedings.
136,
136.
mutation proceeding.
Yes.
And what happened to the suit?
Suit is dismissed. My lords, I'll explain my lord, my case, my lords. Out of 3 acre 21 guntas, respondents have acquired 3 acre 7 guntas. No dispute with 17, sorry, 17 guntas. 5 guntas was proposed for acquisition by the railways. I have produced the document. Subsequently, the railways pass an official memorandum stating we don't require this 5 guntas. Since the railways has not, there is an official memorandum with regard to the effect that 5 guntas has not been used. Thereafter, I got the landlord, that is the petition number 1, got mutated his names. Now, what happens here is, my lords, the respondents challenge it before the AC. The AC sets aside the mutation on the ground that some road has been formed. Our title ಇದೆ, our land ಅಲ್ಲಿ road form ಮಾಡಿರ್ತಾರೆ. ಅವ್ರಿಗೆ ಲ್ಯಾಂಡ್ ಇಲ್ಲ, ಅವ್ರ ಜಮೀನಲ್ಲಿ ರೋಡ್ ಹಾದಿ ಹೋಗುವ ದಾರಿ ಇದೆ. ಹಂಗಾಗಿ ಈ 5 ಗುಂಟೆ ಇವ್ರಿಗೆ ಮುಟೇಶನ್ ಮಾಡಕ್ ಬರಲ್ಲ ಅಂತ ನಮ್ಮೇಲೆ ಆರೋಪ, ನಮ್ಮೇಲೆ ಬಲೆ ಬೀಸ್ತಾರೆ. See, what happens is, road is formed in their land by the state, not by me. My 5 guntas is towards boundaries described.
What was the subject matter of the suit?
Subject matter of the suit was on the ground that the land has been acquired by the railway
No,
department.
what is the subject matter of the suit?
5 guntas, 5 guntas, 5 guntas.
Now what happened? What is the finding of the trial court now?
The trial court says there is no,
Judgment, where is the judgment?
I produced along with the memo dated 2/8/2020. Says that there is no land in excess of 3 acres 70 both the survey.
why it says is because 5 guntas is acquired by the railways on that ground, on the premise that 5 guntas has been acquired by the railways. The declaration suit has been dismissed against me. However, 5 gunta railways ತಗೊಂಡಿಲ್ಲ.
ನೀವು mutation ಅಲ್ಲಿ ಯಾಕೆ ಫೈಟ್ ಮಾಡ್ತೀರಿ ಈಗ?
ಅಲ್ಲ, that is the reason this honorable court on an earlier occasion was pleased to pass for survey, joint survey by railway department as well as the
28 proceedings ಇದು ಇದರಲ್ಲೆಲ್ಲ sketch ಹೆಂಗ್ ಬರುತ್ತೆ?
ಅಲ್ಲಲ್ಲ, because there was a dispute.
Wait a minute. If you have not filed a suit based on this order, maybe this court
Yes.
would have given a thought about it. Because you approved the civil court, you have filed a comprehensive suit.
I have filed a suit.
ಎಲ್ಲಿದೆ ಅದು? ಸುಮ್ಮನೆ ಟೈಮ್ ವೇಸ್ಟ್ ಮಾಡ್ಬೋದು. ಎಲ್ಲಿದೆ ನೋಡಿ?
2/8/2020. Case number 6.
Sir, your rights will be subject to outcome of the appeal. If you
My lords,
filed in a.
my lords, my submission is kindly peruse impugned order. What the DC says is there is a road formed in the land. So thereby this 5 guntas cannot be your entitlement. Whose land for formed road?
Now we have to take note of the adjudication done in a civil proceedings.
Appeal is
Forget
pending.
about all pleadings in the writ petition also. Where, what was the release not by you? Declaration and permanent injunction.
Declaration permanent.
What is the schedule?
Schedule is 5 guntas, my lord.
There is the matter. What is the finding then? ಸುಮ್ಮನೆ time waste ಮಾಡಬೇಡಿ ನೀವು.
Title established ಮಾಡಕ್ಕಾಗಿಲ್ಲ ಅಂತ.
Who did
My lords,
dismiss?
my title is with regard the revenue department, my lords. Acquisition, there also the trial court comes to the.
The subject matter is 5 guntas in a comprehensive suit.
My lords, I'll demonstrate.
You want me to decide as a writ court,
Allala, I'll demonstrate why I can be entertained under 136 proceedings. I will demonstrate because the order of the DC says road ಹೋಗಿದೆ 5 ಗುಂಟೆ ಇವ್ರದಿದೆ. The DC admits the total extent. The DC admits, the deputy commissioner admits they have title only to with regard to 3 acres 17 guntas. Now to placate them in view of road formed in their land.
What's your good name?
Vinod, my lord.
Vinod?
CS Vinod. No, I'm petition number 2.
ಏನೀಗ 128 proceedings ಅಲ್ಲಿ ನಾನು I have to find out whether 5 guntas is written by you.
5 guntas there, it is there.
I have to hold an inquiry to find out whether that 5 guntas is there. Available.
Document speaks 5 guntas is there with me.
Ah?
Document speaks, kindly peruse the order passed by the railways.
Mister, you have suffered a decree, sir. What is this? What is your problem?
My lords, I have suffered a decree on the premise that the land has been acquired by the railways.
You agitate, that may be erroneous finding.
Railways themselves have given an order.
Might be erroneous finding, sir. It has to be reversed by appellate court under section 96.
My lords, I'll demonstrate.
What?
the
No,
extent.
nothing doing with.
Allah, madam, my lords, the impugned order passed by the AC and the DC says road has been formed, so you are not entitled. Their land and road
They are not competent revenue proceedings ಅಲ್ಲಿ road formed open space available ಇದೆಯಲ್ಲ ಅಂತ ಅದನ್ನೆಲ್ಲ enquiry ಮಾಡಬಹುದು 128 ಅಲ್ಲಿ.
It's not available.
That's one without jurisdiction, sir.
My lords, it's with regard to an.
Come on, the suit suffer ಆದ್ರೂ you are holding the field and you are not living. What is it?
My lords, I'm not holding on that
Pardon?
premise, my lord. I'm not.
ಮಾಡಿನೇ ನೀವು ಇವೆಲ್ಲ ಕೇಸ್ ಯಾವುದು ಬರೆಯಕ್ಕೆ ಕೊಡಲ್ಲ ಆರ್ಡರ್.
ಅಲ್ಲ ಇದ್ರಲ್ಲಿ ಏನಾಗಿದೆ?
ಏನೂ ಆಗಿಲ್ಲ.
Submit ಆಗಿದೆ.
Lost. ಏನಾಗಿದೆ ಹೇಳಿ? You have lost.
I have lost a suit. I have filed an appeal.
Please, I will relegate you. You agitate, and you're entitled to get your name mutated subject to outcome of the appeal. Have you preferred an appeal?
Yes, madam. Appeal is preferred.
Where is the matter? ಇದು ಯಾವಾಗ ಆಗಿದ್ದೀರಿ? ಯಾವಾಗ ಹಾಕಿದ್ದೀರಿ ಅದು? ಓ, 2022 ದಲ್ಲೇ ಫೈಲ್ ಮಾಡಿದ್ದೀರಾ? 2 ವರ್ಷದಿಂದ ಇದು ರಿಟ್ ಪೆಂಡಿಂಗ್. ವಿನೋದ್ ಬಿಟ್ಟಿಲ್ಲ ಅನ್ಸುತ್ತೆ. ಗಲಾಟೆ
ಇಲ್ಲ.
ಮಾಡಿದ್ರು.
Nothing like that.
ಗಲಾಟೆ ಮಾಡಿದ್ರು.
ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್ ತಗೊಂಡೇ ಇಲ್ಲ ಸ್ವಾಮಿ.
ಅಲ್ಲ, ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್ ಅಲ್ಲ, ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿದೀರಾ, ಗಲಾಟೆ ಮಾಡಿ. ಅದಕ್ಕೆ ಜಡ್ಜ್ ಬೇಡ ಬಿಡಿ ಅಂತ ನೋಡೋಣ ಅಂತ ಬರ್ಕೊಡ್ರಿ. ದಿ ಕ್ಯಾಪ್ಷನ್ ಪೆಟಿಷನ್. In the caption petition, 5 guntas of land in survey number
268/1.
268/1 is the disputed portion. In view of rival claim, petitioner is before this court assailing the order of
The deputy commissioner.
assistant commissioner ನಿಮ್ಮ ಪರವಾಗಿತ್ತಾ?
Assistant commissioner, both AC and DC.
Assailing the order of assistant commissioner and deputy commissioner.
Yes.
Insofar as 5 guntas is concerned. It's quite interesting to note that petitioner has rightly approached a competent civil court and has filed a comprehensive suit seeking relief of declaration of title over the very petition land and for consequential relief of injunction in OS 61 of 2006.
There are 2 suits.
Who had filed the other suit?
Other suit is filed by second.
Allah, petitioner 1 and 2. Petitioner 1 and 2. Totally 5 guntas.
All right, petitioners have filed 2 suits in OS 61 of 2006 and OS 271 of 2006, seeking relief of declaration injunction. The primary dispute in the comprehensive suit is as to whether issues alidari at what page? Issues alidari.
Issues page number 11.
The primary issues, the core issues are as to whether a petitioner herein who are the plaintiffs are able to substantiate that they are the absolute owner of the suitable property, and whether plaintiffs are able to substantiate that they are in possession of the suitable property as in the date of the suit. These 2 core issues in both the suits are answered against the petitioner's hearing. While answering these 2 issues in the negative, the court in both the suits has held that the petitioner's hearing have failed to substantiate their title over the suitable property and also possession. Suits are ultimately dismissed. In the light of dismissal of these 2 suits, there is no scope for any further inquiry in regard to petitioner's right and title over 5 guntas of land in mutation proceedings. Though counsel appearing for petitioner has vehemently argued and tried to persuade this court that dehorse adjudication by a competent civil court, this court can still examine the petitioner's right over 5 guntas of land. This court is not inclined to grant any indulgence. This court is aware of its limitations, having regard to the fact that this caption petition arises out of mutation proceedings pertaining to survey number section arising out of mutation proceedings and the mandate, and therefore this court has to confine the inquiry as mandated under section 128 and 129. Since comprehensive suits are dismissed, petitioners have to seek their rights addressed in pending appeal, if any.
pending appeals.
In the
We have
event,
filed.
in the event petitioners succeed and are able to substantiate that they are the owners and in spite of acquisition, they have retained 5 guntas of land.
Acquisition dropped. Acquisition and acquisition dropped.
In spite of acquisition and
Subsequently dropped
subsequently dropped.
by
If
the
they are able
railways.
to substantiate that they have still retained 5 guntas of land.
My lord, sir, by the railways.
Consequence.
Acquisition was by the railways, not by the state. Acquisition.
The consequences will follow.
Yes.
The
This is my contention. This. Document ಇದೆ. Document ಇದೆ. Document ಇದೆ.
ನಾವು ಅವರಲ್ಲಿ ಮಾಡ್ಲಿ ಬಿಡಿ ನಾನು ಡ್ರಾಫ್ಟ್ ಅಂತ ಬರೀ acquisition.
Dropped ಅನ್ನೋದಕ್ಕೆ ಡಾಕ್ಯುಮೆಂಟ್ ಇದೆ. ಅವ್ರದೇ ರೈಲ್ವೇಸ್ ಡಾಕ್ಯುಮೆಂಟ್.
That is to be adjudicated. You have to succeed. If your appeal is allowed, you are entitled to get your name mutated. ಅಷ್ಟೇ ವಿನೋದ್. ಅವ್ರು ಒಬ್ರು ತೀರು ಹೋಗಿದ್ರಲ್ಲ ಅದು ಕನೆಕ್ಟೆಡ್ ಅದ್ರಲ್ಲಿ ಏನಾಗಿದೆ?
ಅವ್ರು ಬಂದಿಲ್ಲ. ಅಬೇಟ್ ಆಯ್ತು.
ಅದು ಯಾವ್ದು?
3 guntas.
ಯಾವ್ದು?
First number 45382 is for petition number 1.
However, it is made clear that petition against first petitioner is dismissed as abated. Dismissed as abated. Yes, sir.
Kalburgi bench matter relating to Milord's issue.
ಏನ್ರಿ?
2 year certificate.
ಕರೆಕ್ಟ್. ಅದು ಈಗ ಬೇಡ. Some other day. ಗಾನಿಗಾನ ಅದು ಯಾವ್ದು? ಹಿಂದೂ
Insofar as our case is concerned, my lords, we are Sadar, Lingayat Sadar.
ಹಿಂದೂ ಸಾದಲ್ಲಿ ಕೆಲಸ.
In fact, my lord, the judgments which are referred to by the Honorable Supreme Court in my favor only.
Let's see.
Please.
Lords, this is the matter, my lords. In 2011, I am the auction purchaser. I purchased the property.
Correct.
Illegal occupant.
All right. You need some more time. All right. Yes. Next.
Achha.
48 totally. Patel. ಯಾವುದು? ಟೈಮ್ ಕೇಳಿದ್ರು ಅವರು. ನೆಕ್ಸ್ಟ್ 49 ಕರೀರಿ. ಎಷ್ಟು ಬಂದಿದೆ? 3. ಹನುಮಂತಪ್ಪ.
Sorry, my lord. The petitioners or owners of the property, my lord, survey number 57/3, measuring 5 acres 33 kunta, my lord, at the Shivapura village, the Amrutara Hobli, Tarike Taluk, my lord.
ನೋಡಿದಿರಾ ಏನ್ ಮಾಡಿರೋದು? ಕಾಪಿ ನಾಟ್ ಸರ್.
Really, madam, ಕೊಟ್ಟಿದೆ.
ಇಲ್ಲ ಓಪನ್ ಕೋರ್ಟಲ್ಲಿ ಕೊಟ್ರೆ ಐ ವಿಲ್ ಹಿಯರ್ ಇಟ್.
ಕಾಪಿ ಕೊಟ್ಟಿದ್ದೀನಿ ಅವ್ರಿಗೆ.
ಅಲ್ಲಿ ಕೊಡಂಗಿಲ್ಲ ಅಲ್ಲಿ.
ಇಲ್ಲಿ ತಂದು ಕೊಟ್ಟಿದ್ದೆ ಸ್ವಾಮಿ ಅದನ್ನೇ.
ಇಲ್ಲೇ ಕೊಟ್ಟಿದ್ದೀರಿ?
ಹೌದೌದು. ಮೇಡಮ್ ಹತ್ರ ಇದೆ ಸ್ವಾಮಿ.
ಏನ್ರಿ ಇಲ್ಲಿ ಕೊಟ್ಟರು ಡಿಸ್ಪ್ಯೂಟ್ ಮಾಡ್ತಿರಲ್ರಿ?
ಮೇಡಮ್ ಹತ್ರ ಇದೆ ಸ್ವಾಮಿ. 890.
ಓದ್ಲಿಲ್ವಾ? ನೋಡ್ಬೇಕಿಲ್ಲ ನೀವು. 230 ಮೂವ್ ಮಾಡಿ.
Entertaining, my lord.
What is the urgency?
Entertaining, my lord, the second RA, the first RA reject, my lord, is it? Kindly see, my lord, wherein? The annexure, my lord, B.
First, who are you? What is your right?
Petitioners or the owners of the land, lord, owners of the land in question.
Based on what?
Basing also the earlier, my lord, regarding the ancestral property of the traditional grandfather. This is grandfather, my lord. One, my lord, Dodda Muliyappa is the ancestral property. Then of death episode, the Muligere Palator, then the property falls to his petitioner's father, Maliyappa. Can you see Anex N matter? Anex N page number, my lord, wherein Anex N it is. The record of race is wherein Anex N, my lord, page number. Annex N, my lord, N, page number 97. This property falls here, my lord, Dodda Muliyappa. My lord, survey number 57/3, 5 acres 33 kuntas. My lord, the respondent number 58 have filed an appeal before they show the assistant commissioner for challenging the entries. It was rejected. Already, my lord, the 29/10/2023, my lord. Annexure B, stating that relegating the parties go to the civil court, my lord. Then in this order, my lord, respondent 528 to report RP before the second respondent. It is pending, my lord. before the RP number 17 of 2024. During that period, my lord, she another area, my lord. She filed another RA, annexure, my lord, fee, page number, my lord, 156, my days.
Yaru before Assistant Commissioner.
Oh, please, my days. He passed his second order, my lord, it is. Annexure W, my lord, it is.
Amale he certifies mutation.
Please, my lord, it is. Entering their names in my name, my lord. Sending in my name, changing my name yesterday, my lord, it is on 10/1/2025. Without hearing the property, my lord. That is bad in the implement, it is.
Where is that?
Annexure B, W, my lord, it is.
That revision pending before Deputy Commissioner Ellie there though.
Annexure B, my lord, annexure C, my lord, it is. Annexure C. Page number 30, my lord, it is. 30. Today it was hearing, my lord. It was adjourned before the DC.
Yes.
Please, please.
The informed order has got alternative remedy.
Huh?
Alternative remedy, this is an order passed by the AC under 136.
No. This is the fit case to examine under 227.
This order.
ಒಂದು ಅಪೀಲ್ ಅಸಿಸ್ಟೆಂಟ್ ಕಮಿಷನ್ ಮುಂದೆ ಡಿಸ್ಮಿಸ್ ಆಗಿ ರಿವಿಷನ್ ಹಾಕೊಂಡಿದ್ದಾರೆ ಅವರು. ಮತ್ತೆ ಅದನ್ನ ಹಾಕೊಂಡು ಇನ್ನೊಂದು ಆರೆ ಹೆಂಗ್ ಹಾಕ್ತಾರೆ? ಫಸ್ಟ್ ಆರೆದಲ್ಲೂ ಸೇಮ್ ಮುಟೇಷನ್ ವಾಸ್ ಚಾಲೆಂಜ್.
Please, Matis.
Earlier AC, how that the AC order came to be ended, my lord. The appellants, that is the revision petitioners himself closed the review petition saying that we will agitate before the civil court. That is how the earlier review petition before the AC came to an end.
No, it was 136 to appeal ಅದು.
ಅದರಲ್ಲೇನೆ ಇವರು ಪಾರ್ಟಿಗಳು ನಾವು ಸಿವಿಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಎಜಿಟೇಟ್ ಮಾಡ್ತೀವಿ.
ಅದನ್ನ ಆಯ್ತಲ್ಲ ಮತ್ತೆ ಅದು ಕ್ಲೋಸರ್ ಆಯ್ತು.
ಆಮೇಲೆ ಅವ್ರು ಸಿವಿಲ್ ಕೋರ್ಟ್
ಅಲ್ಲ ಬಟ್ ಆರ್ಡರ್ನ ರಿವಿಷನ್ ಯಾರು ಡೆಪ್ಟಿ ಕಮಿಷನರ್ ಬಂದು ಯಾರು ಚಾಲೆಂಜ್ ಮಾಡಿದ್ರು? ಇದು ಅನೆಕ್ಸರ್ ಸಿ ಯಾರು ಹಾಕಿರೋದು ರಿವಿಷನ್?
Annexure 5 to 8, Matis. Phone number 5 to 8.
They are filed.
Please, Matis. They are filed.
ಅಪೀಲು ಅವ್ರದೇ ಇತ್ತಾ?
ಹೌದು, ಅವ್ರದ್ದು ಅಪೀಲ್ ಅವ್ರದೇ.
ಅಸಿಸ್ಟೆಂಟ್ ಕಮಿಷನರ್.
ಹೌದು. ರಿಜೆಕ್ಟ್ ಆಗಿದೆ ಅಪೀಲ್ ಅವ್ರದ್ದು.
ಅದೆಲ್ಲಿದೆ ಅದು?
Annexure B, Matis. Annexure B, page number 29. ಮೇಲ್ಮನವಿಯನ್ನು ತಿರಸ್ಕರಿಸಿದೆ. ದಿ ಆರ್ಡರ್ ರೆಸ್ಪಾಂಡೆಂಟ್ 5 to 8 ಪ್ರಿಪೇರ್ಡ್ RA. ಮೇಲ್ಮನವಿಯನ್ನು ತಿರಸ್ಕರಿಸಿದೆ. ತರೀಕೆರೆ ತಾಲೂಕು ಅಮೃತಾಪುರ
ಆದೇಶಿಸಿದೆ. ಅಪೀಲ್ ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ ಮೇಡಮ್. No, correct, whatever it is now already ಅದು ರಿವಿಷನ್ ಹಾಕಿದಾರಲ್ರಿ, ಈಗ ರಿವಿಷನ್ ಹಾಕಿದಾರಲ್ರಿ.
That is after the remand from the, after the outcome of the civil court order, my lord.
ಅಲ್ಲ.
This order.
Can you see that? Annexure C, Matis. Miss.
The bottom.
ಈಗ ಫ್ರೆಶ್ ಆರ್ಡರಾ?
Please, Matis. First order, please.
ಇದ್ರಲ್ಲಿ ಏನ್ ಮಾಡಿದಾರೆ ಈಗ? ಅಲ್ಲ ಒಂದ್ ನಿಮಿಷ ಹೇಳಿ, ನನ್ಗೆ ಯಾವ ಮ್ಯೂಟೇಶನ್ ಚಾಲೆಂಜ್ ಮಾಡಿದಾರೆ ಹೇಳ್ಬಿಡಿ. ಜಮೀನಿಗೆ ಖಾತೆಯನ್ನು ಪಾವತಿ ಸಬೂಬು ಬದಲಾವಣೆ ಮಾಡಲು ಇದು ಇಲ್ಲೇ ಒಂದ್ ನಿಮಿಷ ಇಲ್ಲೇನ್ ಹಾಕಿದ್ರಿ ನೋಡೋಣ. ಇವು ತಾಲೂಕಾ ಎಕರೆ ಜಮೀನನ್ನು SR 54 ರಂತೆ ಖಾತೆ ಬದಲಾವಣೆ ಮಾಡಲು ಕೋರಿ ಮೇಲ್ಮನವಿ ಸಲ್ಲಿಸಿದ್ರು.
Against the AC item, are you pending, Matis? Are you pending?
No, but there can't be two appeals.
No, see how the my understanding is misleading.
No, my lord.
One appeal came, that is, they have withdrawn the review petition before the AC saying that we will agitate the matter before the civil court. That is forthcoming in page 29.
ಯಾರು ರಾಮಪ್ಪ ಅಲ್ಲ? ಆಯ್ತು, ಅವ್ರು ವಿಡ್ರಾ ಮಾಡ್ಕೊಂಡು ರಿವಿಷನ್ ಯಾಕೆ ಹಾಕಿದ್ದಾರೆ? ಒಂದ್ ನಿಮಿಷ. ಇಲ್ಲ ಅವ್ರ annexure come to annexure C. Come to annexure C. They have challenged this order, Assistant Commissioner order.
But before the Ramappa agitated the right before the civil court. There they have won the matter. Again that as per the
ಡಿಗ್ರಿ
High Court
ಇದೆಯಾ?
order-
ಈಗ ಡಿಗ್ರಿ ಇದೆಯಾ? ಎಲ್ಲಿದೆ ಡಿಗ್ರಿ ಅವ್ರ ಪರವಾಗಿ?
No, my lord. No decree, Matis. OS pending, Matis. OS pending. 2 to 6, Matis. Can you see, my lord, wherein annexure 103, Matis.
ಎಲ್ಲಿದೆ? ಸೂಟ್ ಡಿಗ್ರಿ ಎಲ್ಲಿದೆ ತೋರಿಸ್ಬಿಡಿ.
ಇಲ್ಲಿ ಬರ್ತಾರ ಅವ್ರು ಮತ್ತೆ.
Offered RA with OS, my lord, it is. It is pending. Page 103, annexure R, it is. For declaration injunction.
That is writ petition number 2866/22.
Ah.
This is also very recent order.
My lord, In that
one
writ,
niಮಿಷ.
please.
ಎಲ್ಲಿದ್ದೀರಿ?
Operating portion of the AC's order. It clearly says that, my lord.
165.
Operating
ಇದೇನಿದು?
Middle of the operating portion, my lord. ಸದರಿ ಜಮೀನಿನ ಖಾತೆಯನ್ನು ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ರಿಟ್ ಪಿಟಿಷನ್ ನಂಬರ್ 2866/23.
ಇದು ಯಾವ ಆರ್ಡರ್ ಇದು? ಡಬ್ಲ್ಯೂ ಯಾವ್ದು ಆರ್ಡರ್ ಇದು?
My lord, in this order,
9/1/2025 ಇದು.
please, madam, the respondent number 58 have challenged my compromise decree before this court, my lord. In that, my lord, is remanding matter to the trial court for first consideration. That's my lord. There was a compromise decree, my family members, that challenge before this court, my lord. That is disposed of, that is without asserting the rights. You can assert all rights before the civil court. Who is pending, my lord, is the fight for the respondent 58. Who is pending for declaration?
After the remand, after the seeking permission before the earlier AC, my lord, they approached the civil court. It is forthcoming in the very order, my lord. They have preferred OS number 99/23, and that came to be dismissed. That again they appeared before the High Court, my lord. High Court, in that
Confusing.
court, High Court has given direction to agitate the matter again before the AC. Accordingly, the AC has passed the order. It is forthcoming in the very order, my lord, 163 pages, very well.
ಎಲ್ಲಿದೆ? ಯಾವ ಸೂಟ್ ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ ಈಗ?
My lord, no, yellow pending family, the respondent 5 to 8, my lord, they have filed suit, my lord, is for declaration injunction. This pending consideration, my lord, and it is very, my lord, can you see? No, madam is confusing, my lord, is.
Telling, I am reading the outright orders.
Madam confusing, my lord, is.
Finding given by the AC, my lord.
ಹನುಮಂತ ಅವ್ರು ಮಂಡೇ ಸೋಮವಾರ ಹಾಕೊಳ್ಳೋಣ, ಸ್ಯಾಟರ್ಡೆ ಸಂಡೇ ಬರೀ ನಿಮ್ ಫೈಲ್ ಓದೋಣ.
Please, my,
ಒಂದೇ ಫೈಲ್.
my lord, madam is misguiding, my lord, confusing my case, my lord.
ನಾವು ಕನ್ಫ್ಯೂಸ್ ಆಗೋದ್ ಬೇಡ ಅಂದ್ರೆ ನಾನು ಓದ್ಕೊಂಡ್ ಬರ್ತೀನಿ ಅಂತ.
Please, my lord,
I'll go through the file and come. We'll
Please,
discuss on Monday.
please, my lord.
Monday ಮಾಡ್ಬೋದಾ?
I'm prime not some. I mean, there's simple matter, my lord.
ಸಿಂಪಲ್ ಅನ್ಸ್ತಾ ಇಲ್ಲ.
Allala, madam confusing, my lord, my lord.
We'll list it on Monday.
Please, great, my lord, great, my lord.
ಅವ್ರಿಗೆ ಮಾತ್ರ ನೋಟಿಸ್ ಕೊಡೋಣ.
ಆಗ್ಬೋದು ಸ್ವಾಮಿ. And in the meanwhile, I sought to interim stay of this W.
Monday ಕೊಡೋಣ.
Please, my lord, great.
Monday will examine.
Please, my lord.
Leonard, AG is directed to accept notice to respondents 1 to 4. Notice to 5 to 8 is deferred for time being. Release this matter in preliminary on Monday.
Please, great.
Yes, sir. Madam, ನೋಡ್ಕೊಂಡ್ ಬನ್ರಿ ಮೇಡಮ್. ಆಯ್ತು, ನೋಡ್ಕೊಂಡ್ ಬನ್ನಿ.
For the petitioner here, my lord, the respondent number 4-3 issued a notice for conducting the survey on Saturday, my lord. My lord, the question of the dispute land already adjudication before the land surveyor, inquiry officer, land surveyor. And another one suit, it is pending before city civil court, my lord. Already against the respondent number 8, permanent injunction suit decreed, my lord. In the meanwhile,
ಯಾರು ಇಲ್ಲಿ ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 8 ಇಲ್ವೇ ಇಲ್ಲ.
Sorry.
6 ಮಾತ್ರ ಇದ್ದಾರೆ.
Sorry, respondent number 5, my lord, the BMTC, my lord. Again,
Suit is for what?
my lord, suit is for permanent injunction is decreed against this respondent number 5, my lord. And another one suit for declaration also pending against this respondent number 5, my lord. In the meanwhile, they have moved the application before the city civil court for conducting the survey, directing the appointing the court commissioner as a ADLR, my lord. And another one subject matter of that, my lord, may kindly go through that, my lord, in annexure E, my lord. It is very clear that, my lord, based on the dispute, my lord, in page number 36, order portion of the
Seek instruction Monday.
ಅಲ್ಲ ಹಿಂದಿ
ಕಾಪಿ ಕೊಟ್ಟಿಲ್ಲ.
my lord, in the meanwhile,
ಏನ್ ಮಾಡ್ತಾರೆ?
ಅಲ್ಲ ಸರ್ವೆಗೆ
ಸರ್ವೆ ಮಾಡಿಬಿಟ್ರೆ ಏನಾಗುತ್ತೆ? ಬರೀ
ಅಲ್ಲ ಅದೇ ಪ್ರಶ್ನೆ ಇರೋದು my lord. ಯಾಕಂದ್ರೆ it is that
I will state if I am convinced Monday.
ಅಲ್ಲ in the meanwhile stay the proceedings.
Meanwhile ಇಲ್ಲ ರೀ.
ಅಲ್ಲ my lord, is already may kindly go through that page number 36, my lord. May kindly go through the page number 36. ಇದು ಲಾಂಗ್ ಬಿಫೋರ್ ಇಂದ ಪೆಂಡಿಂಗ್ ಇರುವಂತದ್ದು ಮ್ಯಾಟರ್, my lord. ಎರಡು ಕಡೆಗೆ ಅಡ್ಜುಡಿಕೇಶನ್ ಇದೆ. ಕ್ವಶನ್ ಆಫ್ ದ ಸರ್ವೆ ಆಗ್ಬೇಕು ಅಂತ ತಂದ್ರು ಸಹಿತ May kindly page number 36 of the order portion of the
You
land
say-
director of the land survey, my lord.
Allah, they are all party to the suit, Allah.
Yeah, my lord. Yes, BMTC, it is the main question of the BMTC, my lord.
Suit is about what?
Suit is of, my lord,
Suit is a suit only.
a suit, my lord, which is in page number annexure R, my lord, it is decreed against the BMTC, the same subject matter of the land. In annexure R, page number 49, my lord. Suit in order portion, it is page number 56. Suit of the plaintiff is decreed. Defendant is hereby restrained by any order of the permanent injunction from dumping the soil or other waste material over the suit property. And another in page number
That Yara, who appears for R5? Because there is a decree
BMTC.
operating. There is a decree operating.
decree operating in the declaration suit only present injunction order no say it is in operating, which is also annexure in this the plaint, my lord. In page number annexure S1, may kindly annexure S1.
Now, who has ordered for survey now?
Now the
Notice yaar issue ಮಾಡಿದ್ದಾರೆ ಈಗ.
land surveyor, my lord.
Phone
Land
number
surveyor
Madam,
annexed.
there is an injunction, permanent injunction against R5.
Yes, my lord.
ಆದ್ರೂ ಯಾಕೆ ಇವರೆಲ್ಲ ಸರ್ವೆ ಮಾಡಿಸೋದು ನೋಟಿಸ್ ಮಾಡಿಸೋದು ಮಾಡ್ತಾ ಇದ್ದಾರೆ? Just seek instruction. The impugned show cause notice needs to be examined. Needs to examine in the context of decree obtained by petitioners in OS 6814 of 1999, wherein fifth respondent is restrained by perpetual injunction from interfering with petitioner's peaceful possession. Petitioner is also placing reliance on an interim injunction granted in a pending comprehensive suit bearing OS number
4872 of 2013, my lord.
wherein the fifth respondent is again restrained from interfering with petitioner's possession by way of an interim injunction. Having taken note of these two significant details, this court is of the view that the notice issued by third respondent pending consideration of a comprehensive title suit needs consideration, accordingly stayed till next date of hearing. Learned AGA is directed to accept notice to respondents 1 to 4. ಯಾರಿದ್ದಾರೆ? BMTC ಯಾರಿದ್ದಾರೆ? Standing counsel. ಯಾರ್ರಿ BMTC ಯಾರು? ಯಾರು ಇಲ್ವಾ? PL ಸಂಜೀವ್. ನೀವು ಇದ್ದೀರಾ? And you dare. ಆಯ್ತು. So and so is directed to accept notice. ಅಲ್ಲ, but government ಅಪೇರ ಬರಲ್ಲ ಅದು. ಈ ಕೇಸಲ್ಲಿ ಬರಲ್ಲ. So and so is directed to accept notice to R5. BDA ಯಾರು? Krishna? K. Krishna is directed to accept notice to R6. A counsel for petitioner to serve two set of copies on the standing counsels appearing for respondent 5 and 6. Liberty is reserved to seek vacation of interim order. Two private respondents, illa private alla, two respondents 5 and 6. Yes.
Much obliged. Yes, sir.
ನಿಮಗೆ ಕೊಟ್ಟಿಲ್ಲ, ಕೊಟ್ಬಿಡಿ, ಈಗಲೇ ಕೊಟ್ಬಿಡಿ.
ಕೊಡ್ತೀನಿ sir.
Yes, sir.
Petitioner, my lord. I challenge annexure M, my lord. Yesterday, notice is issued via WhatsApp, my lord. They issued notice on WhatsApp and they have fixed date for demolition today, my lord. Yesterday, means it's immediately I filed objection before the
Notice for what ಇದು?
for demolition. I am owner of 9 acres of land, my lord. They have issued notice, annexure M, my lord, page 97.
ಯಾರು who has issued notice?
Tahsildar has issued. my lord. Stating that you have encroached upon the government land. ಅದು ಯಾವ extent encroachment ಏನು ಇರಲ್ಲ. Stated they said tomorrow we are coming to take position with police help.
That notice is vague.
ಅಲ್ಲಿ ಬೇಗಲ್ಲ ದೇವ್ ನಾನು ವಿತೌಟ್ ಆಪರ್ಚುನಿಟಿ ಡೇಟ್ is 3ನೇ ತಾರೀಕು ಡೇಟ್ ಇಶ್ಯೂ ಮಾಡಿ ನೋಟಿಸ್ ಇಸ್ ಇಶ್ಯೂಡ್. ಎಸ್ಟರ್ಡೇ ದೇ ಹ್ಯಾವ್ ಸೆಂಟ್ ಮಿ ವಯಾ ವಾಟ್ಸ್ಆಪ್.
All right, I'll list it on Monday. Don't precipitate. We'll.
Today,
Possession ತಗೊಂಡಿದ್ದೀರಾ?
today it is fixed, my lord. Yesterday they sent the notice via WhatsApp, my lord. Then immediately I filed objection yesterday itself.
ಈಗೇನೀಗ ಈ possession is told ಏನ್ ಮಾಡೋದೀಗ? Monday will decide. If you
Till then, let them not precipitate, my lord.
ಮತ್ತೆ precipitating possession
ಇಲ್ಲ ತಗೊಂಡಿಲ್ಲ ಮಾಡಿ ಇಟ್ಸ್ ಇನ್ ಮೈ ಅವರ್ ಪೊಸಿಷನ್. ಆ ಸೈಟ್ಸ್ ಎಲ್ಲ ಮಾಡಿ ನಾವು ಇದು ಮಾಡಿದ್ವಿ. ಇಟ್ಸ್ ನಾಟ್ ಇನ್ ದೇರ್ ಪೊಸಿಷನ್. ಯಾವ ಎಕ್ಸ್ಟೆಂಟ್ ಅಂತಾನು ಹೇಳಲ್ಲ ಇದೆ. ಸಿಂಪ್ಲಿ ದೇ ಸೆ ವಿ ಆರ್ ಟೇಕಿಂಗ್ ಪೊಸಿಷನ್. ಐ ಆಮ್ ದಿ ಓನರ್ 9 acres of land.
I'll hear it on Monday. If you are able to make out a case, I will order for restitution also.
ಅಲ್ಲ ತಿರ್ಗಾ ಮತ್ತೆ ಇವತ್ತೇನು ತಗೊಂಡಿಲ್ಲ ಆಸ್ ಆಫ್ ಮೈ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್
ಅದು vacant site ಆ?
ವೇಕೆಂಟ್
Vacant land.
ಏನ್ vacant ಏನ್ they can't hold it on the.
ಅಲ್ಲ ಬಂದು ಅದನ್ನ ಸೈಟ್ ಅಲ್ಲಿ ಎರ್ಮಾರ್ಕ್
ಮನೆ ಇದ್ರೆ ಹೇಳಿ ಮನೆ
ಅಲ್ಲ ಎರ್ಮಾರ್ಕ್ ಮಾಡಿ ಸ್ವಲ್ಪ ಸಿವಿಲ್ ವರ್ಕ್ ಮಾಡಿದ್ವಿ ದೇ ವಿಲ್ ಡ್ಯಾಮೇಜ್
Monday, Monday.
ಸ್ಟೇಟಸ್ ಕೋ ಟಿಲ್ ಮಂಡೇ ಅಟ್ ಲೀಸ್ಟ್
All right, Monday.
ಟಿಲ್ ದೆನ್ ಮೈ ನಾಟ್ ಸ್ಟೇಟಸ್
So because it's a second round,
ಸೆಕೆಂಡ್ ರೌಂಡ್ ಅಂದ್ರೆ 10th I was supposed to appear before the Tashildar.
why you didn't appear?
I stated in my writ petition also, madam, my mother was not well, even some family, this thing was there.
Yes, sitting ಆಗಿದೆ ಅಲ್ಲಿಗ.
ಆಮೇಲೆ ಇವಾಗ ಏನಾಗಿದೆ?
Sitting ಎಷ್ಟಾಗಿತ್ತು ಅಲ್ಲಿ? ಅಲ್ಲ ನೀವು ಇನ್ನೂ hearing ಇದೆ ಈಗ ಆಲ್ರೆಡಿ ಡಿಸೈಡ್ ಮಾಡ್ಬಿಟ್ರಾ ಪೊಸಿಷನ್ ತಗೋಬೇಕಂತ?
ಅಲ್ಲ
ಈಗ
ಇದ್ರ
ಯಾವ ಪೋರ್ಷನ್ ತಗೋಬೇಕಂತ ಮಾಡಿದ್ರೆ?
ನೋ ಮೇ ಮೇಕ್ ಒನ್ ಯಾವ ಎಕ್ಸ್ಟೆಂಟ್ ಅಂತಾನೆ ಹೇಳಲ್ಲ ನೋಟಿಸ್ ಅಲ್ಲಿ.
ಸ್ಕೆಚ್ ಇದೆ ನಿಮ್ಮ ಹತ್ರ, ಡಿಮಾರ್ಕೆಟ್ ಮಾಡಿದಿರಾ ಯಾವ್ದು ಪೊಸಿಷನ್ ತಗೋಬೇಕು?
ಏನು ಮಾಡಿಲ್ಲ. Till then status quo may be.
ಎಲ್ಲಿದೆ ಅದು ವಾಟ್ಸ್ಆಪ್ ನೋಟಿಸ್ ಎಲ್ಲಿದೆ ಅದು?
ಅದೇ
Annexure M, my lord. This is the notice we got via WhatsApp. Immediately I filed objection. Yesterday itself I filed objection.
ಕರೆಕ್ಟ್ ರೀ, ನೀವು ಪೊಸಿಷನ್ ತಗೊಳ್ರಿ. ಅದೆಲ್ಲಿ ಡಿಮಾರ್ಕೆಟ್ ಮಾಡಿದೀರಾ? ಎಲ್ಲಿದೆ ಎನ್ಕ್ರೋಚ್ ಪೋರ್ಷನ್ ಎಲ್ಲಿದೆ ಅದು?
No,
ಅಲ್ಲ ಈಗ ನೋಟಿಸ್ ಅಲ್ಲೇ ಹೇಳ್ಬೇಕಲ್ಲ ಈ ಪೋರ್ಷನ್ ತಗೋತೀವಿ ಅಂತ.
ಹೇಳಿದೆ.
So we'll stay this notice now. ಎಲ್ಲಿದೆ Annexure M?
Annexure M, page 97, my lord.
Anyway, I am listing it on Tuesday, madam. We'll vacate it. If they are frivolously squatting over, we'll that bill to hand over. How is the annexure?
Annexure M, my lord.
M.
Page 97, please.
ಖಾತೆ ಅನಿಗೃತವಾಗಿ ಒತ್ತುವರಿ ಮಾಡಿಕೊಂಡು ಪ್ರದೇಶವನ್ನು ಖುಲ್ಲಾಪಡಿಸಲು ಆದೇಶಿಸಲಾಗಿದೆ. ಇದ್ರ ಜೊತೆಗೆ ಸ್ಕೆಚ್ ಅದು ಏನಿಲ್ವಾ?
ಇಲ್ಲ.
The input show cause notice. Annexure M is issued. ಯಾರು ಇಶ್ಯೂ ಮಾಡಿದ್ದಾರೆ ಇದು?
Tashildar, respondent number 4, my lord.
Issued by fourth respondent Tashildar does not prima facie indicate which portion, does not reveal the details of encroached portion. This notice is served on petitioner through WhatsApp message.
Yesterday.
Though learned AG has brought to the notice of this court that this is the second round of litigation and petitioner who is a ranked trespasser has encroached over
No,
government
my-
land.
my-
However, matter requires consideration. Therefore, learned AG shall communicate to fourth respondent Tashildar not to take any precipitative action till Monday.
Tuesday.
ಆಯ್ತು, ಅದು ಮಾಜರದು ಡ್ರಾ if provided possession is not taken in a manner known to law as on today. All right, really this matter preliminary on Tuesday.
Tuesday. ಇಲ್ಲ ಮಂಡೇ
ಇಲ್ಲ Tuesday. So Tuesday.
Tuesday. ಯಾವುದು? ಕಮ್ಮಿ ಮಾಡಕ್ ಹೇಳ್ರಿ. 78 rectification ಏನ್ರಿ?
77.
ಆ?
77.
ಅಲ್ಲ ಒಂದ್ ನಿಮಿಷ ಆರ್ಡರ್ಸ್ ಮುಗಿಸ್ತೀನಿ. None appears. Finally, 2 weeks time to rectify office objection. 79.
But the respondent in the August case.
Office of ಏನದು?
2018 ಎಲ್ಲಾನು ಆಫೀಸ್ 8 ಮ್ಯಾಟರ್ ಇದೆ ಕೊಟ್ಟು. ಯಾವುದು ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿಲ್ಲ.
ಏನ್ ಕಂಪ್ಲೇಂಟ್ಸ್ ಮಾಡ್ಬೇಕು ಅವರು?
ಎಲ್ಲ ಸುಮಾರು ಎಲ್ಲ ರೆಸ್ಟ್ರಿಕ್ಷನ್ ಸೊ ಸ್ಟೆಪ್ಸ್ ಎಲ್ಲ ಸುಮಾರು
My lords, in 79.1, my lords, we have filed a memo for retirement, my lords, on 21/8/2020.
And what you have done with other petitions?
My lords, we are for the impleading applicants, my lord.
You are appearing for who? Who appears for petitioner?
My lords, we are for the impleading applicants.
ಪಿಟಿಷನ್ ಲಾಸ್ಟ್ ಟೈಮ್ ಬರ್ಲಿಲ್ಲ ಮೇಲೆ ಒಂದ್ರಲ್ಲಿ ಮಾತ್ರ ಸ್ಟೇಟ್ ಇದೆ.
ಒಂದ್ರಲ್ಲಿ ಸ್ಟೇ ಇದೆಯಾ? ಸ್ಟೇಟ್ ಪಿಟಿಷನ್ ಇದೆ. ಯಾಕೆ ನೀವ್ ಯಾಕೆ ಫೈಲ್ ಮಾಡಿದ್ರಿ? ಏನಿದೆ ಮಿಟೇಷನ್ ಪ್ರೊಸೀಡಿಂಗ್ಸ್? ಅಂಡರ್ ವಾಟ್? ಜೆನ್ಯೂನೆಸ್ ಆಫ್ ಗ್ರಾಂಟ್? ನೀವ್ ಯಾರಿಗೆ?
ನನ್ನ ಹೆಸರಿಗೆ ಆರ್ಡರ್ ಮಾಡಿದ್ರು.
ಅಲ್ಲ ಗ್ರಾಂಟ್ ಅನ್ನ ನೀವು ಓನರ್ ಹೆಂಗ್ ಆಗ್ತೀರಾ ಗ್ರಾಂಟ್ ಇದು
ಪರ್ಚೇಸ್ ಮಾಡಿಲ್ಲ ಸರ್ ಚೇಂಜ್ ಇದೆ ನಮಗೆ ಪೊಸಿಷನ್
ಯಾರಿಂದ ಪರ್ಚೇಸ್ ಮಾಡಿದ್ದಾರೆ
ರೈಟ್ಫುಲ್ ಓನರ್ ಸರ್ 1948 ಅಲ್ಲಿ
ಇಟ್ಸ್ ಅ ಪಟ್ಟ ಲ್ಯಾಂಡ್ ನಿಮ್ ಪ್ರಕಾರ none appears for petitioner by way of final intelligence. Matter is ordered to be relisted on. ಅದು ಸರ್ ನೋಡೋಣ. Right.
Name may be kindly removed.
ಅದು ನೋಡೋಣ ಆದಷ್ಟು. Non filing of acknowledgement. ಏನ್ರಿ ಬಟ್
I am for the petitioner. He
ಎದಕ್ಕೆ
is the
ಬಂದಿದೆ
fourth respondent, my lord. I have served the copy on him.
ಹೌದಾ
Long back, my lord. He is the person, my lord, who is in personifying a person who is deceased about 30 years back.
ಆಯ್ತು R4 council appearing for R4 acknowledges the receipt of copy of writ petition. Yes.
My lord, on an earlier occasion, this Honorable Court has directed, there is an investigation that has been taken place. The police have given the report saying that the person who filed the
Information,
yes, impersonation agide anta. This Honorable Court has also on the last occasion directed the parties to be present. Party was present, but on that day matter could not be taken up. That is the reason why your lordship kindly
ನಾನು will hear it. ಏನ್ mutation proceedings ಈಗ?
petition proceedings ಅಲ್ಲ.
Who are you?
I am the owner, my lord. After 18 years, in the name of the
ಏನು ಸೆಲ್ಡಿಡ್ಡ
ಸೇಲ್ಡಿನ್ ಆಗೋಗಿದೆ. ಸೇಲ್ಡಿನ್ ಆಗಿ 24 ವರ್ಷ ಹಿಂದೆ ಸೇಲ್ಡಿನ್ ಆಗಿದೆ. ಅವ್ರ ಕಡೆಯಿಂದ ಅವ್ರು ಸತ್ತೋಗಿ ಈ ರಿಯಲ್ ಪಾರ್ಟಿ ಸತ್ತೋಗಿ 35-40 ವರ್ಷ ಆಗಿದೆ. ಅವ್ರ ಮಕ್ಕಳು 40 ವರ್ಷದ ಹಿಂದೆ ಸೇಲ್ ಮಾಡಿದ್ದಾರೆ. ಐ ಆಮ್ ದಿ ಥರ್ಡ್ ಪರ್ಚೇಸರ್. ಐ ಹ್ಯಾವ್ ಪರ್ಚೇಸ್ಡ್ ಅಬೌಟ್ 22 years back. Nearly about 18 years thereafter, he files the petition for cancellation of my kata. The assistant commissioner simply does it without looking into the records.
Part heard.
Please, Miller.
Part heard.
There is a police report also to that effect.
ಏನ್ ಕೇಳಿಸ್ಕೊಳ್ಳಿಲ್ವಾ ನಾನು ಏನ್ ಹೇಳಿದೆ ರೆಡ್ಡಿ ಅವ್ರೆ? ಯಾಕೆ ಇಷ್ಟು ಹೇಳಿದ್ರಪ್ಪ? ಯಾಕೆ ಪಾರ್ಟೆಡ್ ಮಾಡ್ಕೋಬಾರ್ದಾ? Why you
In
are
22 itself.
Mister, he's not going to argue now. ನಿಮ್ದೇ ಆರ್ಗ್ಯುಮೆಂಟ್ ಪಾರ್ಟ್ ಹೆಡ್. ಏನ್ ತೊಂದ್ರೆ ಈಗ ನಿಮ್ಗೆ? ಐ ಹರ್ಡ್ ಹಿಮ್ ನೌ. ಪಾರ್ಟ್ ಹೆಡ್ ಯಾಕೆ ಅಬ್ಜೆಕ್ಷನ್ ರೀ? ನಾಳೆ ನಿಮ್ದು ಯಾವ್ದು ಔಟ್ ಆಫ್ ಟರ್ನ್ ರಿಕ್ವೆಸ್ಟ್ ಮಾಡ್ತಿರಲ್ಲ, ಐ ವಿಲ್ ಟೆಲ್ ಯು. What is it? What's your problem, mister? 81.
Lords, I appear for the petition, please. Lords, I have served them a copy, my lords, and I will also, my lords. Lords, I will take out hand summons, my lords, to R7.
Just a minute, wait a minute. Copies are served on Leonard SCGP. Insofar as R7 is concerned?
Lords, hand summons, my lords, because this matter pertains to my lord's ex-serviceman quota.
All right, petition is permitted to take steps to unserved R7 by way of hand summons.
Please,
Yes.
lords, a date may be fixed, my lords, please.
All right, put it returnable by so and so date.
Lords, 82, my lord. Lord, 82, my lords. R4 is, my lords, for R4, my lords, he is avoiding the, my lord, the summons. Even though, my lords, he is appearing in connected matters, my lords, as a respondent number 1.
ಯಾರಿದ್ದಾರೆ ಅಲ್ಲಿ ಲಾಯರು?
My lords, my learned friend is there, my lords.
ಅಲ್ಲ ಅಲ್ರಿ, but you are appearing in connected.
And my lord, the fact is this, my lords.
ಯಾರಿಗೆ? ಸೇಮ್ ಕ್ಲೈಂಟ್ ಅಲ್ಲ, ನೀವು ಕನೆಕ್ಟೆಡ್ ಅಲ್ಲ. R4 you appear. He has to give you, otherwise I will hold service sufficient. Next date.
My lords, fact is this, my lord, neither he is related to the property nor not.
Shri Badrinath, who is appearing for respondent number 4 in the connected writ petition, is directed to accept notice in the lead petition bearing WP number 488/2 of 2023. One week time is granted to Shri Advocate Badrinath to file wakalat on behalf of R4. Yes.
Lords, kindly, my lord.
ಇದು 2016 matter ಇದೆ.
ಹೌದು.
List it in B group and so and so date.
At least not date, my lord.
Next. 83.
Lord, I appeal for the petitioner, Lord, 10 days time may be granted to take steps in respect of R4, my Lord. I have given but returned,
10 days time to take fresh steps.
Lord, they have filed application impleading, they have not served me, somebody.
Sir, counsel appearing for impleading applicant shall serve a copy of impleading application
My lord,
on the
interim,
petitioner's counsel
interim order may be explained. sir.
extended. Idea.
Interim order is
Interim
there.
order granted earlier is extended till next date of hearing. Yes. Next. I 82 the interim order granted earlier is extended till next date of hearing. Yes, Joseph.
84.
84.
For the petition.
Filing a memo, my lords, because response number 9 is no more. She died issueless.
Issueless, sir.
Issueless.
My lord.
And my lords.
Kindly have it on Monday, my lord. My senior is not feeling well, my lord.
All right, memo is taken. Memo is filed indicating that R1 has R9 has died without leaving any class 1. He has memo is taken on record. The petition abates against R9.
The petition is not maintainable, my lords, because of the reason they have challenged the notice issued by the
There's
JDL.
a 47 years delay, my lord.
Unless
47 years delay, my lord.
I'll fix it.
Has to be
I'll fix it.
adjudicated before the joint director, that's before the respond number 2. Respond number 2 issues a direction to the respond number 3 to hold the survey, to hold the spot inspection. And the notice issued by the respond number 3 that has been challenged. The main order has not been challenged. That order remains malicious. If at all, if the writ is allowed, the main order sustains. That order has to be challenged.
Notice is pursuant to an order.
Yes, Manoj, pursuant to the order issued by the respond number 2.
All right.
That order has not been challenged.
List it in preliminary on so and so date.
Kindly have it on Monday, my
Take
lord.
on Monday or Tuesday, Manoj, because.
I said list it in preliminary. One date ಕೊಡ್ತೀನಿ this month. 85.
This matter, my lords, had permitted me to mention for interim relief or final disposal. Idರಲ್ಲಿ ಏನಾಗಿದೆ ಅಂದ್ರೆ Mr. Gopal Swami had appeared that day, senior counsel. Lord should recollect, Lord.
Your lordship,
ಇದನ್ನ preliminary ಹಾಕ್ರಿ. Though the notices are not served, though the process is not completed, in view of urgency pleaded by counsel for petitioner, registry is directed to release this matter in preliminary hearing on so and so date. On ಬುಧವಾರ ಕೊಟ್ರಿ. Let's say on that day.
Lord, my only difficulty is, Lord, on the basis of, but can it
Monday?
be Monday, Lord?
my
Monday.
lords, Monday,
Great.
there is inconvenience, my lords, Wednesday, my lords.
Lord, Lord, the appeal was filed not by my learned friend.
Now Wednesday, your friend is not there.
Yes. Wednesday, my senior counsel will be appearing.
Tuesday,
my-
Lords.
Tuesday.
Wednesday,
will be
my
okay.
lords.
Mangalwara.
Or else tomorrow itself, my lords.
It's bona fides are there.
No, my lords,
Where are they?
there is Monday and Tuesday, there is
Tuesday.
really
ಅಲ್ಲ
inconvenience.
New Year ರೀ.
Now, I'm for the respondent number 26 and 10 and 11, my lords.
27.
Much obliged.
Preliminary hearing, Lord, on 22nd.
Ah.
Preliminary hearing.
Preliminary.
Great.
The petitioner, my lord. My lord, this is, we have approached the DC of Kolar for the permission to give the permission for the playground, my lord.
Urgency, madam.
They-
Urgency.
Oh, my lord.
List this matter in preliminary along with office objections
Yes.
on so and so date.
21.
At this stage of taking steps, my lord, against a tenant, my lord, the petitioners, my lord, has died in the year 2020, and my lord has not approached immediately, your lordship, my lord, have written a letter, and my lord, ultimately, the court has, my lord, because non-prosecution of the, my lord, the petitioner, the.
ಮಾಡೋಣ, where is other side? ಯಾರಿದೆ?
ಅಲ್ಲ ನೋಟಿಸ್ ಗೌರ್ಮೆಂಟ್ ಆಗಿದೆ ಅಷ್ಟೇ, ಪ್ರೈವೇಟ್ ಪಾರ್ಟಿಗೆ ಆಗಿಲ್ಲ.
ಬರ್ಕೊಡ್ರಿ. issue emergent notice on main matter and all interlocutory applications.
Please.
On respondents,
Respondent, my lord,
issue emergent notice to respondents so and so
Please.
on main matter and interlocutory application.
Please.
ಯಾರು ಹೇಳ್ಬಿಡಿ ನಾಗರಾಜ್?
please,
ಯಾರು ನೋಡ್ರಿ private respondents ಯಾರು?
this is respondent number. Respond number, my lord, 3. That is a Muddanna, respond number. I have furnished the
Yes.
address also. Great.
My lord, to applications to bring LRs of respond number 3, my lord.
Notice have to be issued?
Yes, my lord.
Issue notice on LR applications. Next. Huh? ಆಯ್ತು ನೋಡೋಣ, ಅದು ನೋಟಿಸ್ ಕಂಪ್ಲೀಟ್ ಆಗ್ಬೇಕಲ್ಲ.
1/23 for discharge application.
ಯಾವ್ದು 89?
Discharge application, I will file the discharge application R3C manner. At the time of the application open here.
R3C has attained majority na?
These are
Next date ಮಾಡೋಣ. We'll pass orders on the next date. 89?
For the petitioner in this case, not this application, the petition is filed for mandamus, my lord, to consider the representation to conduct the podium, my lord. The subject matter of land is granted in favor of the petitioner, my lord. In spite of,
ಮಂಜು ಮಂಡೇನಾ ಕೊಟ್ಟಿಲ್ಲ, ಇದು ಪ್ರಿಲಿಮಿನರಿ ಮ್ಯಾಂಡಮಸ್ ಲಿಸ್ಟೆಡ್ ಪ್ರಿಲಿಮಿನರಿ ಆನ್ ಮಂಡೇ.
please,
correct. 87. Notice to the LRs of the third respondent. Notice to the LRs of.
ಕರೆಕ್ಟ್, ಎಲ್ಲಾಸ್ ಆಫ್ ಥರ್ಡ್ ರೆಸ್ಪಾಂಡ್
89 and 90 is also same.
ಸೇಮ್
Same.
ಅದು ಮಂಡ್ಯ.
Please.
Serial number 68, my lord.
Serial number 77.
ವೆರಿ ಇಂಟಿಮಿಡಿಯೇಟಿಂಗ್.
16 times have been. Wait. My lord, sorry. Well, no, what happened? 75, there was an interim order. Last occasion incident, 75. God, it's a short matter. It's a matter where it was the one time, other state of short date. He said. My lord.
Serial number
77, my lord.
for issue of Sagoli check, mandamus. Serial number 70. 70.
My lord. My lord.
77 also mandamus, it's covered by judgment.
Lord 68, my.
72 also, my lord, can be taken up in preliminary.
Tuesday or Wednesday.
There is change of revenue entries. In pursuance of the order passed on appeal.
My lord, 68, my
In
lord.
preliminary hearing, my lords.
My lord, serial number 68, my lord. Last time also I requested. She is a widow, my lord. She is a very poor widow. And it's a covered case, my lord. Your own judgment, my lord. Thank you, my lord. Your lordship judgment is covered under lordship judgment, my lord. That's forfeiture and restoration. My lord. Jayama. Apparent of government agency. Yes, ma'am. 68, my lord. And this is covered by your lordship judgment. Yes, my lord. Your lordship has covered it. Okay.
But 77. That's
No.
but 77, my lord, is also covered by judgments, your lordships only. Same similar order may be required. Conduct the Podi Durastu, where repeatedly this honorable court had granted me to conduct the Podi Durastu. In respect of my survey number, they had not been conducted. I had filed a memo to that effect also, it's covered by lordships. Tomorrow.
69, my lord.
Monday.
69, any. Serial number 69, any earliest date may kindly. 2019 matter, my lord. 2019 matter. Any earliest date may kindly. Short it is involved. Correct. Remaining on the